Justice, where are you? Michel and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, I lead the way, hoping justice will win the day. Missionary clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
In the shadows, truth takes form. Every clue a raging storm. A puzzle piece is left to find. Justice served, no wasted time. Follow the trail, step by step. No secrets kept, no stone unwept. Facts laid bare, the proof aligns. Beyond the doubt, justice shines. Whispers echo in the night. A legal war, a righteous fight. Advocates mysterious.
Hey all, wanted to jump in if you can hear me. I have my microphone sort of on. I don't have my earpiece in yet. As you see, I'm showered with light this morning. But if you can hear me, thumbs up. Wanted to tell you a couple things. Michael Bryant took an episode over the weekend. If you get a chance, we're going to play it here. Thank you for telling me. We're going to play it here about whether or not the defenses kept their promises in the opening statement. And, get a chance, listen to it. If not, we'll play it here when there are breaks, when we're not coming on to talk about what we just heard. And also, I did an episode on the chaplain, as you know, Mrs. Kavanaugh, I guess. And take a look at that because your comments, as a matter of fact, under that episode enlightened me. I mean, made me realize a couple things that probably I should have realized. One person, and I don't have your comments up right here. One person said that if I had woke up with all those tubes in my throat, not breathing, and heard Ms. Kavanaugh talking to me, I would have thought that she's an angel speaking with me. And I thought that was really interesting because, yes, she's got that. She has the voice of an angel. Someone said she reminded her of speaking the way Barbara Eden in I Dream of Jeannie speaks. And I thought that was also very interesting because it's true for those of us who remember Barbara Eden, who's now somewhere in her 90s and is just looking gorgeous, as you know. Excuse me, I have allergies again this morning. The other thing that I thought was interesting, the comment the prosecutors made when Lindsay made some comment about "I deserve this," if you remember that, and I took it as they were going after her because she was saying she deserves to have some good push in her treatment and all, and they were talking to making you want to hate her for saying that. But the commenter, one of you, and you all know who you are, said, no, what she was saying was that she deserves to be paralyzed. That's what that's what she deserved. She deserved this meaning her situation. So I thought that was really interesting too. I said, you know what? Wow. Wow. Yes, she's making progress, but she's deserved what she has. She deserved the fact that she was paralyzed. And I said, wow, I did not think of that. And yes, that makes more sense. That makes a lot of sense, doesn't it? And then somebody else said their daughter's a physical therapist, and you work out with whatever bands they give you. The yellow, they determine what your upper body strength is, and you work out with them. You just work out with them. Maybe you don't want to say, oh yeah, that's what I strangled my child with, or maybe you don't remember what color you strangled your child with either at that point. But I thought that I love listening to all of you. Excuse me as I move this up a little bit. I just jumped on because I saw that we were starting. And it is a Monday and it is a work day for us, as you know. And you can hear that my phone is already ringing, saying, work, work, work. Let me look at my phone for a second. I'll be right back. Sorry, everyone. It is a Monday work day, even though this was supposed to be my last 2 vacation weeks, but I haven't taken a vacation. As you can see, I'm here with you in this trial, and work is sort of out of control anyhow. So maybe next week. Yeah. So that's. I thought just listening to all of you was really terrific in regard to that. Now, Michael Bryant is there. I don't. Let's see. I was trying to look at our Justice Serve TV account, which he has taken to having because of the problems I had of being hacked. He only has control of that right now, and so. I didn't see whether or not that he posts anything this morning from Plymouth. I'm not sure. Let me take a look while I have you here. I'm incognito under an account. No, he has not posted anything from there. We are actually live on X and all. So he is not, but he is there. And I assumed that he couldn't like run around like he normally does because I assume the lines to get into the courtroom were pretty big. And if they do the closings tomorrow, the lines will be bigger, and there's a possibility they could close on Wednesday. Remember, the judge apparently is giving the parties an option, and that means both parties. If one party wants it, the line is very long. I figured that. I figured the line's long, and he may not get in today. We'll see. He will get in for the closings, though. I guarantee you that. But the closings could be tomorrow. They could be Wednesday. As I said, the judge was giving the parties the opportunity. If they wanted an extra time to prepare, he told them he would give them that. If you recall, that was said in open court. So we'll see whether or not they want time to prepare on all. And a lot's going to depend about today. Thank you about the blouse. This is actually I'm actually in a dress today, which I usually don't wear, but I have a meeting to go to at 11 a.m. So I am actually in a dress. Thank you. And it's I don't know about where you are, but it's really muggy in New York. It is muggy. Okay. Yeah, we think Michael should have first dibs because he's been there from the start. We've actually been there from the start. We've been talking about this case since last year. We actually were talking about it when we were discussing Kelsey Fitzsimmons because we were trying to show the difference between postpartum depression and postpartum psychosis. So we've had our eye on this case and been discussing the case and know where we wanted to go with the case in terms of trying to educate everybody in the phenomenon of postpartum psychosis. So is Dina there? Are you in the chat, Dina? I'm looking for Dina. Dina, yes, you were holding a spot. Wow. Okay. Thank you, Dina. Thank you. All right. I knew that was going to be the shall we say, Michael's secret weapon was going to be Dina, but we didn't want to tell you all that because he did get up at 4 o'clock in the morning to drive there today. as he does every time he goes. But he does have reservations for Monday night and Tuesday night. So we intend to be there if we can. Michael intends to be there. He's like the Energizer Bunny and the Iron Man when it comes to these things. I get to work on my cases and do my meetings and talk with you from the convenience of my desk. And Michael's on the road, and he loves it. If he could be on the road every day for a trial that we could cover, he would be doing that. And as you see, he's also very good with interviews and with people on the road and giving us some insight that not just there was a line at 3 a.m. Dina says, a line at 3 a.m. Oh my goodness, Dina, what time did you get there? I hope it wasn't 3 a.m. Wow. KC 1125. I will be in listening mode today. Work takes priority. I know the feeling. That's exactly what's happening with me today. Because now everyone knows that I did not go on vacation. As you can imagine, everyone's trying to get things done before other people go on vacation. Dina got there 5 to 6. Okay. Wow, Dina. Wow. 3 a.m. That sounds like a concert band. And all. It's amazing how this case has taken off. And one of the things I was discussing I was at dinner last night with a co-counsel of mine who is in from Chicago on a matter, and also because there's a fundraiser, not just a meet and greet tonight for a funding of a drug rehab facility, Divided Sky from the Trey Anastasia from Fish. She's in. And there's that tonight also. And we were having a roundtable discussion, not Mr. Anastasia, but with my co-counsel and a couple other people at this dinner we were going to. And we were talking about that women's health is so important and women's issues are so important. And women not being the victim are so important if they're real victims, okay? I mean, we have, and there's no doubt that children here are victims, right? And when we talk about trying to educate with women's health, we're not saying that children aren't victims, which is, what everyone then goes off on. Oh, you've forgotten those 3 children. No one has forgotten them. Everyone is saying, let it not happen to other children. Let's understand this phenomena. Let this not happen to other children. And we have gotten more viewers have written in to us, and Joyce Schmehar knows who they are, who also have had postpartum psychosis or depression. And we intend to get to putting everybody on the air we can this week. But today is really going to be focusing on the experts for the defense. And what I was saying was that I think when Dr. Mack and Dr. Heilbrunn, and I don't know if they're going to put on that third expert for the, and not the defense, for the prosecution. I don't know if they're going to put on that third expert for the prosecution. We'll see. We'll even see whether or not they put on Dr. Heilbrunn, who's already been tarnished. But I think when they signed on through the Park Dietz's group of experts that he has, that was back, you remember, he got the first call in December 2023. That's when Dr. Mack got the first reach out, and then 2024. And this case wasn't really on the high profile parameters that it has become. And so maybe, this was just a regular normal case, the killing of 3 kids. So I don't think that either of them expected, and the experts expected, to be in this light. And I'm sorry for my light. I apologize. I'm going to have to do something, but with regard to the studio here, but that's going to have to wait for another day. But I just want to thank you, LW89838. Yes, yeah, I need a little makeup brush this morning. I'm quite made up. And then, yes, Ruby, okay, 3595. Will Mac restrain his bloviation today, or is he incapable? Does he realize how inseparable he is? I don't think he's going to restrain it. Okay, unless he's, well, here's the issue. Once you're on cross-examination, you cannot talk to, the person who's putting you up. You just can't. Excuse me again, as I go off camera. So you are there, and you can't talk to anybody about the case. Now, he can't watch the case either. I guess he Here's an interesting question. Could you go back and watch your own testimony without having anyone comment on it and see? I don't know the answer to that. I don't know that he cannot speak to the ADAs. Except for scheduling purposes, he is not allowed to talk about his testimony once you enter cross-examination, and that's why Kevin Reddington. There was no way he was finishing his cross-examination on Friday because he was going to make sure that Dr. Mack did not have the opportunity or the ability to speak to the ADAs who presented him. Now, there has been a couple of, let me see, give this while we're doing this as these come. Dina, thank you, Dina, so much. Standing in line for Michael was the least I could do to repay you all for all you have done for us during the free Karen read. Dina, we just put you up. It was you. We just put you up, you in all your glory. And you are so eloquent and you are so unafraid. And was our pleasure to meet you. If Michael hadn't walked into that hall of records as he did in the free Karen read, we would have never have met you. It just was kismet that he walked in. It was raining, right? It was rainy day. And he walked in and there all you were. And we got to meet you. And so thank you so much, Dina, for that. We'll never forget your ability. You're wanting to talk to Michael, and you're talking to Michael, easily. And yes, we put you on uncut, unabashed, and told your story because it was a story worth telling, obviously. And isn't that what we're talking about here? This is a story worth telling, and we have to tell it. Let me just show Dina again because she is great, as you know. She's just fabulous. If you don't. Follow anything Dina's at, do anything Dina's at, and don't listen to these trolls that we see. I see these trolls, Dina, right? Oh my gosh, they're just unbelievable, some of these trolls. All right, so there's been some issue about Dr. Mack testifying in other cases. There was one in Florida. I'm saying a lot today. I shouldn't be saying that. It was called and one in New Jersey. The one in New Jersey was called Woodbridge Township Board of Education, Middlesex County. I know where that is. And Michelle Schwab responded. And what this was an arbitration, and I actually know the arbitrator, or did know the arbitrator, very good arbitrator in New Jersey. Matter of fact, if you have a education case and you want it arbitrated, you would want him as your arbitrator. This is one where a fourth grade teacher, stole merchandise twice. Okay. And so they fired her, right? They fired her for a number of reasons, including the fact that she hadn't reported the fact that she had been arrested within the period of time that is required under the teacher's collective bargaining agreement, the contract. All right. And the question was, when they didn't put her back, they didn't put her back. The school district then didn't put her back. After the first arrest, they did put her back. They said, mercy, basically, and we're going to put her back. But the second arrest was all over Facebook. And once things hit social media, her whole class knew, and it became quite a mess. And they terminated her. And the question is whether or not, very interesting, because she'd been on medication, and the medications had been changing. And her argument was, very interesting, right? Her argument was that medications and the tapering and then the changing and then the increasing of the medications and with the new psychiatrist caused her to have this relapse after 14 months where she then stole again. It's kind of like the argument about medications in involuntary intoxication in this case, right? And in that case, Dr. Mack testified for the defense here, and that was the teacher. And basically the court said in that case that he didn't really have an expertise in that area that he was testifying in. I'm shortchanging it. If we have time at some point, we may want to do an episode reading these, but we really don't have the time to read these. But so that was one. And the other case was a Florida case where he was testifying about a drug treatment population, and the court also barred his testimony, and they said he didn't have an expertise in the statistical accounting of what drug addiction people in this program, what drug addiction addicts, I should say, in this program would fit into this program. And while he had an expertise in general psychiatry, he didn't have the expertise in this specific population, that he couldn't determine what it was because he didn't have an expertise in basically in statistics. So we don't know what the statistical number of the population is. So but the end result of both cases, they said that he was testifying outside the purview of the expertise that he had as a generalist psychiatrist. All right. So I'm shortchanging them because, believe me, you don't want to read the Florida opinion that much in the sense that it's about a statistical analysis of this grouping that was going to in Florida. So, but in both cases, it was that this was such a specific area that you had to testify in, that he didn't have that specific area of expertise. So, it's very possible that Kevin Reddington may bring these up, maybe not, that he was testified outside his expertise, or of course didn't allow him to testify in 2 other cases, or if they did, they put no credibility or credence into it. But I just thought the New Jersey case was, well, also, you're all going to laugh because you all know me and the Jets. There's a Jet thing back there. The first items that the teacher took in New Jersey, in Woodbridge, she took pliers to clip sensors off. And then, you're going to laugh, New York Jets hat and 2 New York Jets sweatshirts. How do my New York Jets enter this? How do my New York Jets enter the Lindsay Clancy case? Well, they enter through Dr. Mack and his testifying for a patient that her drug changing and tapering and increasing and changing of psychiatrists caused her to go off the rails, and then she had no control, and she ended up shoplifting again. Again. Okay. Excuse me again while I deal with my and allergic to everything here this morning. All right. So, according to Joy, Michael Bryant has tweeted that there's crazy crowded in the Clancy courtroom today. The public side is full. A couple of press seats are available, maybe. All the parties are in. The Commonwealth attorneys just look miserable walking past me. By nature or circumstance, he adds. By nature or circumstance, he adds. Well, I'll let you all answer that. Okay, I'll let you all answer that. You're all loving my outfit. As I said, it's an actual dress because I'm going to an 11 o'clock meeting. So I won't be with you, as you know, from about 11:15 to whenever that finishes. And it's Dolce & Gabbana. And then this little ditty here is from my Christina, who takes care of 2B and many times lives with us, and is the daughter of my assistant of 30-some years, Pat. But she found this and she thought it would be beautiful on TV, and she gave it to me. And I love wearing gifts that people give me, and I thank her for that. So let's see if there's another one. So Michael will try to join us on the first break, if not for lunch. He's got to be careful, because he's got to make sure he stays in arm's length of his seat. All right. He stays in arm's length of his seat. We don't want to lose him. So probably in the first break, hopefully, if Michael can be here, I won't, obviously, in that first break. I won't be here. So I'm just warning you that now. Even if you see this, okay, let me see. Even if you see this, where is it? There, even if you see that, okay, that's 2B the poodle. Even if you see that, I will not be here because I will be out probably from 11 to 1-ish. All right. So, interesting. I'm just looking at some of your comments as they go past, because you're all very involved in this case. And hold on. When I have to show it to stop it. Every time the camera pans to Lindsay, I see mother grieving for her children. They're in our hearts along with Lindsay. I agree with you. This one case here is just so heart-wrenching. It's so heartbreaking. Yes, those children are gone. And yes, let's do something to honor the children by recognizing that there was really a problem here and how she was treated. I've never heard somebody reaching out for help as much as I've heard Lindsay Clancy reaching out for help, right? Never heard that. Never heard her reaching out for help that much. in any case. It's just a tragedy. And remember, she checked herself in for 4 days. She checked herself in. She didn't want to hurt the kids and all. And my goodness gracious, how this happened. And then the other thing is, everyone, I think Dr. Gregoire, that still is a fabulous episode. I think that we trying to educate from England, who is, and a lot of people have been in our comments, by the way, who've worked for Dr. Gregoire's team, and said he is the world-renowned expert in perinatal mental health, which is what it's called, perinatal mental health. And just, he said that when you have a psychosis, yes, you're living with it, but when you have the psychosis, you can go back to you're back to normal living, and then you can snap, just like snap. It's just like that. You snap, okay? And you could be smiling one moment, and then you could be jumping out the window the next. And that's how it works. And you have to understand how it works. And if you've never treated a patient with it, wow. I see they're panning to the courtroom. So why don't we put that up, Joy? And I will move out of the way here. Let's put that up, and I'll move out of the way. Let's see. Let's try to, Joy's going to bring in the, I'm watching the panning to the courtroom. There we go. Let's see. As soon as I think we have to take the card down behind. Don't we have to take that card behind that shows our, they're actually, they're in a sidebar right now. So I'm going to be getting out of here pretty soon, but I think we have to take the behind card, Joy, down. Do we? Yeah. So, what I'm just saying there, let's see if we can, do that. I'm over here. Joy will make this totally, complete in our frame as soon as I get out of here, which is going to be any second, but we just saw the pan. There we went with the pan. So, okay, so we got to take that card out somehow. Right? And then put the court back in. Try to make myself smaller even when I am here. If you can't take the card out, just bring the court in. And again, and let's bring the court back in, Joy. Oh, I can see in the backstage that we've lost the court. We have lost the court in the backstage. We should bring it back in. Okay, let me see. You're in law and crime. My goodness gracious, hold on. This is live. This is why we have live. Let me see if I can do window and get law and crime. Lindsay Clancy for streaming. Okay, it should be day 18, right? Just day 18, or no, this day 19 we're on. So I have to find the law and crime day 19 trials. Here we go. This is day 18 trials. Okay, maybe I could bring this in. I may be able to bring it. You have it, Joy? You have it in? Because I have it up on from Law and Crime. I don't like Court TV because it has too many of their ads on the sides that come in, if possible. I'd rather try to bring Law and Crime in. Let's see. I can do it on my file. I can do it. Let's see. I can share my screen. Is that it? Are we there? Is that the same? Is that the same one that I have behind, Joy, that you have? I'm trying to get this up for you, and I know you will take care of Michael, and you all, when if Michael can't make it for the mid-morning break, you will all deal with it. Well, Joy, I'm gonna, yeah, thank you. I think that's better. Now, am I sharing it? Or are you sharing it, Joy? I think Joy is sharing it, so I'm just going to leave mine in the background in case something goes wrong when I'm not here. Law and Crime is glitching. Okay, and I am sharing it. All right. Okay, isn't that interesting? I have talents I didn't even know that I am doing. We all have learned, by the way. We learned a lot. So Joy said Law and Crime is glitching, but let's see what happens, because they do have a even though it's the same place. I mean, we know Law and Crime and Court TV are now one or the other the same. Do you want to put Court TV back up, Joy, if you think that's better? Why don't you put Court TV back up? I'll remove Law and Crime, okay? I'll remove Law and Crime. Put Court TV back up if you think that it's glitching again, okay? I'm going to let Joy put Court TV back up. I'm going to remove mine, and I'm going to let Joy put Court TV back up. There's nothing happening. That's why we're going to
Last question. Is there any other serious matter of concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this
There we
time?
go. I'm going to
Again, thank you so much for those instructions.
I may remove myself from the stage. I'll see you back
if you remember, on Friday, we were in during cross-examination of Dr. Mack, who had testified Friday afternoon. We're going to return to the cross-examination, and the only difference is Dr. Mack is going to be available by Zoom here. We've had a couple other witnesses, so you all kind of know how that's going to work. So we're going to finish the cross-examination of Dr. Mack by Zoom. Commonwealth, if they have redirect question, and then we're going to continue with the Commonwealth's rebuttal. All right, and so just to kind of go back as far as the procedures that we followed, so the Commonwealth presented their case. Then after they were done, the defendant presented their case, and we're now on to the Commonwealth's rebuttal. All right, and when the Commonwealth's rebuttal.
Okay, we're having a little glitching problem with our feeds. Okay, Joy, you're going to have to pull yours up. Mine's not working either.
Correct? I know there are other times that I've created opinions.
Oh, I'm sure.
I'm not sure how much.
I'm just asking about criminal responsibility. That's it.
I'm talking about criminal responsibility. And I know there are other times I've created opinions, but I'm not sure that I've testified about them in the courtroom.
So my question was simply, how many times have you testified in court on criminal cases regarding the issue of lack of criminal responsibility, and this would be your third time, right?
That is my recollection.
Okay. And you have testified in court on behalf of various governmental agencies on other matters in addition to criminal responsibility, correct?
Yes.
And you are operating under the umbrella, if you will, of the Park Dietz conglomerate of a lot of expert witnesses that, as I understand, would parcel out cases to different people. Is that right?
There are times that I do cases through Park Dietz and Associates. I can't speak to how many experts they have and exactly how they, as you put it, parcel things out. But over the span of my career, there have been times that I've done it when cases have been presented through Park Dietz and Associates, and times that I've done it through other entities. As I discussed the other day, I had a role for the state of Maryland, and at times, and in this case, there was a criminal responsibility trial that I was a part of when I had a role for the state of Maryland. So going throughout my career, it's been multiple different entities.
You've also testified, since we're talking about it, in the state of Pennsylvania, right?
What's your question?
You've also testified, since we're talking about it, in the state of Pennsylvania, right?
I believe I have.
Was that at Park Dietz, or was that you individually, or one of your other entities?
You'd have to specify which case.
Commonwealth versus Torres, 342 MAL 2021, Pennsylvania.
Can you cite that case again, please?
Sure. Commonwealth versus Torres, 342 MAL 2021, Pennsylvania, where the court held that that would be Abram Mack, was apparently certified only in child and adolescent psychiatry. You lacked forensic certification to testify in the field that you were ostensibly going to testify in. Does that refresh your memory?
No.
Did you testify in? Did you testify in Commonwealth versus Torres in Pennsylvania?
I don't remember.
How about Commonwealth versus Carter in New Jersey? You remember that one?
No.
Do you recall that the court held on an appeal that you used an approach that fell below the standard of forensic practice?
No.
How about Feder LeBron versus the Secretary of DCF, 710 Fed 3rd, 1202 in Florida? You remember that case, I'm sure, right?
I do.
And in Feder, there was a gentleman, Mr. Feder LeBron, who was a Navy veteran, who was a single father and had a child. And he was a member or a person that was able to get benefits from what's called TANF, T-A-N-F, Temporary Aid to Needy Families. You remember that?
I do.
And the state of Florida decided that because needy families consisted of either minorities or drug users or people that would not be reliable to work in the confines of working underneath the TANF, so they wanted to have blood testing and drug testing of all the people that were temporary aid to needy families, right?
That's your conception of what was happening with that.
Well, that's my conception from reading the case, sir. Do you agree, sir, that TANF is an acronym for Temporary Aid to Needy Families?
Yes, it is.
Do you agree, sir, that this gentleman, Mr. Feder LeBron, was a plaintiff in a lawsuit against the state of Florida?
Yes.
Do you agree, sir, that it was in federal court?
Yes.
Do you agree, sir, that in federal court, the court held that, in fact, you were unqualified to give an opinion that you attempted to give, saying that it was perfectly appropriate to test by way of urine or blood people that are benefiting from the TANF program, because your testimony was that they belong to a class of people that I guess had to be tested. Right?
I don't agree with your conceptualization.
Okay, so the court ultimately ruled that your argument, your testimony on behalf of the state of Florida, the government, and you indicated that TANF benefits, applicants for TANF were people that were involved with drug use, violence, and higher rates of suicide. Remember those words, those three words?
The testimony that I provided.
Do you remember testifying, sir, about the people that are the beneficiaries of the TANF program, people that need aid because of needy families, are people that should be tested by way of blood or urine? And your argument, sir, was because they are of a class that would be more likely to commit a crime or have suicide or drug use. Did you testify to that?
That is not the way that testimony or that report was presented. No,
okay, so your answer is no. Let's keep it that way. Your answer is no. So you recall, sir, that there was an appeal, and in fact, on the appeal, it was determined that, yet again, you were not qualified to offer a relevant opinion because, number one, you never studied the TANF population. Recall that?
No, that is not the correct conceptualization.
Says you. Number two, that you did not survey any data. Recall that, sir?
Specifically in Florida is the nuance on that issue.
And number three, that you had no research whatsoever on the data that you based your opinion on. Would you agree with that, sir?
No.
Do you agree, sir, that the court held that you relied on other researchers' studies and didn't make any effort whatsoever to form an opinion based on your own research? Do you agree with that?
I don't remember the specific language of the court.
All right. Do you recall that ultimately your testimony was stricken?
No, I don't believe that it was stricken.
Okay. In any event, sir, you would agree with me that you have a memory of Ava Mack being subject to this attack, if you will, by the attorneys on behalf of the people that were involved with TAMF, right? You remember that much, right?
Yes,
Okay.
I do.
Thank you. Now, in summary, sir, you're here to testify in front of this jury regarding your testimony and opinion that you've given regarding Lindsay Clancy's state of mind at the time of the killing of her children. Is that correct?
Yes,
And you evaluated her in 2026. Is that right?
yes,
So you really evaluated her about 3 years after the incident that occurred in January 22, right?
January 2023.
So you do recall the date that the incident occurred, 23, right?
Right, so to answer
Okay,
your
the
question about-
answer is right.
Yeah.
Okay. And in reference to your answer, sir, you would agree with me that there was a significant passage of time between the incident in 2023 and when you saw her about 2 or 3 months ago, right?
Correct.
Okay, and you drove out there with the guy that's going to be in here testifying in about an hour or so, Helbrun. Is it Helbrun or Heilbrun?
When you said that I drove out there,
I'm just asking the guy's name. Is it Helbrun or Heilbrun?
you'll have to ask him how he likes to pronounce it.
Well, did you know how to call him or what to call him when you were out there with him for 2 days at Tewksbury?
Kirk.
Kirk, okay. And you met Kirk, I imagine, that morning that you were going to evaluate Lindsay?
Yes.
And what was the date that you evaluated her? Was it February
I
date?
think the first date was April 10th.
Okay.
The second date was April 12th. And those were the 2 days that I was there.
Right, because Kirk had to give her psychological testing on the middle day, right?
Correct.
Okay, so did you stay in a hotel or a van, or where'd you stay?
You're asking me where I stayed?
Yeah, I don't want to meet up. I just want to know where you stayed.
I stayed in Massachusetts.
Where?
I believe in Wellesley.
Where? Was it like Holiday Inn? Was it a Ritz-Carlton? Where?
A private home.
A private home, okay. Kirk didn't stay there, did he?
I don't know.
You don't
No,
know?
he didn't stay there. He didn't stay there, that's for sure.
Okay. So in any event, you must have had plans to meet up with Kirk at Tewksbury Hospital, right?
I did meet Dr. Halpern at Tewksbury Hospital, yes.
Okay, I'm calling him Kirk because that's what you told me is that you refer to him as, but it's Dr. Hoffman, how do you pronounce it?
I believe it's Halpern, but you'll have to ask him how he prefers it.
Okay, I will. And then did you meet him in the parking lot of Tewksbury?
Yes, I think that's right.
And
Or in the
you had,
lobby.
sorry, what'd you say?
Or in the lobby.
Okay. So when you went there on that date in April, the first day, you already had your information that you were able to form your opinion based upon. Is that right?
At the time that I initiated the examination, I had reviewed records related to Ms. Clancy. But creation of the ultimate opinion.
No.
And,
I'm asking about the records, sir. Real simple. The records that you reviewed. You had already reviewed them before you went to Tewksbury Hospital. Is that fair?
Yes.
Okay. And the records would be, obviously, cell phone extraction records, yes?
I don't know exactly when I reviewed the cell phone records.
How about defense expert forensic psychiatric evaluations? Dr. Philip Resnick, Dr. Margaret Spinelli, you reviewed the reports that were already prepared by my experts, is that correct?
And also Dr. Zeisel.
Zeisel, yeah, thank you. Okay, because I had sent them to you, isn't that right?
You had sent them, I believe, to Dr. Heilbronn.
To Dr. who, I'm sorry?
I think Dr. Kirk Heilbronn. And I think he was able to give them to me.
Okay, fine. So you also were able to review Department of Children and Family Records dated February 3rd of 2023, correct?
Correct.
And those would be records that pertained, obviously, after the death of the children, but it was just an interview of Patrick, the father, and Lindsay's husband, right? That's what those were.
That was a substantial component of that, but that was the DCF evaluation that occurred, and they, I believe, interviewed him when he was at Boston Children's Hospital.
Okay, all I'm asking is that the DCF, in other words, there's no DCF records that shows that Lindsay was abusive to her children, right?
I don't think that was necessarily the conclusion of that report.
Well, it wasn't the conclusion of any report. There were no other reports other than February 3rd, correct?
Yes, that's right.
Okay, and that would be interviewing Pat, the father and the husband, right?
As I said, I think effectively that is the core component of that report.
Okay, that's the component of the report. The answer is yes. You also had medical records from Astor Mental Health Records, right?
Yes.
That would be Jennifer Tufts,
Yes.
Jennifer McAllister, right?
I'm not sure if that's the name of another doctor in that practice, but substantially Astor Mental Health included the work of Dr. Tufts.
Dr. Tufts. And how about nurse practitioner Gelada? Did you review her records as well?
The records of hers that came from the organization that she worked in, yes.
What organization was that, do you know?
I'm not exactly recalling the title of it, but I believe it's South Shore Mental Health, but I'm not exactly sure of the exact title.
Boston Children's Hospital, Brigham and Women's Hospital, and McLean Hospital records. You reviewed them, correct?
Yes.
Spalding Rehab, right?
Yep.
Tewksbury Hospital from March 27th of 23 up through April 1st of 26, which is a little bit before you saw Lindsay, right?
Correct.
They were about 7,000 pages, a lot of paper, right?
Yes.
Toxicology records, police reports, grand jury testimony, you read all that too, right?
Correct.
Police interviews of witnesses, right?
Correct.
And you had met with, I imagine, or spoken to, by telephone perhaps, with the district attorneys, the prosecutors here.
Yes.
And where did you meet them?
The prosecutors?
Yeah.
Only by phone.
Okay, so you met them by phone. When was that?
I don't know offhand when that was.
How long was the conversation?
I don't recall. It could have been somewhere between 15 minutes to 45 minutes.
And basically they told you that they wanted you to evaluate a defendant who had been indicted for triple homicide of her own children by the name of Lindsay Clancy. You knew that from speaking with them, right?
Effectively, I knew that, yes.
And, you know, I normally don't go there with expert witnesses, but it was fair game on Dr. Zeisel. How much money do you make a year on your forensic evaluations? It
ranges over the years. several $100,000.
Yeah.
Can be a few.
And a lot of that,
More.
I'm sorry, go ahead.
No, go ahead.
So a lot of that it would be appointed cases or cases either from Park Dietz or some other warehouse that asks you to evaluate people and testify in the court, right?
Or over the years, people contact me directly.
Really?
We're talking about over the last 15 to 20 years.
Right. So when you were contacted by, strike that, did the DAs here call you or did you call them?
I don't recall.
Do you recall that they told you what a horrible case this was, that this woman killed her 3 children by strangling them? Did they tell you that?
Sustained. Next question.
Well, did you know what the factual allegations were of the case? Yes or no?
Well, all the factual allegations, yes, I believe they were conveyed to me during a phone call.
Yeah. Okay. And when you were engaged or retained through Park Dietz and Associates to work for the Plymouth County District Attorney's Office, I mean, that's fair to say. You were working for them, right?
Effectively, I was retained by the District Attorney's Office, yes.
All right. And let's talk about confirmatory bias. You know what that is?
Well, you were asking me the other day about the cognitive bias think tank, and we talked about how, as a part of my work in patient safety.
No. This is Dr.
I would like to be able
Hold on, doctor, please. Listen to the question and answer the question. Go ahead.
This is confirmatory bias, sir, not a think tank talking about safety of anybody, okay? Confirmatory bias. Have you heard of that term?
I have.
And what does it mean?
Well, if you're talking about the work in diagnosis in medicine, as I was getting at before, it refers to the idea that an individual has a idea as to what they're aiming for, and they gather information that feeds to that, and that brings that point together.
Okay. So would you agree with me, sir, that when you are retained in your practice, working, whether it's for Dietz or somebody else, and you are engaged by a prosecutor, such as the Plymouth County DA's office, is it fair to say that you go into your work and your evaluation, and I hesitate to use the word investigation, but you have a confirmatory bias? You're hoping that you're going to be able to help them out, right?
No.
No. Okay. So you had read all this material, you had spoken with the prosecutors, and I imagine you had done a team back with Kirk Heilbrunn, right?
A what?
You talked to Kirk Heilbrunn about the fact that you guys were going to go in and evaluate Lindsay, right?
We had worked with the prosecutors, and I believe them with you.
No, you didn't. Excuse me. You didn't work with me. What do you mean? You didn't work with me.
I imagine there was interactions in terms of setting up the dates on which this would occur.
I had nothing to do with it. My office manager, Laura Mather, would have done that. I had nothing to do with it, sir.
Yeah, okay, next question.
So when you went out there on the 2 days that you went out, forget the middle day, because that's when Kurt was by himself. When you went out there, the two of you met in the parking lot or the lobby, one or the other, correct?
Yes.
Yes?
I said yes.
And the purpose was to go interview her, right?
Miss Clancy, yes.
So you guys go down the hallway, you go in the elevator, you go upstairs to the locked wards, they have to open the door, they have orderlies and people that escort you. Is that right?
Yes.
You have to sign in, you have to have ID because it's a locked ward, right?
Effectively, yes.
Effectively. And the two of you, you and Kirk, go into a room where she's sitting in her wheelchair by herself so that you, two of you, can interview her. Is that correct?
Yes.
For how many hours did you interview her the first time?
The first day, it was roughly ended up being about I think 4 or 5 hours.
And have in mind, sir, as counsel has already elicited, she's incontinent. She has issues because of being paralyzed and had to have a break, didn't she?
She did not ask for a break.
She was able to power through the 4 hours?
I don't know if that's the appropriate way to frame it. We took a break. During the interview, we discussed the schedule that she has for catheterization, if that's your question.
So you and Kirk Halbrin sat down and you questioned Lindsay, the both of you together or one at a time, or how'd that work out?
One would ask questions, and if another one had additional questions to ask about that particular topic, then the other would ask.
And she was, fair to say, she was pretty cooperative with you guys, right?
Yes.
She was polite, she was affable, right?
Yes.
She answered your questions, right?
Yes.
And then when you concluded that first day, then the next day, Kurt Heilbrunn went on his own to Tewksbury and had another multi-hour interrogation, questioning, or whatever of Lindsay, right?
He was there for a second day for psychological testing.
So you're aware of the fact that he was there for psychological testing, right?
Yes.
Now, a psychiatrist doesn't do psychological testing, the psychologist does, right?
Typically, that's true.
And there are a number of tests that are administered to people when they are being evaluated for purposes of a criminal case such as this, right?
There are a number of different tests that test different aspects of an individual's psychiatric or psychological or cognitive functioning.
Right. Like, for example, you want to determine, I would imagine, whether or not they're lying or exaggerating or minimizing their symptoms, right?
That's always an interest, yes.
And it's of interest because if a person is, in fact, masking or lying about their mind, trying to fake out an evaluating forensic psychiatrist or psychologist, when you say that's of interest, that's something that can be the test result that a jury could look at, right?
Well, I'm not sure if there's a test that specifically states a person is lying.
No. You ever heard of the MMPI?
I have.
Okay. You ever heard of the K scale?
Yes.
What is that?
Well, the K scale is among the internal validity scales of the MMPI. The MMPI is an assessment of the individual's personality.
Okay. So let's focus on the K scale, sir. When you say that it's a, let me ask you again, what is your understanding of what the K scale is seeking to find out?
I answer this in the context of the purpose of the MMPI and what the MMPI is designed.
What are you smiling for? This is not funny, sir.
Sustained. Next
Well,
question.
you know-
Next question.
MMPI, K scale, focus. What does it mean, sir?
So the MMPI is an assessment of personality, and it is a set of questions that the individual responds to provide the test and to provide the user of the test to understand what is their personality like. The K scale is a set of questions embedded in the MMPI that are designed to see whether or not the individual is exaggerating in their responses, generally speaking.
Okay. Or lying, right? They call the K scale the lie scale, right?
Well, if you're simply referring to your own personality style, the issue is whether or not the answers are reliable or valid. It's not a matter of assessing if the person is lying on the MMPI.
Does the MMPI assess to any degree whether or not a person is lying, in your opinion?
No.
No? So let's stay with Dr. Mack's opinion on the K scale. What would that do? It would determine if somebody is not being truthful about their symptoms, or they're exaggerating their symptoms?
Well, the MMPI assesses the individual's personality and their thoughts about themselves. So the question is how to get an accurate reading of the person's personality. If it is the case that they are having a deviation on the K scale, then you might not utilize the MMPI as a whole. But the MMPI is not designed in a sense as a lie detector.
So what does that mean, sir, when you say if there's a manipulation of the K scale? What does that mean?
I don't think I used the word manipulation.
What word did you use?
I may have said deviation.
Okay. So if there's a deviation on the K scale, according to you, what does that mean?
It may come to a threshold that the MMPI is not usable, and
because
the users cannot gather information about the individual's personality as a result.
Because they're lying, and it's not a reliable test, right? That's the ultimate consideration, right?
Right. So it's not saying that the person is lying. It's saying that the test is not reliable.
Because the person who's the subject of the test is not being, let's say, forthright. Is that fair?
I don't know that it's always necessarily a conscious act. An individual, it simply reflects the tendency the individual has when answering the questions that are on that subpart of the test.
Okay, so if somebody has been indicted by the Plymouth County District Attorney's Office for triple murder, and you are working for the DA, evaluating whether or not they are suffering from a mental disease or defect, would you agree with me, sir, that there may be a tendency for somebody to exaggerate their symptoms to try to paint a positive picture of themselves?
Overrule.
Not necessarily.
Well, how about a little bit necessarily?
I don't know that there's a relationship.
Okay. So you are aware, regardless, that when Lindsay took the test for Dr. Kirk Halbrun, that there was no indication whatsoever of any malingering, exaggeration, or anything along those lines in that test. Would you agree with that?
If you're talking about the MMPI, correct.
That's what we've been talking about. I don't know. We're looking at each other.
I wasn't sure if he was going to answer, but let's ask the next
question. Yeah, okay. So you, tell me again what your answer was, sir?
That effectively, that's what the testing elicited, that her K scale, effectively, it was a valid test.
Okay. Now, you, in your review of all of the records, Tufts, Gelada, McLean, you knew that one of the healthcare providers, which would be Gelada, was focusing on the possibility that Lindsay could have been suffering from bipolar 2. Is that right?
I am aware that that was on her mind, that was something she was concerned about, yes.
And bipolar 2 is quite common, is it not, sir, as a precursor of a person who is suffering from postpartum depression or postpartum psychosis, right?
I don't understand your question.
Okay, well, how about, is it appropriate in Dr. Mack's opinion to give a person suffering from bipolar 2 or bipolar 1
an individual, there is a need in one's practice, traditionally at least, that if an individual might be suffering from bipolar 1 or bipolar 2, to avoid using SSRI medications. However, that has been reduced in terms of our worry about that over time, but that was maybe 20 years ago, 15 years ago, something that psychiatrists we're more concerned about, but the concern has lessened over time.
It has. So in your opinion, sir, it's okay to give a woman who is coming to you for help, who's been diagnosed with a bipolar 2, it's okay to give her the SSRI, in your opinion. Is that what you're telling this jury?
That's not what I said.
Oh, okay. Tell me what you said.
I said the concern about the relationship between SSRIs and mania or bipolar disorder has lessened, but that doesn't necessarily mean that people's practices have changed.
And when you say mania, what does that mean to you, sir?
Mania is a state defined in the DSM. I believe we discussed this the other day.
Well, go ahead. What is it? What are the symptoms of mania?
So mania is a condition, and it's defined not only by the symptoms that I'm going to mention, but also by a time frame. And as we discussed the other day, it is a mood state that is used as a building block for bipolar type 1. So one would need to see 7 days consecutive, and where the following symptoms, 4 at least of the following symptoms are present most of the day for all of these days. And that would include a thought process called flight of ideas. Secondly, distractibility. Thirdly, an engagement in activities that are pleasurable but have painful consequences. Rapid speech, or what we would call pressured speech.
Pressured speech.
Or rapid speech. Additionally, grandiosity and an exaggerated amount or excess degree of goal-directed behavior.
And what is your... go ahead.
Go ahead.
What is your understanding, sir, of the symptoms of bipolar 2?
So bipolar 2, well, we didn't finish the definition of bipolar 1, but in terms of bipolar type 2, one would need to have had a major depressive episode. I believe we discussed that the other day as well. And also one needs to have had what's called a hypomanic episode, which is similar to a manic episode, but lesser in terms of time course that's required. And only 3 out of the 7 symptoms are required.
So bipolar 2, you would agree with me, sir, is in fact a major or a serious mental illness, right?
Yes.
And your opinion, after you had your opportunity to go back again with Kirk on the 3rd day and interview Lindsay in Tewksbury Hospital. And how long did you interview her for the 3rd day, asking her questions?
I'm not sure I remember. It was perhaps 3 hours.
So after you completed your evaluation, you came to a conclusion that, in fact, Lindsay was suffering from a major mental disease or defect, to wit, bipolar 2. Is that correct?
No.
No. So why don't we look at your report and you tell me what your ultimate opinion was of your diagnosis of Lindsay after evaluating her, sir.
I think I said this the other day that my
Why don't you say it again, sir?
Yes, I'm happy to. My opinion was that, and is, that she suffered from a major depressive episode and that was a part of major depressive disorder.
Well, looking at your report, sir, on your conclusions, would you agree with... So do you have your report?
He's reading from the wrong report.
Do you have your report, sir?
Can I see it sidebar just for a second?
It's not the wrong report.
Okay, let me just jump back on when there's a sidebar. Dr. Mack is probably very happy. He's not in the courtroom itself, but he's still not answering the questions, right? He's still not answering the questions. We can't get to like the yes or the no, or just to answer the question. And even if you don't get your question answered, all right, as a defense attorney, this is wonderful because you want the expert to look like they're recalcitrant, or they just want to talk about what they want to talk about, and that all you're doing, and so you don't really care if you're Kevin Reddington. And I'm giving you a little law school course in how you cross examination. You don't care. You're just going to keep asking the question, and you don't really care what the answer is because you want to make him look like a jerk. Okay, basically. And so this past year at Harvard, I had to cross-examine a federal judge, all right, who was a great witness. And he just wouldn't give me what I wanted to give him. So the tact I took was to make him look like a jerk at some point, so that, because he wouldn't answer the question. And so again, you have to be able to, as a good defense attorney, be able to kind of move around. If you don't get the answer, where you go. If you get the answer, where you go. And if you decide that you don't get the answer and you get the answer, you still want to make him look like a jerk. This is how you're doing it if you're Kevin Reddington. You're not giving the witness time. You're saying, answer my question. You're putting your testimony into the question. Obviously, the judge is getting annoyed because the judge, again, had to tell him, answer the question. Answer the question. And the jury sees this. Okay, let's go back. I'll take myself off, go back in the court.
On page 35, is that at the time of the incident that Lindsay Clancy was suffering from a mental disease, and then you have the opinion, however, she retained substantial capacity to appreciate the wrongfulness or criminality of her conduct. Is that correct? Did I read that right? And the mental disease from which she suffered, in your opinion, was a mood disorder, major depressive episode. Is that right?
Yes.
And you further opined that she may have also had an anxiety disorder that preceded or continued to be present while the major depressive episode proceeded through January 24th. Is that right?
Yes.
Okay. Now, you're aware that she has been at Tewksbury under a particular diagnosis of a mental disease or defect, right?
Yes.
What is that?
I believe it's adjustment disorder.
Adjustment disorder. Is it not your understanding, sir, that she's suffering, according to diagnosis, bipolar disorder?
I think you'd have to show me where you're referring to.
So, did you have a chance to review Dr. Helbin's report?
I did.
And do you know what Dr. Helbin's opinion was? Of a
In
diagnosis?
terms of
Diagnosis.
Yes.
What was it?
I think he made a diagnosis of bipolar type 2.
So you have nurse practitioner Gelada, who, as a treating practitioner, indicates that the diagnosis possibly is bipolar disorder, correct?
I don't know that she used those terms, but I know that she was concerned about the possibility.
And you know, because you've obviously read and incorporated into your report Dr. Resnick's opinion, correct?
Correct.
And what is Dr. Resnick's opinion, sir, to your understanding?
In terms of the diagnosis?
Yeah.
Bipolar type 2.
Okay. How about Dr. Zeisel? You also had access to and incorporated into his report, your report, his diagnosis. What was that?
Now, offhand, I don't remember what his diagnosis was.
How about Meg Spinelli? Did you have a chance to review her report and incorporate that into your report?
I reviewed her report.
Do you know what her diagnosis was, sir?
I believe it was bipolar type 1.
Right. So with all of the various healthcare providers that have an opinion of bipolar type 1, would you agree that that is a very strong indicator that a person could very well be suffering from postpartum depression?
I'm confused by your question because that last piece is not necessarily inconsistent with the diagnosis of major depressive episode.
I'm asking you, sir, about
what I discussed the other day was when that specifier is able to be used, that would be a diagnostic question.
So, with the understanding that nurse practitioner Gelada is bipolar, or looking at bipolar, that Zysel report, you don't know or recall what it is, but you incorporated it into your report. Dr. Resnick is bipolar too. You feel that this is or is not indicative of a precursor to a person suffering from postpartum depression. It's in the books, in the articles, right?
Your use of terms, to me, seems apples and oranges. The question of postpartum depression would be, does the person have a mood disorder, and is it in the time frame following birth?
I can't hear you. I'm sorry.
So,
I can't. Can you say that again, please?
We're talking about categories that are not aligned with each other.
No, I'm asking you what your answer was, okay? What's your answer?
You'd have to restate the question.
Okay. You recall Friday, sir, that you were talking about onset of postpartum depression symptoms occurring within a particular time frame. Do you recall that, sir?
The diagnosis would be
The question is simple. Do you recall saying what the time frame was Friday?
I'm trying to answer your question.
What is the time frame?
The time frame designated for the diagnostic specifier called with postpartum onset is 4 weeks.
Okay. And that's your opinion, right?
Well, I believe that's what the DSM says.
Okay.
4 week
so
period
let's talk about
the 4 week period. The 4 week period in which that specifier may be added.
Okay. You recall saying
The
that
diagnostic rule.
you recall saying that a person can be postpartum and it has to be within 4 weeks. You recall saying that Friday?
What I would have intended to say.
No.
which I believe
What did you say to the, come on, what did you say to the jury last Friday?
Doctor, please listen to the question and just answer the question as asked, okay? And then if the Commonwealth has any redirect, they can follow up with their questions. Go ahead.
Thank you. Do you recall saying that the person has to be postpartum within 4 weeks, according to the DSM? You recall saying
To
that?
meet that specifier, yeah.
Right. Well, do you understand, sir, that every woman that has a baby for the rest of their life is postpartum? Because postpartum, quite frankly, means having a baby, right?
Sure.
So,
But that wouldn't be the specifier of with postpartum onset.
yeah, but you can't, postpartum is not a disease, doctor.
Right,
Postpartum,
it's an application that is defined in terms of 4 weeks.
okay, according to you, right? You understand that World Health Organization is different, right?
If you're talking about the ICD,
What is that time frame, sir?
I'm not sure what it is. I think you said it was 12 weeks.
How about the proposal to amend the DSM-5 text revision, or TR? What's the proposal for that?
Well, there's a proposal specifically around the proposed diagnosis called postpartum psychosis, and for that, it's a 6-week period.
So you've got 4 weeks, you got 6 weeks, you got 12 weeks. Would you agree, sir, that postpartum depression, postpartum psychosis can occur up to a year or even a year or longer?
I don't know, but I am telling you what the DSM says in terms of how to diagnose it and how to code it.
Okay. You would agree, sir, that she is at Tewksbury with a diagnosis of bipolar, right?
That may be among her diagnoses.
Okay. And she's on medication, right?
Yes.
And she hasn't had, over the past 3.5 years, any problems with sleep, anxiety, depression, symptomology of the same while she's been medicated at Tewksbury, right?
She has not demonstrated any signs of mania.
And she hasn't demonstrated any signs of anxiety either, has she, while she's been on the medication, the right medication, right?
I note that she's complaining of anxiety. I'm not sure she's demonstrating signs of anxiety.
Other than the fact that she's paralyzed and has to be in a wheelchair, she's not exhibiting the inability to bathe, the inability to emote, to have feelings, to talk to people. She's able to communicate with people, right?
Yes.
Okay. Do you know what medications that she's on while she's at Tewksbury?
She's taking, I think we discussed this the other day, a low dose of Zyprexa, I believe clonidine and trazodone, and propranolol occasionally.
Okay. Now, after you had a chance to review the medical records from Dr. Tufts, which would be from end of September of 22 up through October of 22, for example, initial prescription, right?
I've reviewed all of the records from Dr. Tufts, yes.
And you recall what the first prescription was that she got, right?
Sertraline?
And that would be what, 25?
Yes,
Was that increased?
it was.
And was there an issue or a problem, according to Lindsay, when that was increased from 25 to 50?
Yes.
And what was the problem that she indicated to the doctor?
She wanted to sleep, but she was finding it hard to sleep.
She was unable to sleep for a period in excess of 48 hours, is what she said, right?
I think it was at that point, yes.
And also, she indicated that there was, in her opinion, a symptom that she didn't really have a need to sleep, even though she had gone 48 hours without sleeping, right?
No, she wanted to sleep.
Well, would you agree with me, sir?
She was tolerating, she described that she was tolerating during the daytime and functional sufficiently without the sleep, but she found that she was trying very hard to sleep and she couldn't sleep.
And do you recall her indicating that she did not feel, regardless of 48 hours straight without sleep, that she had a need? She said she didn't feel like she had a need to sleep. Did you see that in the records?
I'm not sure that it would be characterized that way.
Did you see, okay, did you see anything in the records?
Wanted to sleep.
All right, one at a time. Go ahead, Mr. Wright.
Did you see anything in the records that indicated that she complained of the fact that she had gone 48 hours without sleeping after she was on the sertraline, and then felt that she did not need to sleep, even though she'd been without for 48 hours?
I don't exactly recall what was written by Dr. Tufts, but she described to me that in that period...
Doctor, I'm asking you about the medical records, not what you think she told you 3 years later. The medical records.
The medical records review the fact that she was not able to sleep.
And would you agree with me that one of the symptoms, sir, that you would be concerned about as a psychiatrist is when a woman who is postpartum, after having a baby, is complaining of a number of symptoms, one of which is that she went a long period of time unable to sleep, but didn't feel that she had the need to sleep? That's textbook, isn't it?
Well, the DSM textbook refers to a decreased need for sleep as the seventh element of mania.
Okay, so that is an indicia of mania. Can I get that out of you?
The way it's written is a decreased need for sleep.
Okay.
I don't know that she has decreased need.
And then the medical...
Trying very hard.
Go ahead.
I think she desperately wanted to sleep.
Is that what you think, sir, or is that what your opinion is based on the medical records?
That is my understanding based on the totality of the information.
Okay. So is it your understanding that she also exhibited signs or symptoms of postpartum depression?
So to the extent that she had depression in a period after having had a baby, that is not how DSM would refer to it, but as you said, everybody would be postpartum in that regard. So my opinion is that she had major depressive episodes in this year, or within 4 or 5 months following birth.
Sir, you're familiar with the postpartum psychosis. You're familiar with that, right?
So there's the concept of having psychosis.
Are you familiar with postpartum psychosis, sir? Yes or no?
I'm familiar with a proposed diagnostic entity called postpartum psychosis, and the idea that people can have psychosis as a mental disorder at other times.
You're familiar with the Department of Mental Health in Massachusetts, right?
Yes.
You're familiar with the funding of the Department of Mental Health for the Massachusetts Child Psychiatry Access Product. You're familiar with that, right?
No.
Called the MCPAP, that focuses on postpartum psychosis and postpartum depression. Are you familiar with that, sir?
No.
Would you agree with me that when a person has a child and is within the postpartum period, that they may present to a doctor with symptoms that might lead the doctor to believe that they are suffering from postpartum depression? Would you agree with that?
I'm not familiar with that particular program. I'm happy to.
All right, I know you're happy, but I'm just asking, sir, about postpartum depression. Forget the program. You're not familiar with the program. We get it. I'm asking you now, sir, about your familiarity with postpartum depression.
Yes.
Okay. And there are symptoms of postpartum depression. Fair to say?
Postpartum depression.
Are there symptoms, sir? Yes.
I am familiar.
Okay. And forget the DSM. Let's just focus on the symptoms as you understand it for postpartum depression, which according to you has to occur within the first 4 weeks of birth. But quite frankly, it could be 6 weeks, it could be 12 weeks, it could be a year, right?
You said forget the DSM, except that making diagnoses in psychiatry requires an authority, and we utilize in this country the DSM.
Maybe we shouldn't?
So,
All right, sustain. Next question.
So you're familiar, sir, you're not familiar with MCPAP for mothers in Massachusetts. You're not familiar with that subsidiary of the Department of Mental Health, right?
no.
Are you familiar with the Department of Mental Health postpartum psychosis provider training? In other words, what the LISCWs are learning and what the psychologists or psychiatrists working for the DMH are learning about postpartum depression, postpartum psychosis. Are you familiar with those standards?
No.
How about the Edinburgh postnatal depression scale? We talked about that Friday. You're familiar with that, sir?
I am.
But you don't feel it's important. You think the regular GAD scale, general anxiety scale, is sufficient, I guess, right?
I don't think I've said that.
Oh, okay. So do you think that the Edinburgh postnatal depression scale is important as a tool for a diagnosing physician dealing with a woman that's within the time frame and exhibiting symptoms of postpartum depression?
Yes.
Okay. So what was Lindsay's scale, if you know now? You had the weekend, I imagine, to look it up.
I don't offhand know what it was.
Okay. So if I offhand told you that it was pretty much off the chart, would that have any impact on your opinion as to the utility of the postnatal depression scale that was administered to her?
No, sustained. I mean, overall, let me ask. Sorry.
It's a scale that elicits distress, which she had, and it elicits depression, which she had.
And it's not just limited to distress and depression. It's focused on, and again, I'll read it, the Edinburgh Postnatal Depression Scale, right?
Right.
So, no, the answer's right.
She had diagnosis of depression. She was being treated for depression.
All right. So you, in any event, you don't utilize, apparently, the EPDS, right? You don't utilize it in your practice, whatever that may be.
Correct.
Okay.
Not that I'm against it. I just haven't had the opportunity to use it in some time.
Just like you think that, you know, an episiotomy is a tear, I guess, when a person has a baby, right?
I'm sorry?
You remember Friday you said that when a baby is born and the woman suffers a tear, that you called it a particular name?
An episiotomy.
Right.
When there's a need for repair for a tear, there are several different degrees.
No, wait a minute. Hold on now. Hold
What
on.
can have.
Excuse me, sir. Friday you said that the episiotomy is, in fact, a tear. Do you remember saying that?
I'm not sure exactly the wording.
Did somebody tell you that you were way off base on that testimony Friday, sir?
I'm not sure what you're referring to.
I'm referring to you saying that an episiotomy is a tear. And it's not.
And, Your Honor, is there a question before the witness?
I already asked the question. I'm looking at him staring back at me.
All right. Why don't you
The last,
just hold on? Well, you can rephrase that.
Do you remember saying Friday that episiotomy is a tear? Do you remember saying that to this jury, sir?
I don't remember the exact words that I stated.
Okay. Did anybody over the weekend tell you that in fact you were wrong and that it is a surgical procedure and that a natural tear has nothing to do with that procedure other than repairing? Did anybody talk to you about that at all over the weekend?
No.
Okay.
No.
So you would agree with me, at least, that postpartum depression, even though you don't use the EPDS, does have symptoms that a doctor would consider if a patient came to him or her for help, right? Yes or no?
So-
Yes or no?
You're asking me about a condition which
Right.
is not the way that it's defined.
I'm asking you, sir, whether or not you understand as a doctor that if a woman has a baby and comes to you because she is in trouble, that you would look for symptoms, would you not? Yes or no?
Yes.
Okay.
Yes.
And if the woman told you that she was less able to laugh, no emotion, unable to see the funny side, is that a symptom, sir, in your opinion, of postpartum depression? Yes or no?
It's a symptom of depression.
Was Lindsay Clancy complaining that she was unable to laugh or emote or see the funny side, if you will, of life when she went to see Dr. Tufts and Dr. Gelada? Do you recall that, sir?
Yes.
Okay. Okay, so let's just say the next issue would be stopped looking forward to things. You're familiar with that. People don't look forward to things and they, what is that called? Anhedonia or something like that?
Right. So that was one of the several elements of major depressive episode that I referred to the other.
Right. But it's also one of the symptoms of postpartum depression, correct?
They are the same. When
Okay.
you have depression and
How-
you meet the qualifier, then you can call it depression with postpartum onset.
How about a person that comes to you and says that they're anxious and worried constantly for no good reason? Would you agree, sir, yes or no, that that's a symptom of postpartum depression, according to the authorities?
So
Can you answer that yes or no, sir? It's real easy.
depression.
Sir,
If it's
All right, hold on. If you can't answer the question as asked, doctor, just say you can't answer it as asked, and I'll ask counsel to rephrase it. Go ahead.
yes.
so would you agree with me, sir, that the next symptom of postpartum depression would be anxious or worried for no good reason?
So I can't answer that question.
You can't. You can't?
I said I can't.
Okay. Was Lindsay Clancy expressing to the doctors and the nurse practitioners and the LICSWs or whatever on the medical records that she was anxious and worried on a daily basis for no apparent reason?
Yes.
Did Lindsay Clancy also indicate that she would have episodes of fear or panic for no good reason?
Yes.
Did she also indicate, sir, that she was overwhelmed by life, basically, overwhelmed?
Yes.
Did she also indicate that she was so unhappy and worried and anxious that she had trouble sleeping?
Yes.
Did she indicate that she was sad or miserable and unable to enjoy things like family, friends, society?
That is a symptom that progressed as those months moved on, yes.
Sure did. Did she also say that she's unhappy? She was so unhappy that she was crying on a daily basis.
Yes.
Did she also indicate that she had thoughts of harming herself?
Well, or suiciding. Yes.
So if she's successful in harming herself and she dies, then it's suicide. Either way, it's a thought of harming herself, right?
I don't think she had the interest of harming herself simply for the interest of harming herself. She had the interest of suiciding.
And she wasn't successful, obviously, right?
Are you referring to January 24th?
So the postpartum depression, sir, which invariably involves the EPDS, which you don't use, consists of 1 to 10 symptoms, and she hits every one in the medical records that you reviewed. Is that correct?
First of all, I'm not sure what well, I can't answer the question as you asked. I'll put it.
Let's talk about postpartum psychosis, because that is something that can follow postpartum depression. Is that right?
You're using terms that make it that I can't answer your question.
Postpartum psychosis, you can't answer? You know what that is, don't you?
Are you referring to the proposed diagnosis that we referred to earlier? The one
I'm referring to the fact that this young lady was suffering from postpartum psychosis when she killed her kids. Do you know what postpartum psychosis means?
So there is a observation that a person may have psychosis, or there is the proposed diagnosis that we referred to the other day.
Let's do this. Symptoms of postpartum psychosis. Number 1, hearing voices. Would you agree, sir, that hearing voices is indicative of having a symptom of postpartum psychosis?
You're referring to a condition or an illness called postpartum psychosis, and I don't know that I can answer questions as a psychiatrist based on that.
Would you agree, sir, that when a person is suffering from postpartum psychosis, you understand that term, do you not?
When we elicit,
do you understand the term postpartum psychosis? It's real easy. Do you understand that term?
It's actually not easy. It's serious, but when we do elicit psychosis after a birth, we take it very seriously. Typically,
who's we? Who's we? We take it seriously. Well, who's we?
We psychiatrists. I as a psychiatrist.
Yeah. So would you agree with me, sir, that when you are diagnosing, if you do, a patient that's coming to you for help after having a baby, so it's postpartum, and has been through, let's say, postpartum depression, and is now complaining of hearing voices or a voice commanding her to act, that is a symptom of postpartum psychosis, yes or no? Is it?
That would be psychosis. I don't know exactly based on your hypothetical as to whether it would count as the proposed postpartum psychosis illness, disease, but it certainly would be a concerning symptom or sign.
Okay, so if you had administered the Edinburgh test, that is something that may have assisted you in evaluating the claim that the person is hearing voices? Because that's one of the things that you would be concerned about with a patient, right?
You're always concerned if you're encountering somebody who's hearing voices, especially if they're new.
Especially if they're a mother, right?
Anybody.
How about thought broadcasting? You ever heard of that?
Yes.
Okay. How about a patient that says that they're worried about hearing voices and they're worried that people such as teachers could hear the voices in their head? Is that something that would concern you?
Yes.
How about if the person was afraid that somebody is able to hear the voices in their head and would call the police or DCF and they'd lose their kids? Is that something that would concern you?
Hypothetically, yes, it would be a concern.
How about actually in this case with Lindsay Clancy? Did you come across that in all of your investigation?
I came across in my evaluation a period where she worried that people could hear what she was thinking. That's different, first of all, from thought broadcasting. But in either event, as I've said, she was in a serious psychiatric state, and she was suffering.
How about number 2, postpartum psychosis symptomology, delusional beliefs with distorted reality? Did she complain to Tufts or Gelada about having distorted reality, being disassociated? Things weren't real. Do you recall coming across that?
So there were times that in the context of some of the medication she was taking that she felt that things weren't real, yes.
Okay, so
Or that
my
she felt,
question, sir,
uncomfortable.
my question, sir, is whether or not she complained of that to her health care providers. You'd agree with me
Yes.
that she did, right?
Yes.
Okay. How about appears normal in between episodes, calm, even laughing? Would you agree with me, sir, that postpartum psychosis waxes and wanes? It comes and it goes, right?
So are you referring to a particular...
I'm asking you a
when
simple question.
Okay.
Do you agree that postpartum psychosis waxes and wanes, that it can come out of nowhere and then leave, and a person can appear normal? They can even laugh. Would you agree with that, sir?
Are you referring to postpartum psychosis and illness? Or the findings of psychosis in somebody who's postpartum?
I am asking you about Lindsay Clancy, the young lady that's sitting right here that you're testifying against in front of this jury, telling this jury that she was responsible for the death of her children. You with me?
I'm not sure I understand exactly the context that you just stated.
Okay,
But
the
if you're
context I'm giving it
about
is,
the natural course of an illness called postpartum psychosis. That illness has not been refined. It's not something that we in psychiatry, at least as far as I'm aware, can talk about as an illness where we understand its typical course and we
okay,
understand...
time out.
All right, hold on. Let him finish. Doc, you done with that answer?
I'm done.
Okay, good.
You're telling me, sir, that you don't believe or buy postpartum psychosis. Is that what you're telling me?
I didn't say that at all.
Okay. So you do believe that postpartum psychosis is a serious mental illness?
I don't think it's a matter of belief or not belief. I'm aware of how to elicit the symptom or sign of psychosis. I am also aware that there's a proposal for an illness that would be recognized, where we understand its typical course and how it progresses, that has been proposed and that has not been approved for use in psychiatry in the United States.
Approved by who?
By the American Psychiatric Association.
The APA, so you...
Hold on.
By the team that let me, if I can finish, by
That's
the
the judge you're
particular
talking to, not
body
me.
within the American Psychiatric.
Do you agree that postpartum psychosis is a legitimate disease or defect? Yes or no?
when you have a symptom or sign of postpartum of psychosis at any time, but particularly in the postpartum period, it is a legitimate finding and something to be concerned about and to treat.
Okay. And when you say within the time frame, you're referring to the Dr. Mack time frame of 4 weeks, right?
No, I think, as I said, any time that a person has psychosis.
Okay, so
The issue about 4 weeks has to do with how we would diagnose it or what wording we would use to diagnose it, but that doesn't have to do with the reality of the individual.
okay, so anytime that there is a psychosis, and if it's postpartum, you would agree that you can put the two words together and it's postpartum psychosis, right?
You would not utilize that in your diagnostic terminology.
Okay. Well, you would agree,
You
sir.
would see that, and you would be concerned about it. According to the DSM, you would not
All right,
utilize
hold-
that.
I'm sorry. Doctor, if you could repeat that answer. We had some problems following it. Go ahead.
So the presence of psychosis is always of concern, especially if it's new onset. To the extent that we are talking about the proper terminology of labeling something, whether it is postpartum onset or not, the DSM provides guidance as to the time frame. That is different than my saying that it is a not serious condition.
So, symptom number one, complaint, according to the Mass General Hospital, major research project, along with the Department of Mental Health, dealing with postpartum psychosis, would indicate that hearing voices, a voice commanding her to act, is a symptom of postpartum psychosis. Do you agree with that? Yes or no? Just give me a yes or no.
I can't answer that.
Okay, the answer is no. The answer is no.
Action.
All right. He just doesn't agree with it. Next question.
We answered these questions several times now.
Really?
Overruled. You're going to let him ask that question if you want to ask that again.
So let's move on, sir, so we don't fight over number one. How about number two? Delusional beliefs, distorted reality. Would you agree that that's a symptom of postpartum psychosis, sir? Yes
You
or no?
said number one, number two. I don't know what authority you're referring to.
Do you agree, sir, that a symptom of postpartum psychosis, in addition to the hearing of the voices, would be delusional beliefs and a distorted reality?
I can't answer because I still don't know if you're referring to the phenomenon of psychosis or you're referring to some illness.
I'm referring to the illness that Lindsay Clancy was suffering that's in her medical record, sir, that you tell this jury you read. That's all I'm asking.
Well, I didn't find any evidence of psychosis in her record.
Okay.
Other than
Was there any was there any indication that she was hearing voices? Did she complain about that, sir? Yes or no?
she complained about intrusive thoughts,
Okay.
if that's where you're
How about the delusional beliefs and distorted reality? Do you recall her complaining about distorted reality, sir? Yes or no?
I'm not sure she used those terms. If you're referring
No,
to,
never mind what I'm referring to. Your answer is no, right?
No, she did not display psychotic features.
I didn't ask about psychotic features. I'm asking you about delusional beliefs and distorted reality, doctor.
That is a type of psychosis.
Okay.
So I didn't see any evidence of any psychotic features throughout the medical records.
So it's your understanding from reviewing her medical records that Lindsay never indicated that she was not participating in reality, that she was in a disassociated state, that she was out of touch with reality. You're telling this jury you never saw that?
I did see that evidence, that component that she discussed with her
Right. Good.
physician.
Great.
I don't see that as a sign, strictly speaking, of psychosis. It may have been in some cases, but
Right.
I don't see any signs of psychosis or delusions.
Like in this postpartum psychosis, sir, you'd agree that delusional beliefs, distorted reality is a symptom. Yes or no? Not waxing and waning with your answer. Yes or no?
Are you referring to an authority there?
Doctor,
I agree.
Doctor, hold on. Here's the way this works. All right. You don't really ask a lot of questions. You answer the questions. All right. If I told you before, if you can't answer a question the way it's framed, just let me know, and I'll tell council to frame it in a different way. All right? So that's the rules. That's how it works here. So go ahead, Mr. Reddington.
Thank you. Would you agree, sir, that a symptom of postpartum psychosis with a woman who is coming to a physician for treatment indicates that they appear to have normal periods between episodes of disassociation where they're calm, they're even laughing, and they can drive cars, they can talk to people, they can use telephones, all of that, right?
It would be, that description may be of other things, but it's not necessarily of psychosis.
How about severe sleep deprivation, sir? Do you agree that severe sleep deprivation is a symptom when you're considering the whole of the patient complaining of various symptoms? Severe sleep deprivation is a symptom of postpartum psychosis.
I can't answer the question the way you phrased it.
Okay, so let's say postpartum psychosis, you're somewhat familiar with it, and would you agree that severe sleep deprivation is a symptom of it?
I can't answer the question.
Okay, you can't answer it, okay. How about rapid mood swings? Would you agree that rapid mood swings are a symptom of postpartum psychosis, sir?
I'm not sure I understand your question.
Okay, how about a person saying that they're not herself? I want to be myself. I want to go back to being myself. I can't be myself. Is that a complaint that is a symptom of postpartum psychosis, sir?
It might be, if the person has psychosis.
Okay, the answer is it might be. Did Lindsay Clancy indicate that she wanted to go back to being herself?
Yes.
Now, did she also, was there any evidence, sir, of thoughts of harming her children?
There were periods when she had impulses or intrusive thoughts about harming her children.
And when you say intrusive, if I come to you and if a person comes to you and postpartum psychosis is on your radar and says that they're having intrusive thoughts about harming their children, would you not ask them what that means? In other words, is it a voice in their head? Is it their thought process? What is it? Do you ask that question?
Of course.
Did anybody ask that question when she was complaining about having intrusive thoughts about suicide, for example? Did anybody ask her what that meant? Voices in the head or thoughts?
I believe that the clinicians at McLean, at Mass General, Dr. Gelada, Dr. Tufts all asked about, or all made inquiries to understand the nature of her suicidal ideation.
Do you believe that based on your review of the medical records and based on your review of the numerous cocktail of drugs that were prescribed to her that she received good medical care from Gelada and Tufts?
Objection.
No rule.
I don't have an opinion on that.
Did she complain that she was not herself and her family could see the change?
Yes.
Okay. Did she also complain of thoughts of suicide?
Yes.
Did she also have poor insight?
I'm not sure that she had poor insight.
Well, if you are looking at postpartum psychosis and the symptoms are 1 through 10, if a person is complaining to you as a doctor, and when I say complain, I don't mean complaining, I mean that's medical language, that they're complaining or giving you a symptom, of 1 through 9, that is a very, very strong indicia that the person is suffering from postpartum psychosis, is it not?
1 through 9. I'm not sure I can answer that question.
Okay. How about blood tests? You think they're important when you're dealing with prescribing medications like Tufts was after a month?
Oh, they can be.
And do you think, sir, to a reasonable degree of medical certainty that a person should be given a basic blood test when you're prescribing these medications to them?
No overruled.
There are some situations where blood tests are required or needed, and other times when psychiatrists may feel comfortable making prescriptions without such tests.
So there is a further test that can be given that would actually determine whether or not a person's enzymes are reacting to the drugs, the narcotics that are being prescribed to them. Isn't that right?
You say narcotics?
Well, drugs, you know, like sertraline or...
Can you say the question again?
Sure. Prescriptions. When a person is prescribed prescriptions, it is well within reason that a competent physician would, number one, take a simple blood test, right?
It's possible.
Okay. And I guess that's up to the doctor that you're seeing, right?
Well, sure, or depends on what concerns the person may have, what's their medical history, what's your awareness of other factors that are affecting their biological health.
So let's take Lindsay Clancy.
And which medication we're talking about also.
Let's take Lindsay Clancy, for example, sir. The medical records that you reviewed when she's dealing with Tufts and Gelada, did they administer any blood tests to her at all?
Not that I recall.
Is there a further analysis that can be performed on the blood that is drawn from the woman when she sees the doctor to determine whether or not there are enzyme reactions to the prescription drugs that they're prescribed?
There are tests that can be done to determine the relative degree of one enzyme or another and how much they would do in terms of breaking down the medications, if that's what you're talking about.
Yeah, that test wasn't administered to Lindsay, was it?
I don't think so.
In spite of innumerable, which we won't have to go through, complaints that she had and her husband about what was happening to her as a result of her postpartum, as well as postpartum depression, symptomology of postpartum psychosis in conjunction with the narcotics, the drugs, the prescriptions that she was given. They never did any further testing, right?
Correct.
How about thyroid? Is that something that's important to you as a doctor dealing with a postpartum depression or postpartum psychosis?
Thyroid would be important to assess in a person complaining of mood problems, yes.
Well, how about a woman who is complaining that during the postpartum, which goes on ad infinitum, is complaining of postpartum depression symptoms and or postpartum psychosis? It's important to check their thyroid level, isn't it?
It would be important to check thyroid in multiple different psychiatric conditions.
So the answer is yes, right? The answer is yes.
Well, I'm not sure that specifically answers your question.
I don't care. Thank you. That's all I have, Judge.
Okay. Commonwealth redirect?
Good morning, Dr. Mack. Now, defense counsel kept referring to your investigation in this case. Do you see your role as an investigator when you're retained to do these evaluations?
No.
And in fact, you are evaluating for a specific question, correct?
That's correct.
And in your evaluation in this case, you were asked to focus on the mental condition of Lindsay Clancy at the time of January 24, 2023, right?
So, excuse me, he's able to answer yes or no, but this is direct, so I'm objecting to the leading.
I'm going to allow just to kind of focus to the area, and then we'll go from there. Go ahead, counsel.
Thank you. You can answer that question.
Yes.
Now, were you provided the information that you reviewed?
Yes.
And were you aware where that came from, whether it was the court or the district attorney's office or from defense?
I am not necessarily aware of the origin of any of the documents that I reviewed, only that I did review them and I did possess them.
And as far as the timing of when you were retained in this case, I believe your testimony on Friday was that your memory was early 2025 you were retained. Is that right?
Yes, I would say that the initial discussion about it was at the end of 2024. I am not exactly sure when the Commonwealth or the District Attorney's Office exactly made the retention happen, but I understand it to be early 2025.
And you were provided a significant amount of information after you were retained, correct?
Yes.
And that information continued to come to you up until the point that you were going to meet with the defendant in April of 2026. Is that fair to say?
That's correct.
And were you able to set up that interview with her on your own?
No.
Is it your understanding that it had to be with the permission of the court and the parties?
That's my understanding.
And that date in April was a date that was provided to you as a date that you could go and speak with her, correct?
Yes, the two dates, April 10th and April 12th.
And in conducting these evaluations, is it standard or best practice to review as much information as you can prior to that interview?
That's correct.
And you were provided records from the Tewksbury State Hospital in the weeks prior to your interview. Is that fair to say?
Yes.
Now, when you're retained on cases, this case and any other, you're paid for your time and your work regardless of what your ultimate opinion is, correct?
That's right.
Can you explain to us the relationship that you have with Park Dietz and Associates?
Yes. There are times that attorneys around the country go to Park Dietz and Associates seeking or asking if they have an expert in a particular field. And Park Dietz and Associates may be able to propose one expert or another who might be able to help that attorney or law firm.
And so in your relationship with that company, you are simply an independent contractor, or are you employed by the company?
Independent contractor.
And fair to say, there's not kind of a group email that somebody can send out asking for experts on all these types of areas in which you testify, right?
No, the Park Dietz and Associates would go to individual experts that they think might be appropriate for one or another case given the topic.
Now, you were asked some questions about Dr. Halbrin, and I think last week on Friday you indicated that you didn't know him prior to working on this case. Is that correct?
Correct. I had never met him.
And so is he a name that was familiar to you in your area of general psychiatry?
I knew that he was another expert that works with the Park Dietz and Associates group, but I had never met him.
And in fact, he's not a general psychiatrist, is he?
I believe he's a psychologist.
Okay. And so your focus is different than his focus, correct?
To some degree, yes.
Now, how did it come about that you and Dr. Halbrin ended up going to Tewksbury at the same time?
Well, my memory is that to the extent that he also had been retained, that there was a need to that there was only going to be one opportunity for an examination by the prosecution. And so rather than create two different sets of interviews for Ms. Clancy, it was better to overlap them and have them happen concurrently.
And in relation to the purpose of the interview with the person being evaluated, the defendant here, Was there anything different about your approach and his approach as far as the information you were seeking to gather?
Generally, no. As has been mentioned, he went ahead and did psychological testing on the second day. But other than that, it's still the same topic, the individual's mental health.
And in regards to that particular, those days that you were there, it wasn't just you and Dr. Halbern in the room with the defendant, correct?
That's right.
Who else was in the room?
One person who served as a videographer, well, two individuals who served as videographers.
Do you know who retained the videographer?
I don't.
And you're aware that Ms. Clancy was also on a one-to-one. So was there a staff member from Tewksbury close by, if not in the room?
Close by, but not in the room.
And the person who was conducting the video, they were in the room running the video the whole time?
That's correct.
And fair to say, as it pertained to taking breaks, you and Dr. Halbern offered the defendant multiple opportunities to take a break, correct?
Yes.
And
we made it clear that we could take a break anytime.
And she repeatedly declined a break, right?
I recall that, yes.
Okay. And that would be contained within the video that was running throughout the course of your interaction with her, correct?
Yes.
At this time, Your Honor, I'd like to present as the next exhibit the recorded interview with the experts.
I see counsel at sidebar. That'll be exhibit, yes.
Exhibit 292.
Okay, no objection?
No.
Dr. Mack, on cross-examination, you were asked about the LeBron case that you were involved in. You recall that line of questioning?
I do.
And in that case, you were retained by the state of Florida. Is that right?
Yes, the executive office of the governor.
And you offered an opinion in that case, correct?
Yes.
And was that testimony or by way of a declaration or a report?
It was a report, and then there was a deposition.
And so you were part of a hearing with the court in Florida to determine whether your ultimate opinions could be considered in the case, correct?
I don't think that there was a specific separate hearing up to that point.
Okay.
My recollection is that in the phase of a summary judgment proceeding, that the use of my testimony was discussed in the summary judgment documents from each side.
And then ultimately, your opinion wasn't utilized by the court, right?
If I recall the statement of the court in the document, it was that Dr. Mack is not an expert in this case, or it may have said Dr. Mack is not a qualified expert in this case.
And why was that?
My recollection of the case, which is now almost 15 years ago, was that the information that I was aware of in terms of the rate of substance use in individuals who received TANF was nationwide and was not specific to Florida.
And the issue was a Florida TANF case, right? Having to do with residents in the state of Florida. So as far as the limitations there and your testimony in these types of cases could be nationwide. In that particular case, it was just that you didn't have enough information about the residents in that state, correct?
Well, that was
Okay, if you can answer that, and then go ahead.
my understanding is that was one of the elements by which the court determined or made the statement that it did.
Okay. And you were offering some opinions about your expertise in the area of addiction during that time period, correct?
Yes.
Had nothing to do with criminal responsibility.
Correct.
Now, you talked a lot with defense counsel about the DSM, so I don't want to go too far into it, but on Friday, you directed Attorney Reddington to a particular part of the bipolar and related disorder chapter having to do with specifiers. Do you remember that?
Yes.
And you directed him to page 173, which referred to the specifier with peripartum onset. Can you just explain to us first what is a specifier when we're talking about the DSM?
Specifiers are a way in which the DSM allows a diagnostician to highlight certain details of the individual's presentation. But as I was mentioning the other day, psychiatric classification nowadays refers to the larger presenting symptoms that the individual has, and specifiers can be added on. So a person can have a severe mood disorder, and then one can add on the specifier of with postpartum onset, or atypical features, or other specifiers that have been defined.
And so when you were referring to page 173, where it starts the long paragraph about with peripartum onset, is that the portion of the specifier categories for bipolar related disorders where we're talking about postpartum periods?
Yes, there's a defined way in which a person can add as a diagnosis whether or not there was onset in that particular time frame.
And that's where we find the 4-week timeline, correct?
Correct.
And it also talks about different mood episodes, including manic and depressive episodes in that section, right?
That's right.
And that section also talks about the fact that it could present, mood episodes could present with psychotic symptoms and without psychotic symptoms, or psychotic features, I should say. Is that right?
Right. Bipolar disorder is a disorder of mood. Abnormal mood is what the diagnostician observes and is aware of. And if there is a way to determine that it's a major depressive episode or a manic episode or a hypomanic episode, that will help to determine if this severe mood condition is bipolar or major depressive disorder.
And so in that regard, the same specifier is also part of the major depressive category, correct? As
right. As I said, the specifiers provide detail, but they are not the, so to speak, the major element of the diagnosis. The major element of the diagnoses in DSM are the observable major symptoms and signs.
Well, I'm asking about just what's contained within those specifiers, because you and counsel went back and forth quite a bit on Friday about what's in there and what's not in the DSM when it comes to the peripartum onset. But as far as in both the specifier for bipolar and depressive disorder, there are a number of those features that you were discussing that is in the DSM as a specifier.
Right.
Okay.
Yeah.
And those are presentation with psychotic features, the frequency of occurrence or reoccurrence of the peripartum onset for these disorders, right? That's in there.
Yes, the description has that, yes.
As well as the risk of postpartum episodes being greater when people have history of depressive disorders or bipolar disorder. That's within that specifier for each of those two chapters, is it not?
Yes, that portion of the specifier is a description of what's been observed over time. It's not necessarily the criteria, but it's the observations that have been so commonly observed that they were able to write that in the manual.
So this concept of a peripartum onset, or we've been using it as postpartum interchangeably, it's within the DSM-5, right?
Yes, the DSM-5 provides a manner by which to make a diagnosis that provides this specification or highlights this detail of the individual's illness.
And as far as your conclusions, again, when you're asked to do an evaluation, do you rely on other people's conclusions about diagnosis when making your own diagnosis?
It's important to understand what others have observed and what they're concerned about. And then as a physician, one will make one's own diagnosis.
And so in this case, you came to the conclusion that the defendant presented with a major depressive episode, right?
Correct.
And you relied on diagnostic criteria in the major depressive disorder category. Is that fair to say?
Yes, that was the diagnostic criteria that I used to support that diagnosis.
And counsel went through with you today a number of different, I think he called them symptoms of postpartum depression. But as far as major depressive disorder, what are the 9 general symptoms that you see, or you can find 5 or more of, to find that somebody suffers from a major depressive disorder?
So a major depressive episode is defined, and this is parallel to the description I was giving earlier of a manic episode. They're both problems of mood. They're both discrete periods of mood problems. So a major depressive episode would be a 2-week discrete change in a person's mood, and you have to have at least 5 of 9 different symptoms or signs, and it has to be persistent, and it has to be most of the days. So the 9 include starting out with anhedonia, meaning lack of feeling pleasure. Secondly, actually feeling depressed mood. It can be feelings of guilt or worthlessness. And And then it also may include problems with thinking about death or suicidality. Furthermore, problems with sleep, eating, what we call energy, psychomotor activity, either psychomotor slowing or agitation. And then all these, you have to have 5 out of these 9
Right.
In order to meet the major depressive episode.
And I think maybe you might have missed one, diminished ability to think or concentrate. Is that one?
So, concentration.
Concentration.
So,
So a lot of the symptoms that counsel read to you are symptoms that are in the category of a major depressive disorder. Is that correct?
yes, this is the method of making the diagnosis of a major depressive episode.
So when you were asked on cross-examination about postpartum depression, and you kept answering that you found her to have a depressive disorder, are those the symptoms that you were speaking of when you were saying you found a major depressive disorder?
Can I object?
No overruled.
But leading?
Correct.
No overruled. I'll allow it.
I have nothing further.
Okay.
Thank you.
Anything further?
Just briefly, sir, are you suggesting that my office had any control over when you were able to go visit Lindsay in the hospital?
Objection.
No overruled.
I don't know if your office was involved, but I imagine, so I don't know.
You don't know.
I imagine your office was aware,
Thank you.
but I don't
All right,
know. that you had control.
Doctor, I think you've answered the question. All right, next. Anything further?
Nothing, thank you, Judge.
Anything further, Como? All right, thank you, doctor. Thank you very much.
Thank you.
All right. All right, so members of the jury, we're going to take the morning break at this point, and we're going to come back, continue with the Commonwealth's rebuttal case. We'll have a witness who'll go on the stand after we get back. All right, so we'll take the break at this time. Thank you.
Court, all rise. Jury, sign your close and notebook. Face on the chairs, please. Jurors, next to the court.
All right. Anything we need to discuss before the break, Como?
No, Your Honor.
No, thank you.
All right, so we'll be in the morning recess at this time. Thank you.
Thank you.
Court is in recess.
The jury?
Yes, Your Honor.
All right.
Court, all rise. Jurors entering. This court's now in session. Please be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy.
And with that, Attorney Sprague.
Thank you, Your Honor. Good afternoon. Can you please state and spell your name for the record?
Yes. My name is Kirk Heilbrun. That's spelled K-I-R-K, and then Heilbrun.
What is your occupation?
I'm a psychologist. I am in the Department of Psychology at Drexel University in Philadelphia. And as part of that, I run two clinics. One is a clinic where I conduct psychological evaluations for, thanks, sir, for courts and attorneys, and the other is what we call the Reentry Project, where we provide assessment and treatment services to individuals who are either returning from federal prison or under the jurisdiction of a federal mental health court or have been exonerated following a false conviction.
And do you specialize in certain areas of psychology?
Yes, I do. I'm a forensic psychologist, and that means that I take the application of clinical psychology and I apply it to legal proceedings in criminal and civil matters.
Can you describe your training in clinical psychology?
Yes, I can. I received a doctoral degree from the University of Texas at Austin in 1980. And as part of that, I received training in various sorts of assessment and treatment and therapy and research and things like that. And then as part of that, I was involved in a full-time internship between 1979 and 1980 at the University of Texas Health Science Center at San Antonio.
And did you receive specialized postgraduate training in forensic psychology?
I did. I received from 1981 to 1982, I did a postdoctoral fellowship in the applications of That involved full-time exposure to clinical work in correctional and forensic populations, and also a thorough exposure to the clinical and research literature on assessment and interventions with these individuals.
And are you licensed to practice psychology?
I am licensed in the state of Pennsylvania, and I'm also part of something called PsyPact, which allows people licensed in one state to practice on a temporary basis in another state.
And are you board certified in clinical psychology?
I'm board certified with the American Board of Professional Psychology, which is the oldest and most rigorous kind of board certification agency organization in the country.
And are you board certified in forensic psychology?
Yes, I'm also board certified in forensic psychology with the American Board of Professional Psychology.
And do you have experience in the treatment of individuals found either incompetent to stand trial or not guilty due to lack of criminal responsibility?
I do. Between 1982 and 1991, I was first a staff psychologist, then a chief psychologist at the Florida State Hospital in Chattahoochee, Florida. And then between 1991 and 1994, I served as the clinical director of the forensic unit at Central State Hospital in Petersburg, Virginia. And at that time, I was also serving as an associate professor in the Department of Psychiatry at the Medical College of Virginia in Richmond. And as a part of these positions, I had responsibilities for providing assessment and treatment services myself, and also for supervising such services provided by others.
And could you describe your job responsibilities at Drexel University?
I could. I teach graduate and undergraduate courses in forensic assessment and law and psychology. And as part of the clinic that I mentioned a moment ago, I conduct forensic evaluations at the request of judges and attorneys. And I supervise individuals who are providing services to the individuals who are either coming back to the community from prison or under the jurisdiction of a federal mental health court, or who are leaving prison having been exonerated following a false conviction. And finally, I conduct research and supervise students who are working in psychology. I have. Over the course of my career, I've published about 240 articles, chapters, and books in the areas of aggression and violence, juveniles, mentally disordered adult offenders, forensic assessment, ethics, and malingering and deception. And two of those interests that are particularly applicable to the present case are risk assessment, which helps us understand the influences contributing to violent behavior, and also forensic mental health assessment, where we consider the important principles and steps that are connected with psychological and psychiatric evaluations in legal contexts, such as criminal or civil proceedings.
And are you involved in providing continuing education to mental health and legal professionals?
Yes, over the past 15 years, I've presented about 50 lectures and workshops in the areas of forensic assessment, risk assessment, treatment, sexual offenders, and ethics.
And Doctor, in your experience in doing forensic evaluations and in teaching people how to do forensic evaluations, would you call someone you're doing a forensic evaluation on your patient?
No, I would call them perhaps someone who's being evaluated or an evaluee or something like that. They're not a patient because the role of therapist in treating a patient is different from the role of a psychologist or psychiatrist in conducting a forensic mental health assessment. They're different in a number of different ways, but basically what we try to do as a forensic evaluator is we try our best to conduct a thorough evaluation in which we are out there and trying our best to be accurate and just come up with something that is as true and accurate as we can possibly make it in terms of evaluating the questions that were asked. When we're working as a therapist, basically we're working to help somebody improve in their in various kinds of difficulties that they're having in life, symptoms, problems, and that sort of thing. And the two can conflict sometimes because as a therapist, I just want to do my best to help somebody. As a forensic evaluator, I want to do my best to be as accurate and open and thorough as possible, even if it doesn't necessarily help someone.
And seeing as you've treated patients and you've conducted forensic evaluations, would you conduct a forensic evaluation on one of your patients if requested?
I would not, no. If I were asked to do that, I would explain that those are two different roles, that there is very likely a conflict of interest that could arise if I try to do both, and I would refer whoever requested it to another individual to conduct the evaluation.
And have you testified in cases as a witness on issues like competence to stand trial, criminal responsibility at the time of an offense, civil commitment, and other areas?
I have. Over the course of my career, I've testified about 330 times with adults and juveniles. The issues have included things like transfer and sentencing, competence to stand trial, mental state at the time of the offense, civil commitment, and personal injury. I've testified on behalf of both the defense and the prosecution, and I've been qualified as an expert in juvenile criminal and civil litigation in both state and federal court. And I estimate that over the course of my career, I have conducted about 75% of the time I've conducted an evaluation and testified on behalf of the defense. And the remaining 25% have been conducted and have testified on behalf of the prosecution or by order of the court.
And have there been times in that 25% of your casework that you've been retained by the prosecution, say for a criminal responsibility evaluation, where you find that the defendant is not criminally responsible and you have to tell the prosecutor that?
Yes, that happens with the prosecutor, and it also happens with the defense. And it's just something that we have to be able to do if we're in the profession of forensic psychology, because if we try to be thorough and accurate and impartial, then sometimes the results will favor whoever asks us to conduct the evaluation, and sometimes they won't. And what they have to hear, if my findings don't favor them, is that they're probably not going to want to use it.
And is there something called retention bias?
There is. That's something that's been discussed, particularly in the last 10 or 15 years. And there are a number of different kinds of biases that the field has paid particular attention to, potentially, over the last 20 years or so. And retention bias is the bias that is a part of what we can experience when we want to or inclined to favor the side that asks us to conduct the evaluation. And that's an important consideration. And I'm aware of it, and I try to guard against it as much as possible by talking with others, getting multiple sources of information, and a variety of other ways of doing that.
So when you conduct a forensic evaluation, you're actively guarding against having that retention bias?
Yes.
Now, have you specialized in any particular diagnosis or type of offense or legal question?
I have not specialized in that way. Most of my forensic evaluation experience has been with criminal and juvenile matters, and they have often included alleged crimes of violence, but I haven't specialized in any particular kind of mental or emotional disorder, any particular kind of crime, anything like that.
And when you say criminal and juvenile matters, are you referring to adults as the criminal portion and juveniles as juvenile?
I am, yes.
Okay. And do you find that there's a benefit to not focusing in on a particular illness or diagnosis or type of offense?
Yes, I do. Among the biases I talked about a minute ago, there's something called confirmation bias. And basically that's if you make up your mind earlier or incline toward one particular diagnosis or anything like that, then there can be a real problem, because when you get conflicting information, that is information that's not consistent with that decision that you've made or leaned toward early on, then the problem becomes you pay attention to the information that's consistent with it and you stay away from the information that isn't. And so in some ways, for me, not specializing gives me an advantage, because what I can do is come in and not be inclined toward any particular diagnosis or possible answer to a particular set of questions or a particular hypothesis or anything like that. What I can do is do my best to look at the different possibilities, and when there's evidence favoring one or supporting one, I'm inclined toward that. And when there's not, then I set it aside.
And have you had leadership experience in your field?
I have, yes. I served as the chair of my department at Drexel for 15 years. And I've also served as the president of two national organizations, the two that are most strongly associated with forensic psychology.
That may be admitted.
Doctor, were you asked to conduct a forensic evaluation of Lindsay Clancy?
I was, yes.
And what did that entail, that forensic evaluation?
One of the things it entailed is doing my best to review a lot of information, to meet with Ms. Clancy in an interview, to speak with her in particular about what happened around the time of the alleged offense, to conduct collateral interviews with other individuals and review a wide range of documents. And so I have been reviewing documents since January of 2025. I had the opportunity to meet with Ms. Clancy in April of this year, 2026. And at that time, spent 3 days with her, along with Dr. Avram Mack. One of those days, which was video recorded, we talked about her background and a lot of information like that. The second day, where I met with her myself and did not video that because some of these psychological tests are private and they should not be videoed. So we did some psychological testing during that second day, and then on the third day, back with the video, back with Dr. Mack, we talked with Ms. Clancy about the things that she was thinking and feeling and doing around the time of the alleged offense. And so I mentioned that I reviewed records. I've got a report sitting in front of me, and those records are spelled out over 4 pages, so I'm not going to run through the whole list with you. But those records did include things like cell phone records, the defense expert forensic psychiatric evaluation reports by Dr. Resnick and Dr. Spinelli, some Department of Children and Family records, digital forensic records, including texts and information that was provided by the watch that she wore, the Apple Watch, and the phone, variety of medical records, police investigative records, police interviews with many people, and grand jury proceedings, as well as surveillance footage of the Clancy family going to various places, Museum of Science visit, Cape Cod, CVs, that sort of thing.
And in total, all the time that you took to review these documents, look at the evidence, interview and test Ms. Clancy, approximately how much time have you spent on this case?
About 180 hours prior to coming to Plymouth. So most of that was spent in reviewing records. About 10 and a half hours was spent in meeting with Ms. Clancy and doing the testing. And then another hour and a half was spent in collateral interviews.
And who did you interview in collateral interviews?
I interviewed her former husband, Patrick Clancy, and his mother, Ms. Clancy's mother-in-law, Sue Clancy.
And did you also request to interview Ms. Clancy's mother and sister?
Not her mother. I did request to interview her sister, and I think she decided against that.
Now, you mentioned that when you interviewed Ms. Clancy on the first and third days, you were with Dr. Mack, correct?
Correct.
Why is it that you two were interviewing Ms. Clancy together on those days?
Well, that's something that I do sometimes, conduct a joint interview. That's done in training contexts, for example, a fair amount. And in this case, many of the questions that we were going to ask her, a large number of the questions that we're going to ask her about her background and her history were going to be similar. So we were able to conduct those, ask those questions in a way and save some time, keep her from having to go through and ask and answer them twice. Then the third day, again, many of the questions that we were going to ask had to do with her thinking, feeling, and behavior leading up to the time of January 24th. And basically, it involves kind of a step-by-step process, going very slowly, getting a lot of detail. And we expected that many of those questions, sort of step-by-step detail, were going to be things that we would be able to work on, or they were going to be things that we could ask twice, or we could ask once and see it on the video.
And in terms of your interviewing Ms. Clancy together, after that was done, did the two of you come up with a joint opinion on a diagnosis?
We did not, no. Although we were interviewing her together on 2 days, we took that information and we each independently came up with our own report, our own review of that information, our own analysis of what it meant, and so on. So, no, we wrote separate reports. We actually did not agree on the diagnosis.
Now, if we could have the PowerPoint. In terms of your evaluation of Ms. Clancy, including the records and the collateral interviews and your interviews of her, did you form some main conclusions?
I did, yes.
And if you could tell us, what were your major findings regarding Ms. Clancy's mental health history before September of 2022?
She had a fairly limited mental health history before September 2022. She did experience some anxiety related to achievement. She's a very strong student in school and she got straight A's basically. She experienced some anxiety while in nursing school doing case presentations because you have to stand up in front of a group. And that made her kind of anxious. And then she had some anxiety connected with her 3 pregnancies, some in the beginning about the ultrasounds and so on, and some sort of as she was returning to work. So after each child, she'd have some time off with a child, and then after several months, she would return to work. And on each of those occasions, with Cora and Dawson and Callan, she had some anxiety because she didn't like to leave her children. That was an important consideration for her, whether it was dropping them off at school or returning to work or leaving them with a babysitter or going out with friends, going out on date night. She didn't like to leave them. And so those were some of the things that were connected with her mental health history before September of 2022. And this was in the context of her growing up as a highly achieving individual, getting very strong grades, competing in sports and competitive cheerleading. These are all things that the anxiety probably pushed her a little bit more in the direction of doing this very well, because she was a very hardworking and highly self-disciplined individual. She also grew up in a family that was close and comfortable and had a number of friends that she spent time with, both as a girl and a teenager and so on. But she was very highly achieving. And I think one of the important aspects of her mental health history before September of 2022 is that she really did not experience anxiety in a way that interfered very much with her functioning. She had a little bit of she had about 6 months worth of treatment for the anxiety connected with the nursing school. But it was not something that interfered with her life very much prior to September of 2022.
And doctor, did you also learn that growing up as a child, she didn't experience any type of abuse, witness any domestic violence, have any sort of trauma or anything like that as she was growing up?
Yes, one of the psychological tests, which I'll talk about a little bit later, is called the Adverse Childhood Experiences measure. And that's something that asks an individual whether they went through what we would call adverse experiences or traumatic experiences as a child and an adolescent. And there are 10 of them. And if you have 4 or more of them, that puts you at higher risk for different kinds of adverse outcomes as an adult. She did not endorse any of those. So on the ACEs questionnaire, she had a 0, which really goes to the question that you ask of whether she had adverse or traumatic experiences as a child.
And so she did not, correct? She did not report any.
She did not report any, and there were any number of individuals who were asked similar questions about her childhood and her adolescence, and they all said basically no, she did not.
And then can you tell us about your major findings for the mental health history beginning in September 2022?
Yes, I can. So it was about 12 weeks after her son Callan was born, and she was feeling very anxious and sometimes depressed about having to leave him when he went back to work. There were 2 reasons for that. One is that she had felt anxious about leaving her children on a number of occasions and with the previous kids. But the second reason was she was breastfeeding and Callan was not taking the bottle. And so she was worried if she went back to work. She worked as a labor and delivery nurse on the night shifts. And she was worried that if she left Callan home and he woke up in the night and wouldn't take the bottle, there would be a problem. And so that was what got her particularly anxious. And what happened was she searched for a psychiatrist, found one, Dr. Jennifer Tufts, in September, and went to Dr. Tufts and got a prescription for Zoloft she wanted to reduce her anxiety somewhat. And she didn't begin taking it immediately. She was a little bit worried about the impact that it might have on the breast milk. But sometime in October, she began taking the Zoloft. And things started getting very difficult at that point.
And doctor, did you learn how things became difficult from the records in your interview of her?
I did, both of those. And from, I guess you could say the records, because a number of people had talked about that, including her husband, Patrick. And I also got some of that information from him as well during the collateral interview.
And what did you learn?
What was happening toward the end of his 12-week paternity leave is that she was getting more anxious when she started in mid-October taking the Zoloft. She immediately began to have some difficulty. The anxiety did not get better. In fact, it got worse. There were some symptoms of depression. She immediately started having some really difficult insomnia and felt a lot of stress and so on. And so in October and moving into November, she had hoped to return to work and planned to return to work, but it was not going to work out for her because her symptoms were really difficult. So in the middle of November, she texted her mother-in-law, Sue Clancy, who was at work, also a nurse, and she was in the emergency room at South Shore Hospital. She felt unwell. She was having problems sleeping. She had a racing heart. She had lost some of her appetite. Continuing into November, she was struggling with anxiety, severe insomnia, palpitations. She was just having a lot of difficulty with the thought of leaving the baby, racing thoughts, feeling overwhelmed, and things like that. So moving further into November, into late November, she was just having real difficulty with sleep disruption, and she had concerns all along, starting in mid-October, about the impact of the medications. It was her thought that the medications were giving her some of these adverse reactions because it was really difficult for her to look at this and say, I wanted to get some improvement in the anxiety, and I did not. Instead, it got worse. And so late in November, she was still having a lot of trouble sleeping. She thought that she was close to what she called the end of her rope. She was feeling off and disconnected and sort of like a zombie. And she began to report panic symptoms, concerns about being addicted or dependent on the benzodiazepines, some kind of disoriented and forgetful and disconnected from her body. So she was having a lot of difficulty with what she thought were the medication that was resulting in this kind of impact. And then into December, it was not getting better.
And sir, if I could just interrupt you.
Yes.
On your PowerPoint here, are we still on number 3 here, or have we moved on?
I don't know as he finished his answer.
Why don't you come in focus?
Are we still on number 3 or have we moved on?
We're still on number 2, but,
okay.
but I'm also slipping in a little bit of number 3 as I answer number 2.
Okay. And if you could please continue describing what was happening in December of 2022.
Yes. Around this time, late November, early December, she began to experience what she called horrible, intrusive thoughts. And those thoughts were about harming herself, potentially. And as she continued to experience these kinds of thoughts later into December and January, they would occasionally be about harming the children. But for the most part, particularly early on, these were thoughts about possible suicide and harming herself. And the way she described it is these thoughts would just pop into my head, and they included things like, your brain is damaged, you need to kill yourself. Now, the way she described these is they were not auditory hallucinations. Instead, they were her own thoughts. They were intrusive and unwelcome, but they were not auditory hallucinations. And that's important because if she had been hearing a voice like you're hearing my voice right now, it comes from outside of your head. And that's a different kind of a symptom than having thoughts, even unwelcome and intrusive thoughts that are in your head. If it's coming from outside, that is very likely a psychotic symptom. And if it's a psychotic symptom, then that has different implications for what's wrong with you, as opposed to something that is unwelcome and intrusive, but inside your own head.
And doctor, the way she described these thoughts that she was having in December about harming herself, in the medical records and in her conversations with you, she described those as unwelcome but internal thoughts, correct?
Yes, that's right. It was important because of what I just said that I asked her the question, when you were experiencing these thoughts, were they like your own thoughts or were they like auditory hallucinations? And she said they were like my own thoughts. And she made it clear that they were unwelcome and intrusive, but they were like my own thoughts. And she didn't get to talking about experiencing auditory hallucinations, as I will talk about a little bit later, until January 24th. And so she continued to have real difficulty with various kinds of problems. She had lost about 15 pounds, not intending to. She was having tremors and sweating and GI symptoms and sadness, severe depression, that sort of thing, as she described it. Feeling numb and zombie-like were her words, again in December. And then by middle December, it was getting very difficult for her as she talked about it. Her sleep was getting a little bit better, but she was continuing to have significant symptoms of depression, things like hopelessness and the loss of capacity for pleasure and things like that. She described her experience on December 15th of 2022 as one of her worst days. She went to, her husband took her to Mass General that day, and she did not stay very long, but it was one of those things that was really difficult. The symptoms were, as she saw it, pretty bad. And then on December 20th, she went to a hospital called Women and Infants in Rhode Island, and they had a day program for postpartum individuals having difficulties. And they said that they weren't going to take her, that she didn't meet their criteria for the postpartum program. Generally, that was because they said that she looked like she was having a general anxiety symptoms and depressive disorders, but not so much the postpartum necessarily. And
doctor, if I could just stop you.
No,
yes.
you finished with that description of what information you got from that provider?
Not quite, Judge, but almost.
Okay.
I apologize.
Yes.
You can finish.
So she was not going to remain in women and infants, and the next step that she took was hospitalization at McLean.
And so if I could ask you a follow-up question now, before we
Yes.
go on to McLean,
Yes,
about women and infants. Were you able to review the women and infants records?
I was, yes.
And looking at the women and infants records, on page 9 I have here, it states that patient was offered several options for her, including inpatient treatment for medication management, a partial hospital program focused on general mental health, or continued outpatient management. Patient plans to follow up with her outpatient provider for guidance. So even though they said she didn't necessarily fit into their postpartum program, they did offer her 3 other programs, correct?
They did, yes.
And her response, Ms. Clancy's response, was that she was going to discuss that with her provider for guidance, correct?
Yes.
And in reviewing the records of Dr. Tufts and Rebecca Gelada, did you ever see any mention of the defendant actually following through with that and discussing with them those 3 options that were offered by women and infants?
No, what I saw is that they were back to being treated according to the plan and the medication and so on. But she was back to being treated, discussing with Dr. Tufts what the best implications were for treatment.
Okay. And then you were about to talk about what happened at McLean. So if you could please tell us what you learned about McLean and how that was impactful to your analysis or your evaluation.
Yes. She was admitted to McLean on January 1st of 2023. And what got her there was suicidal thinking. That was very difficult for her. That was a very difficult time to experience that sort of thing. And so she went into McLean on January 1st, and their admission documentation listed postpartum depression and major depressive disorder, which they described as recurrent and mild. While she was in McLean, what she reported as her primary concern was insomnia. And she said that while she was hospitalized, it actually made her more anxious than being at home. And when she was asked about the suicidal impulses and thoughts, she said that she would not commit suicide because of her children and her mother. So she had they asked about reasons for living, among other things, and those were some of the ones that she cited.
Doctor, would that be called a protective factor?
Yes, sometimes it's called a protective factor.
And that's something that protects you or prevents you from committing suicide?
Yes, would keep you from doing something like that.
And then what were your further findings?
So she stayed at McLean for 5 days, and she was documented as not having safety concerns and at minimal risk for returning to the community by January 3rd. She described her mood there as numb, but she denied things like delusions or hallucinations or suicidal thoughts that were continuing or homicidal thinking. And at the time she was discharged on the 5th of January, she was described as cooperative and pleasant, with no psychosis, no suicidal or homicidal thinking. And she said, when I was asking her about it, that when she left McLean, she had what she described as a small shred of hope after discharge, because she was off of medication, Seroquel, which she thought was causing her a lot of trouble. But the intrusive suicidal thoughts returned, she said, within a week or so following her discharge from McLean.
And would be moving on now to number 3 on your PowerPoint?
Yes,
The
we are.
Symptoms following the beginning of medication. So what were your major findings in that area?
Well, I have, I think I've combined 2 and 3 as I've talked about this, because one of the things about this is after she started taking the medication in October, the Zoloft, she had, the anxiety didn't get better. She had great difficulty with insomnia. And she said she was numb. She felt like a zombie. It wasn't something that she was able to see any improvement in. In fact, she thought it was getting a lot worse. And so basically, what she thought is that the symptoms that she was experiencing following taking the medication that was prescribed beginning in October, she said the symptoms were getting worse, particularly a new symptom, which was insomnia.
We could move on to the next slide. Doctor, and does that bring us to number 4 on your PowerPoint, the adverse response to medications, including bad insomnia?
Yes, and I won't take nearly as long in talking about that, because one of the things that she thought was happening when she began taking that medication in October is that the medication itself was far from making the anxiety better. It was making it worse and keeping her from sleeping, and it was, she thought, making it difficult for her to she thought that the medication was actually making it a real problem for her to sleep, to feel. She felt emotionally numb and that sort of thing. And so accompanying the bad insomnia with the apparent adverse responses, producing the insomnia and other things, was a real problem for her as she saw it. And it's one of the things that she continued to emphasize to providers, whether it was Dr. Tufts or Ms. Gelada, a nurse practitioner. She said, basically, I think these medications are making me worse. But one of the things, moving on to number 5 there, one of the things she also said is that she was focusing on making the anxiety, helping the anxiety get better through medication. There was a little bit of counseling going on with Ms. Gelada, but one of the things that she did not really have was, say, a cognitive behavioral therapist or something like that to help her work through the problems. She thought that medication was going to try to help, and it really did. It was something that she focused on a good deal.
And when you say she was focused, the defendant was focused on medication resolving her problems, would that include talking to doctors about different medications to try, researching medications on her own, asking friends and family for tips on medications, things like that?
Yes, all of those things.
Okay. And then should we move on to number 6, the mixed evidence about diagnosis and the nature of her problems?
Yes.
And what were your major findings in that area?
Over the course of the time that she was going through these experiences between mid-October and late January, she'd had a lot of providers offer a lot of diagnoses, and there were a lot of complicating considerations. So among some of the diagnoses that she'd been given were adjustment disorder with anxiety and depression, generalized anxiety disorder, major depressive disorder, bipolar disorder 2, postpartum depression, postpartum psychosis, post-traumatic stress disorder. That last one was not before January of 2023, but it's something that she has right now. And in addition to those diagnoses, which sort of implies that she has a disorder and she has symptoms, there were complicating factors. She had psychotropic medication with apparent adverse reaction. She had serious sleep deprivation over a 3-month period. She had between 5 and 8 months after the birth of her third child. She had anxiety about returning to work in the fall of 22. She was worried about leaving her baby for work, and he was not taking the bottle. And the other thing, which was important for her, is she was always someone who was she was into exercise, and she stopped exercising sometime in October when she started having these adverse reactions. But it's one of these things that it was a real difficult thing for her to handle when she couldn't do the running or the yoga or the Peloton or other things that she used to keep her anxiety managed.
Were you aware that she was able to return to exercising on several dates in December and in January, going to the Kingsbury Club where she was a member?
Yes, she was trying that, yes.
Yeah. And is that something that, as putting on your clinician hat for a moment, is that something that you would recommend to a patient, that they, in this situation, that they try to do things like exercise to complement medication and therapy?
Well, if it works, it does work for some people, and they use it effectively over the course of their lives, particularly if they have some anxiety that might not fully need treatment, but it's something that might interfere with your life a little bit.
And what were your next actions?
Well, if we could move on to the next slide, please.
So here we have number 7, your diagnosis, bipolar 2 disorder. So was that your diagnosis of Ms. Clancy?
It was, and it was hard because of all the diagnoses in the records and all the symptoms that she experienced and so on. To make a diagnosis of bipolar disorder or bipolar 2 disorder, which is a kind of a less serious way of experiencing bipolar disorder, you have to have identifiable mood swings. And one is a period of depression, which she certainly had, but a period of depression. And that was something that made a big difference over a certain period of time, in depressed symptoms and sadness and not having much or not having much motivation and things like that. But you also, for a bipolar diagnosis, need something where you have an identifiable period where the mood is much greater. It's much. One of the things that I might say is that one feels during a manic period sort of high, jumpy, decreased need for sleep, racing thoughts, sort of flight of ideas, thinking really fast, excessive appetites for different kinds of things, not getting tired, feeling important and powerful, and things like that. And I was having a hard time finding something that looked like it was a manic episode. There were times when she felt, as she described it after the birth of different children, she felt good, she felt on top of the world, she felt really close to them, to her husband and her kids, and so on. But it's also something that it didn't look like a manic episode so much as it looked like she was really feeling good and getting back into exercise and things like that. So it's one of those considerations where the thing that sort of gave me pause for a while in diagnosing a bipolar disorder is that I didn't see that manic episode. But what really convinced me is that she's been at Tewksbury now for more than 3.5 years. And the diagnosis of record at Tewksbury is bipolar disorder. And they are, as I read the records, very careful about what they prescribe and how much, and various other kinds of considerations. And one of the things that the records reflect is that when she was on some medication that's prescribed to help stabilize her mood, and it was discontinued for medical reasons, she had a kind of immediate response to that, which is to say, she noticed it, and that's a consideration as well. So I ended up with making a diagnosis of bipolar 2 disorder, which is a slightly less, not slightly, it's a less severe form of bipolar disorder.
And doctor, why did you diagnose with bipolar 2 and not bipolar?
Because bipolar, as I said, is a more severe kind of diagnosis. It's more noticeable. And if you had a bipolar diagnosis, then I would want to see something that clearly and definitely looks like a manic episode. And I did not see any evidence of that before January 24th of 2023.
And there were some incidents that have been described by witnesses who have testified and in the medical records, things like the defendant cleaning out her garage with her husband at one point in time. Was that something that you did or did not see as manic, and why?
Well, there was some indication in the records that some people thought it was manic. I did not see it that way. She did not describe, when I asked her, whether she did not describe that as a manic episode. She didn't think it was. And when I talked to Patrick Clancy, he said he didn't think it was either. And basically it was cleaning out the garage and getting a lot of stuff into 20 trash bags and so on. But one of the things he said is, they were both working hard, but it wasn't all her out there putting stuff in 20 trash bags, and he wasn't a part of it. He said he was definitely a part of it.
And would it be accurate that bipolar disorder requires that period of mania for, I believe it's 7 days, where bipolar 2 requires hypomania for 4 days? Is that right?
Yes, that's right.
And so did you see signs of hypomania?
Well, that's something where it's less clear that it's manic, and that's one of the things that inclined me toward bipolar 2 is I just did not see signs that were clearly manic episodes, but it looked like something that it possibly could have been a less serious or less severe manic episode.
And in terms of this diagnosis, this bipolar 2, is there a way to determine whether she always had this disorder or if it's something new, and if it's something new, when it appeared?
It's a disorder that typically comes on in adulthood. It's not something that you have as a kid or even for the most part as an adolescent. It's something that you start to show the signs of when you are in your 20s or 30s.
And so at this point, would it be time to move on to number 8 on your PowerPoint?
Yes.
Which would be criminal responsibility evaluation. So mental state and legal standard are relevant. So what were your findings on number 8?
Well, one of the things that I wanted to say about number 8 is that I wasn't called up here just to make a diagnosis or talk about symptoms. This is a criminal responsibility evaluation. And one of the things that I take a look at very carefully when I'm doing something like this is what's the standard for criminal responsibility in the jurisdiction. Now, I'm aware that the court will instruct the jury about the standard and how you apply it and so on, but my understanding of the standard for criminal responsibility in Massachusetts is that a person is not criminally responsible if at the time of the offense they suffered from a mental disease or defect and as a result lacked substantial capacity either to appreciate the criminality or wrongfulness of their conduct or to conform their conduct to the requirements of the law. So there were really three parts. There really are three parts to that criminal responsibility standard. The first is mental disease or defect, and that's one of the reasons why I've paid so much attention to the symptoms and when they began and things like that. But the other thing that I try to do is take those symptoms and see how they affect somebody, in this case, Ms. Clancy's capacity for knowing that something like this was illegal or wrong, or how they affected her capacity for conforming her conduct to the requirements of the law, which I think of as kind of controlling her behavior.
And to determine, is that something that those three elements are those things that you kept in mind throughout your evaluation of the records and your interview of the defendant and the psychological testing that you did?
It is, yes. And it's something that I put on page 1 of my report because I always try to do that to try to make it as clear as I can that this is something I'm paying attention to throughout the entire evaluation.
So that's your mindset when approaching the evaluation of Ms. Clancy?
It is, yes.
Okay. And so what types of psychological tests did you do with Ms. Clancy?
There were several reasons why I wanted to do psychological testing. One is what we call response style. In a matter like this, somebody like Ms. Clancy during an interview could respond what we call reliably, which is within the limits of her memory, as accurately as she possibly can. But there are other response styles. One is that somebody could do what we call exaggeration or even fabrication. Sometimes that's called malingering, which is they distort or they take the kind of report that they do and they exaggerate or even fabricate the severity of what they are experiencing. And then the other kind of response style is to underreport, basically to say, I'm going to minimize or even deny things that I actually experience. So response style is always important in doing a forensic evaluation like this, and I paid attention to it. And one of the psychological tests that I administered, something called the Minnesota Multiphasic Personality Inventory, has scales that allow me to look and say, is she being kind of reliable, or is she exaggerating or fabricating, or is she minimizing or denying? So that was one of the reasons that I wanted to do these tests. The second is I wanted to pay attention to possible symptoms of what we call severe mental illness, things like hallucinations or delusions or mental disorganization. They can't really kind of focus on what's being discussed so much as you tend to get off track or have tangential speech, which is kind of running off the topic and going to different ways and so on. Cognitive disorganization is another speech. There's also review of her reported symptoms around January 24th of 2023, and I wanted to ask her questions in a fairly comprehensive way about that. There are other symptoms that she was experiencing reportedly, depression in particular, and I wanted to know how depressed she was feeling. And so that was something that I could also measure with these psychological tests. And then finally, suicidal thinking was quite important. And I wanted to ask her questions about her thinking and feeling and behavior related to suicide kind of leading up to January 24th and then around that time. So these are all reasons why I gave her psychological tests.
Could I have you pause there for a moment?
Yes.
I'm not sure if it's a good time
This is
to
a good
break.
time to break. All right, why don't we do that? Thank you. All right, so members of the jury, we're going to take the afternoon recess at this point. You know my instructions, so they're going to be the same. Don't talk about this case. Don't do any research about this case. Don't listen to anything about it. Don't read anything about it. Have a nice break, and we'll have you come back here about 2 o'clock. Okay?
Court, all right. All right, please. Good. Close the notebooks, place them on your chair. Just like this.
All right, Doc, give me a step down. All right. Anything we need to address before 2 o'clock? All right, so we'll be in recess till approximately 2 o'clock.
Hey, sorry, folks. Got a little tied up there. I made it. Hey, look, nobody's here in my spot. How about that? All of the others over on the other side there. Nobody was like my little spot here on the concrete bench. Anyway, hey, thanks for joining, folks. So here we are, day 19 of the Lindsay Clancy case. We are in the Commonwealth's rebuttal case. Still, we heard follow up on the. Oh, I know I've got to change this. I feel it in my bones. Yep. Sorry, folks. There we go. That should be much better. I could hear the lady over off my shoulder better than I could hear myself. Anyway, so so we began obviously with cross-examination, continued cross-examination of Dr. Mack. I'm curious what people think about this because I can't read jurors' minds, but just to me, there are times when Kevin Reddington's aggressiveness and his advocacy, which is the best, I get it, I appreciate it, can be a little annoying, can be a little bit too much, can be, and this guy, we're talking Dr. Mack, the guy was easy prey. So I don't know that he had to go on him as hard as he did at times where he's kind of interrupting him and he's making snide comments. I think the last thing he said before he sat down was, I don't care. I don't care when he was trying to answer, when Dr. Mack was trying to answer the question. I don't know. Is it too much? Do you think it's appropriate, inappropriate? The judge almost always sides with counsel. Generally, it's Kevin Reddington because the Commonwealth is mute for the most part. Even when I felt the doctor was the one who was trying to answer and being cut off, I think the court could easily have said, Mr. Reddington, let the witness answer. And if you don't think it's the appropriate answer, then, continue on. Anyway, I just felt like it can be too much at times. And I don't know if at the point where it got to be, in my opinion, too much, it mattered. I think the jury was over it. I could see from lack of notes, for sure, one of the key things we look at. And also just kind of a more, kind of a ho-hum kind of look about them. There's one guy, haven't given him a name. He sits right next to Tony in the front row. He's third in from the left, probably 50-ish or so, a taller, thinnish guy. But he was giving it a lot of this today. And generally, because it was a video, I'm sure that Dr. Mack was very grateful not to have to step foot back in this courtroom. He got to do his thing by a video, and it worked cleaner. It was all around. It was good. It wasn't like some of the issues we've had with the video up to this point, but because the jury is looking straight at the video, they aren't looking this way to the jury box. So they're looking at the video, and he's just, as if, I don't know what you got to say, but I'm over it, just my take on it. And I saw a couple of folks that were similarly no longer all that excited about Dr. Mack's testimony. And I think I posted something from the courtroom how horrible he was. He was a horrible witness, horrible expert. He is the antithesis of an expert. He is the guy that's like, hey, Judge, I need to call somebody who's an electrical engineer and they're a swimming pool expert. I mean, this guy does teens, he does adolescents, and he does almost zero. In fact, I think if you probe deeper, he does zero on postpartum issues. And the reason that they kept jousting at the end, and it really got to be aggravating, and I think the jury was picking up on this, you have to remember, Dr. Mack does not believe that postpartum depression or postpartum psychosis is a disease or condition. To him, it's a blip in the DSM. Why is that? Because it's not his area. It's not his area of expertise. He doesn't know the articles that have been written. He doesn't know the experts that have lectured on it. He doesn't know. This guy, it's like you took a bag with experts' names in it and you reached in. What do you got? Pull one out there, Commonwealth. Okay, here we go. Dr. Mack, what do you think? I don't know. Let's get him in here. Totally wrong for this case. And so his theory is underwhelming and overriding theory was postpartum conditions are not in the DSM except as a quick reference. So therefore, any question you ask of me about symptoms of postpartum depression, postpartum psychosis, I can't answer. I will answer them in the context of psychosis, right? Not postpartum. So by weird way of analysis, if you consider that pretty much anything that happens after you have a child is postpartum, and if in fact you have a psychotic episode after you've had a child, well, by definition, I guess that's postpartum psychosis, but not in the way that it is being connected in this case. That is that it is a condition in and of itself. It is not a symptom of something else. It is not an underlying condition of a bipolar, although they may be interrelated. So if I ask him, well, what about this, and this for psychosis? Well, I can't answer that because he never looks at anything in the context of postpartum psychosis because it's not in the DSM. And he's relying on that because it's not his area of expertise. So they went back and forth on that so much. I was getting annoyed. And I think the jury was too. I really do. So anyway, packed today with a lot of the hangers on that have parachuted in. I'm looking at the media sign-in sheet. I think we were, thanks to my secret weapon, which Dina knows who she is, and I think you may have seen it. I posted that little video of me walking up today. Because of all of the new interest in this case, for all the folks who have been nowhere to be seen up until this point, there's a bigger line. And, the last thing I want to do is come up here and be shut out, right? So she was so helpful, and I couldn't be more appreciative. We'll see what happens tomorrow. For closings, it'll be even worse. The question is whether they get to closings tomorrow, since they have the rest of Heinbein, who, by the way, just on the first part of his direct examination, is far better and far more qualified and far more honest, where he's saying that he disagrees with Mac, which isn't saying much, but it sounds like a lot of his underlying assumptions, review, preliminary diagnosis is much more in line with reality and perhaps can be used by Kevin Reddington to support his experts, the defense experts. Anyway, I'm looking at the sign-in sheet for the media, and there's like Today Show, 3 people on there. What the fuck do you need 3 people from the Today Show sitting in the courtroom clogging up a seat? Why? 2 or 3 people from NBC News. Why? Are you trying to make up for lost time? It's wrong. And if these guys were better equipped and more suited, I love the bailiffs, I love the court folks. They're the best, but they're ill equipped for this. They're just not used to it. When I reached out to them prior to the first day of trial, and I said, so what's first of all, like a moron, I'm thinking from day one, this is going to get some eyeballs. This is going to get some attention because the issues are so important. So I reached out. Well, do you guys have a plan for overflow for media or public, both, whatever? Oh, no, we don't. And then from day one, when I was here, I think there might have been 10 or 15 media, whereas now on the list, there's probably 50. And you can't get all 50 of them in the courtroom. So because they aren't quite equipped for that, and even today, and I'm guessing for closings, there will not be any sort of overflow, but they aren't sophisticated enough to make it very clear. Look, 1 seat per organization, news organization, outlet, however you want to describe them. 1, that's it. Takes care of the problem. Nobody's shut out. The assholes from New York or wherever they may be, they don't get to hog all the space. And those who have been here every week since the beginning don't have to, get up at 6 a.m. or fight to grab a little piece of the pine just so they can watch what they've been watching and following, in the case of Justice Serve TV, for years and present here every single week of the trial. Not every day. I didn't say every day. Every single week, 4 days of a given week, every single week. And here we are into week number 5. Anyway, that's the way it is. My solace is twofold. Get the message out there. However you got to do it, great. And your days are numbered. I mean, the reason you're here is because of the import this has gained and the eyeballs it's gained online, not because of what you're doing in cable or regular news. No, you're doomed. Your days are numbered, so enjoy. Takes 3 people from mainstream media to figure out anything. No independent thinkers. Plus, they all love the rug companies. Yeah, well, they're certainly bought and paid for, aren't they? And just watch a few minutes of any of their programming, and it is brutal. Okay, so let me see if any of the notes before. I don't even mind sitting here. Going to monitor. As soon as they go back in live, I'll if I have to wait a few minutes for somebody to leave before I can go back in with this particular witness, I don't care. Cross will be a little more entertaining, but I think like the jurors, are just done. Can you give us the case? Can you do that? We aren't going to spend a lot more time. I can't imagine a doctor coming in and changing anybody's mind, whatever that mind may be at the moment. I did like, and we'd expected this in the further cross of Mac, and that was, are you familiar with the Torres case? Are you familiar with the Cantor case? Are you familiar with the LeBron case? All of them in which you were found to be a total incompetent moron. Do you remember any of those cases? It doesn't ring a bell. Good luck resurrecting and rehabbing that, and the Commonwealth was really not able to do that. They only talked about one case where the argument was it was a kind of a review by a number of experts of a given situation, and they chose not to use him because he was not qualified in that area. Sound familiar? Yeah. So that was brutal. And I know that Kevin Reddington said, I don't normally ask this question, but hey, the Commonwealth brought it up. So, how much you making? How much you make from this operation? I think when he said hundreds of, from the work that you do each year, hundreds of thousands of dollars, I think if you're going to be vague, you might want to be vague on the low side. When you throw out, hundreds of thousands of dollars in such a nonchalant way, I think that annoys people. Bipolar, blah, blah, blah. And the reason, again, Dr. Mack could never say the words postpartum psychosis is he's looking for things that relate to a traditional psychosis, and he can't marry them with postpartum conditions. You just can't do it. Cannot do it. So his ultimate opinion, we heard Friday, didn't change. Major depressive disorder with adjustment disorder. And Heilbronn will have a different opinion. We've already heard part of it, right? So what do you think about Heilbronn and Mac going to the Tewksbury facility at the same time? I knew they were going to kind of poo-poo it, as we talked about on Friday. Oh, it was scheduling. We can't get all of the time we need. Therefore, we had to double up. Kevin Reddington made a final statement about that, really, by saying, are you saying my office had something to do with whether you could or couldn't see the defendant? And I think there was an objection. Witness tried to answer saying something like, well, I don't know about that, but I'm sure you were aware of it. Well, I hope he was aware of it. It's his client. What are you going to sneak in there, and pretend to be a doctor with the facility? Of course not. Of course he would have known that. Okay, so let me see if there are any notes on the new doctor who, like I said, I think he's potentially far better, but then how low a standard is Dr. Mack? Pretty low standard. Does he find psychosis at times? He's not sure. This stuff's going to be totally fleshed out and then torn apart. It'll be very interesting to see how Kevin Reddington treats this doctor, at least what we've seen so far, which seems much more appropriate and thorough and prepared and the right kind of guy for this case. So I think the cross should reflect that, with a touch more respect. But then again, it's a low standard. That last answer, I don't care. Okay, that to me was just, it was too much. Come on, dude. They talked about specifiers, of course, in the DSM. That's all that Dr. Mack knows is the DSM. So now you've got Dr. Heilbronn, who's been at it longer. He's done the similar materials much longer. He's consulted on 330 cases, 25% of those for the prosecution, which of course they want to point out because that's the minority of the cases he does. But in this case, he must feel so strongly that he has to do it. So that's why he's here for the prosecution in this particular case. Broke down the time period before September 2022 when Lindsay Clancy had some issues, primarily related to going to nursing school. We heard this earlier. She had some anxiety about the nursing school process and speaking in public, as 75% of all humans do. Remember, 75% of all humans, it's either 75 or 80, are more afraid of public speaking than dying. And then he got into the post-September 2022, which is obviously the key period of time. Dr. Tufts. Yes. There was a couple of notes I made here. She has the whole suicidal ideation. I got confused when I heard him talking about her concerned about her hurting herself, but I couldn't tell whether that was mixed in with hurting the children at some point. So I'm going to have to look that over or cheat on somebody else's notes. And he talked about the period of time in McLean for what that was worth. Comes up with his diagnosis of bipolar 2. Bipolar 2 is it's like the minor leagues. Bipolar 1 or just bipolar is Major League Baseball. So he decides she has that because of the various traits that he finds, the racing thoughts, the feeling like she's not going to get better, that she's numb, that all of these things. But he also found no real mania. And it sounds to me from all the doctors that manic episodes, are what will elevate bipolar 2 to good old-fashioned straight bipolar 1, as it were, or just bipolar. So that's what I found consistently of those that have been talking about it, that it seems that's the deciding factor. Okay, let's see. Let me go through a couple of items here while we're 10 jewels and a gold coin. Thank you, Christy Babe, or is it Christy Babe? It could be either. American Dreamer, thank you. One Just to Serve TV membership. Appreciate that. And look who's a new member. I wonder if we got one of those memberships. Lori Howard, 2061. Thank you for joining. Appreciate that. We're going to get back to some more traditional member stuff next week, because this case, in my opinion, if it's not done, verdict out the door by Wednesday, I'll be shocked. The line of day, postpartum is not a disease. Yeah. That's because the guy is married to the DSM. Whatever it says, if the DSM says it is a disease, I will say that it is a disease. But until then, I'm not going to say it. Joy, big question for Michael and Linda. If they are monitoring, can a rebuttal salvage Dr. Mack at this point? I said, this is a weird situation in which you have two more Commonwealth witnesses, rebuttal witnesses, that effectively have to rehabilitate Dr. Mack because he's that horrible. I've never seen that before. You can look at a witness, an expert, you're giving them a certain amount of credibility, credit, impact on the case, impact on your arguments. But when you have a guy that's just so bad that not only is he's a zero, he's a negative. So your next witnesses are going to have to help make him look better. That's a bigger question. It's not a question about whether Dr. Mack is salvageable, because I would say no. Will the other doctors that are testifying be able to help salvage him? So far, like I said, I like the guy who's on there now. I think he's reasonable. He seems to be experienced. And I guess we'll find out one day if the jury, someday soon, if the jury gave much thought to everybody but. So I'm just going through these. I forgot to delete, because if I don't delete what happens, I go through each one about 4 times, which is okay. That's not a horrible thing. There, see, there we go. Okay, got one. Okay. Do you think the prosecution provided Dr. Heilbronn with a list of the questions they were going to ask him? Well, up to this point, I mean, we've gotten into some of his diagnosis. This guy's done it before. So any list is going to look very similar case to case to case. The real question is, did they give him answers? Did they say, here's the critical questions. Could you give us these answers? Which, of course, would be discoverable and would be made into a major faux pas and embarrassing moment by any cross-examination, especially Kevin Reddington. So, yeah, I'm sure he has a sense of the ebb and flow of the questions just from experience. That's not unusual. You can sometimes even give an expert, areas of topics that you want to talk about. Obviously, he had his 10-point PowerPoint there. Who prepared that? I would ask, if I'm Kevin Reddington, who put that together? And I'm sure he's going to say, I did. But did he do it? Was there any input from the Commonwealth in putting that together? I don't know. That's a very legitimate line of questioning. We'll see if that happens. Yeah, I did notice this too, and I'm not sure that the jury did or that it made an impact on them. Michael, what did you think about the latest witness reading from his notes? And he's doing it. He was doing it even during talking about his history and his experience. Like, I've got my CV, but I can't tell you what the hell I've done. Let me look. That's weird. I mean, normally these guys, especially somebody who's worked as often as he has and as many cases as he has, I think he said 330. That was my note. You're not really note bound for things about what you have done. So I found that a little bit odd, but I wonder what the jury makes of it, because it didn't come off to me like I'm reading somebody else's stuff. It was more like this. Yeah, this is what I've done, and I'm maybe because I've done so much of it, I can't keep it straight. But it was odd. I don't see that a whole heck of a lot. If you got any questions, folks, pile them in now, or I'll be forced to go to the streaming comments, and then I could grab anything. Joanna White, thank you so much. Appreciate the new membership. I got a couple of cool books, authors I've lined up that we're going to get to with our Justice Served TV True Crime Book and Wine. Where were they at the beginning? Now, Sheila, I'm going to object to that question as vague. If you want to flesh that out and I can find it, I will be happy to answer that question. At the moment, though, I'm objecting. Minds were made up before the rebuttal witnesses. Definitely. Anyone taking notes on the jury? Yeah, they are. But when the cross exam for today of Dr. Mack, in my opinion, kind of hit a wall and just kept throwing itself against the same wall. Not much note taking going on. That's when I saw people like quizzing the witness in that quizzical way, but not engaged enough that they're jotting everything down. New witness, back to the notes, because he was new and he was saying some things that they hadn't heard, and they were more straightforward. Dr. Mack was all over the Mac. I mean, all over the map. It was unpleasant, and you think it was unpleasant for us. Woo. Dr. Halpern is reading his witness statements in conjunction with questions. Yeah, again, is that just the way he prepares? Is that is some? I would be asking that question just because it's been raised by folks who have been watching. It's doctor, is that these your notes, independent notes? Did the Commonwealth help you with that somehow? Because just to put away that fear, I don't read a whole lot into it. I'll be honest with you. Yes, areas of inquiry, of course. He's their employee, and I do appreciate their attempt to let the jury know that, hey, just because you're our guy doesn't mean you're going to tell us what we want to hear, right? Well, the fact is, if he really didn't have for them what they needed, he would not be on the witness stand. He might be in the file somewhere. He might be an undisclosed consultant, but he's not going to be on the witness list, and he's not going to be on the stand testifying. So, kind of a bit of sleight of hand. Typically, you don't need to get into that, but I think because the prior witness was so bad, the Commonwealth felt, yeah, maybe we got to let this jury, be reminded that this guy may have come up with something against us, but here he is testifying. Yeah, like if you didn't know, he'd still be testifying. Why does the Commonwealth want to enter video into evidence but not show it? Well, here's why, and I did post this too, because we know how long the interviews were. It was a total of 10 hours by Dr. Heilbrunn. Remember, day number 2, which was April 11 this year, was not attended by Dr. Mack. So that one was not videotaped, and it was, or recorded. Who videotapes anymore? How old are you? It was not recorded, and it was not including Dr. Mack. So only the 2 sessions, including both Dr. Mack and Dr. Heilbrunn, were video recorded by somebody in the room, which the defense wanted to make clear. It wasn't, the Commonwealth wanted to make clear that it wasn't, these 2 doctors just pounding on Lindsay Clancy, she's unarmed. Leave me alone. That there was another person in the room, and it's on video. They want to introduce that video to show that it was not a situation in which they were ganging up on Lindsay Clancy. But the thing is, that's when they went to sidebar. And I said, this is probably 7-8 hours of video, because the 2 days that both doctors were there, we know it was 4.5-ish the first day. Nobody asked, but I'm assuming somewhere close to that second day, which was really the third day with Heilbrunn in the middle by himself. You're not going to run that in court. There's not a chance in hell. So the compromise is make it available for the jurors. They'll have some way to play it if they so desire. I would say the odds are slim and none, and slim left town, as they say. But you never know. You're gonna get you may get a juror in there that's like, that's not fair. They sent both those doctors in, and they just ganged up on her. Okay, well let's go to the video recording, and let's see what that was like. Maybe you need to see 10 minutes of it. Maybe you skip around to see, you get a sense of what that interaction was really like. So that's why it's in after. You knew where it was going. I mean, I can't imagine. There's no way they could get away with playing to the jury a little clip. No. It would have been all or nothing. As it turns out, it was nothing. But they do have a chance to take a look at it when they get to, as they say, when they get to deliberating. What kind of cross-exam strategy will Reed use with this guy versus the rest of the Commonwealth medical people? Well, like I said, I think, Kevin Reddington has his style. I'd never second guess what he wants to do. However, I think when you have a witness that is less despicable, less an easy target, and so far with Dr. Heilbrunn, I think he seems sharper. Again, low standard. And I think he's more appropriate for this case. Now, he's not going to agree with the defense expert opinions, of course. But at least that's something that Kevin Reddington can focus on. Okay, here's how. Remember, that's the goal when you go after an expert. It's to attack the underpinnings of their opinions, whatever they may be, whomever they are that they relied on, whatever tests they relied on, whatever medical records they relied on, whatever police reports they relied on, and often as important, what they didn't have to rely on. Did you know this? Oh, no, I didn't know that. How about this? No, I didn't know that. How about this over here? Well, would any of that impact your opinion? Sometimes they'll admit it would. Sometimes they poo-poo it away and make it sound like, well, no, it's would have been nice to know, but it doesn't change my ultimate opinion. So, but the short answer to that question is, I don't think it'll be as aggressive, abrasive, and in my opinion, sometimes a bit rude beyond what really was necessary. Because I'm telling you, like I said, the guy it's like it's like shooting the proverbial fish in the barrel with that guy. What was the dig about? Where did you stay? The Wellesley house. What was the implication? What does Kevin here? I think he was just giving this guy shit because he's very vague. But I will tell you, it's a weird line of questioning. We knew that Mack and Heilbrunn did not drive together to Tewksbury, to the facility. We knew that one day Mack had the day off. I'm surprised he didn't start asking, well, did you go down and have a bowl of chowder? Did you have a lobster sandwich? That's that kind of questioning. It's really irrelevant where he stayed unless it was in, the Commonwealth's spare bedroom. And so I would have been objecting to all of that crap as irrelevant. Where he stayed, so what? Unless you've got some foundational information that suggests it was inappropriate where he stayed. He stayed at Wellesley at a private residence. Okay. More than I think anybody ever needed to know or should have cared about. I think it was just Reddington just dicking the guy around, to be honest with you. Again, easy target. Why did the Commonwealth in a video not show it? Yes. Boy, you should be thanking the judge for this. If he started, and I'm telling you, I've seen trials. I've never handled a trial where that kind of video has been allowed, but I know from cases I've followed or reported on, it has happened, and it is brutal. So be glad that was not allowed. It would have been interesting, I have to admit, to see Ms. Clancy, in that setting, just to, this is her home, Tewksbury, at the moment, and see her interact with these professionals, because we're not going to hear her testify. We really haven't seen or heard her do much of anything except some unintelligible language on the 911 call that I heard. So that, from that standpoint, would have been kind of interesting, and not objectionable on that standpoint, because once that was recorded, and again, I don't know what happened. I don't know if it was under oath, or there are objections that could be made to keep it out on a witness level, not on the medical records level or the medical testimony level. That's the only interest I would have had, just to see, how she looked, how she acted. But I think on balance, be very glad be very glad that is not something we have to pour and bore through. I'll tell you that. Okay, now I'm into the grabbing now, because I don't have, when I'm doing this thing on the fly, it's hard for me to see whether somebody's asking a question or whether it's just a comment. So I just grab. I'm just grabbing. Let's see what I got here. Following up on what we just talked about. Wellesley, a wealthy town from the west of Boston. Maybe the inference was that he was on a little vacay with the little biz mix in. Okay, here's my answer to that. So what? So what if he was? So what if he went out and had a nice dinner with friends on the night that he wasn't doing it? So what? I have no problem with that. Yeah, it was not quite the same, but it may have had the same impact. Dr. Sue, like Fauci, Mac pled the fifth in his faint responses. Yeah, perhaps he. And again, when they got to the very end, and he would just say, I just can't answer that question. He was not an experienced enough witness to know how to deal with that. And it comes back to that central theme that I mentioned. He does not believe that postpartum psychosis or depression is a thing, because the DSM does not. So when you start asking him questions about that specific condition, which he may describe, he may go as far as to call it a symptom of normal psychosis, he can't answer those questions. And the judge finally helped him out by saying, just tell him you can't answer the question. Yeah, that's one of the answers that I'd like to have. What does it make her look like? Patriotic revolution. I imagine the video makes Lindsay a very sympathetic defendant, even more sympathetic than sitting there. I think you may be right, but that is my curiosity. Christy, I'm calling you now Christy Babet, just because it sounds more exotic. I feel like Big Red today was a little easier on that witness during the Zoom last week. He was brutal, but I wouldn't trust him anyways to be a good doctor for people. No, that guy is going to need therapy after this whole thing is over. And it is technically over for him, but there's going to be a continued flashback, right? Interesting. Okay. Pletch. I think that's close. Michael said it's not fair and that they ganged up on her. Well, they may not have ganged up on Lindsay. You can't experience what Lindsay is feeling. So, someone's state of mind from an interview. Yeah, I get that. Yeah. And I think they just poo-pooed that whole 2-on-1 by suggesting it was a scheduling issue. Yeah, it was scheduling, because I don't think they've been trying to do it for 2.5 years. They've been trying to do it for a month or so before it actually happened. And we are Charlie 1971. If I'm on the jury, I have no interest in the recording. I'm looking for reasonable doubt. I found it already. Yeah, that's what I'm thinking. A lobster roll. You like a nice lobster roll, Nick? I had a great one when I was coming back from, I was going to say just this little golf tournament, but I might as well just say it was the U.S. Open. And sound like I'm pretentious. I just going to the golf course, and I took the ferry from Bridgeport, Connecticut, right across the Sound to Port Jefferson, and then got to drive another 20 minutes and get on the bus, blah, blah, blah. But on the way back, cute little mall of sorts, street side vendors and a restaurant that had the most amazing lobster roll. And, sometimes you'll get them, I should say most of the time, you'll get them and they're so globbed on with, gooey stuff and mayonnaise and secret sauce and whatever. And you're going, is there some lobster in here somewhere? This thing was just lobster, just chunks, and a little bit of drizzled butter on there. Oh man, I'm sure lobster is very high in calories. It's probably like a 5,000 calorie lobster roll, but it was good. Yeah, you're right. It's no ham sandwich. You're right. The other expert, you asked me that. You know where my notes are? I left my folder on the seat where I've been sitting, because I have an aisle seat. I like the aisle. You're closer to the hot dog vendors that way. And that's where I left my little note. Dang it. I knew you'd get me. I can't remember. But here's the key difference in terms of training. Dr. Mack was a psychiatrist. Dr. Heilbrunn is a psychologist. So if you're comparing your apples and your apples, Dr. Z, who I chatted with in the hallway there, I was reminded, I think I might have known this. He has a twin brother named Jeff. And he has, he said, we're within, I don't even know they studied these things, within 3% identicalness, identicalicity of one another, that they look mannerisms as identical as you could possibly be. Guess what he does too? He's a shrink as well. Just bizarre. So we were having some fun with that. I asked him, did you ever use that whole twin thing as, you know, like when you guys were dating, do that? So he did. He took the fifth on that, interestingly. Anyway, so he's the forensic psychologist, right? And Dr. Heilbrunn is the forensic psychologist. And you may have noted this. Remember, the Commonwealth tried to make a big deal out of Dr. Z being not just a forensic psychologist, but also treating psychologist. He's treating Lindsay Clancy. He's seen her 200 times or whatever that number was. So they've had with Heilbrunn, you know, he's above all that. No. If I'm going to be in a position where I'm going to be treating someone or I'm going to give a forensic evaluation of someone, I never do both. No. I look down on somebody who does that. He didn't say that. But that's the impression the Commonwealth is trying to leave, because we know that Dr. Z did both. And you know, when Kevin Reddington comes back up there, he's going to have to reference that. I wouldn't spend a ton of time on it, but that's the reason the Commonwealth mentioned it as they did. So, and then this third, I think the third witness, if anybody knows it, shout it out, because I have it on my little list. I think they are all, that person is also a forensic psychiatrist. So you'd have two psychiatrists and one psychologist. For the defense, they had Dr. Condi. Dr. Condi was the psychiatrist, the forensic psychiatrist, who I was not all that excited about. Not that excited. No, Sheila, I did not. In fact, the woman who was so lovely to bring me the lunch on Friday, first thing she said when I saw her here today, not on Friday, it was whatever day it was last week. First thing she said was, I didn't have time to make lunch. And I'm like, oh, well, harumph. No, I said, of course. I hadn't really expected that. I was just actually going to thank you again for the one you did last week, which was great. And today, because of the timing and all, I never stopped. I rolled into the parking lot 5 minutes before they opened the door, found Dina, and sauntered on in. So, you know, I'm eating like a Cliff Bar or something like that. Boo-hoo, poor me. I'll be fine. I just had another little snack of that type for the lunch break. Let's see. I didn't think their questioning together was a big deal. Yeah, you know, that's why I was asking you guys what you thought about that. I realize, I think in the real world, when they're marching to trial and all along the way, you don't know if the case is really going to trial. I feel more forgiving of that kind of thing, especially when it's the defense, when they're paying out of their own pocket, than when it's the government, like the Commonwealth. They know how to waste money here in Massachusetts. So maybe they could have gotten some folks engaged a little bit earlier, even though they weren't sure. Maybe there's an off road for this, as there should have been. I think maybe there's an off ramp that we don't have to go to trial. Maybe we won't need those experts, and so that's why they waited until earlier this year. I don't know, but that's the fact. And I think it's just a practical consideration. If we're going to do this, and if I'm not just Lindsay's legal representation, but if I'm her medical folks, to me, get it all done. It's maybe less stressful. It's, I think maybe it's not just more efficient, but maybe it's more humane. I don't know, just a thought. So I like Tangled Charlotte. I agree. I think to me it was not a huge deal. Hey folks, how are you today? Good. I'm sure you guys know by now, Lindsay Clancy's parents, they go through my office. They go right through my office. No big deal. Kevin, how's it going today? Good, right? Just I like to check in on you, make sure you're all right. Did you get a haircut? Got a haircut. Looking good, man. That's so, yeah. That's one of the bailiffs here. Super nice guy, or court officers, I guess technically. Okay, let's see. Where was I? Yeah, Tangled Charlotte. I do not disagree, which kind of means I agree. Double negatives. Okay, that's a good idea. Thanks, Sheila. Sheila and Joy on it as always. Let me move on down here and see if I can find anything. Oh wait, somebody starred some stuff. Let me circle back. Yeah, it's up to them. Jeanette Johnson 9926. All the to me that was the perfect compromise. Prosecution whining and moaning. We want to show this to show that blah blah blah. It wasn't a big deal, and the court says, "Are you crazy?" And put it in their evidence. They want to look at it. They can look at it. You never know. You could have, of the 12 that are finally in the box, you could have 11 people that are like, who cares? Move on. Who cares? And you got one person saying, no, I got to see it. So you look at it. I mean, it's got to be that collaborative effort. I personally would say, I don't know. If somebody else wants to look at it, I'd be like, I can live without it. But if anybody else wants to look at it, I'll watch. I would be just curious to see her demeanor and how it went. And I don't know which way it would cut, to tell you the truth. I don't know. For me, I mean, if I'm looking at that to decide which way I'm going on this case, I think something's wrong. That should not be a deciding factor in the case. Via Google. There you go. Thank you so much. Satoff, I'm assuming is the pronunciation. Forensic psychiatrist. That was my recollection. And a professor at the University of Virginia. Thank you, BCBA brat. I put the accent on the brat. BCBA brat. Thank you so much. I appreciate that. I know that's on my list because that last name, that's why I couldn't remember it. The last name is a little wacky. It could be Satoff, Sathoff, Satoff, Sawtoff, Sawthoff. It could be any or all of those things. Where is that? Is that German, you think? Swedish? I don't know. No. Is this something you're guessing or that's what you heard? Because that to me would be short shrift. I mean, I know Commonwealth did 20 minutes on their open. Reddington did 31 minutes, and we just went over that. If you haven't seen it yet, the defense version of Promises Kept, ? Which I launched on Saturday. So if you haven't seen that, take a look at that as we head toward closing arguments. But I don't know. I have not heard that. To answer your question, I did not hear that. And certainly we're going to learn more about that officially either today or tomorrow. Tomorrow may end up being, I'm predicting perhaps, last expert in part. I don't know, will it take 2 hours to finish up this dude? I hope not. But if it does, then we'll have the third witness, and that'll be the whole day tomorrow. And then they'll use the afternoon for the continued jury instruction conference. Remember, at least no, the judge didn't call me. Hold on a second. This may be him. Okay, bye. Yeah, we don't know about the instruction that's been requested by the defense for involuntary intoxication. If that instruction is allowed, and of course the Commonwealth says, no evidence she was intoxicated. Drugs were all out of her system by then. Well, thank you, doctor. You have no clue because you didn't do blood tests. You have no idea what was in or out of her system at the time of the incident. Defense is saying, well, no, clearly it was involuntary intoxication. She wasn't taking these meds to get high and loopy. So we want the instruction. If that instruction is allowed, then you've opened the door for involuntary manslaughter. That is a max 20 years here under most circumstances. There are aggravating and mitigating circumstances, but there's no mandatory minimum. So with Lindsay Clancy having no prior record, with her medical condition being what it is, judge could come in and say 5 years. We don't know. Could say 5 years suspended. We don't know. Suspended until she's released from whatever facility has to get her to be as normal as possible. So yeah, we'll see. I'm very interested in that. I think that would happen with whatever's left of tomorrow, and then boom, Wednesday you're right off with the closings and jury instructions, and then they get deliberating. Thank you. I see 3 people reminding me of my bad note taking and my failure to bring my notes here. Gregory Satoff. Who's going with Satoff? Satoff. versus Sathoff. I think those are the two likely. Satoff and Sathoff. Oh, that was I was checking on Kevin. There he goes. There's Kevin. There's Kevin right there. Say, Kevin, nice haircut. It was definitely, especially for court officer, it was kind of floppy down over his ears. So he appreciated. I noticed his haircut. If it wasn't a little windy out here, I might not have noticed. Okay. Again, I need to personally get the info on this from the court, but I have no reason to distrust. I just think it's really too short. I think an hour each side is plenty. Look at all the number of doctors, the number of recipient witnesses, the arguments, which can be kind of convoluted, and they need a little time. People can kind of process when it's laid out for you. I think it's too short. But I have no reason at this point in time to discount what Pletcher is telling me. And others have mentioned 30 minutes for Commonwealth, 30 minutes for defense. Of course, that would be weird. Commonwealth, you get 30 minutes. Defense, you get 20. Are they going to break up the Commonwealth, though? As I recall, I should remember this from Kelsey Fitzsimmons. We just had this. As I recall, defense goes first, prosecution goes second, and they don't have a rebuttal in this part of the world. Once again, weird. Another weirdness, normally you've got, because the Commonwealth has the burden, or the state has the burden, they go first, and then they reserve a little bit for rebuttal. I think it's the best way to wrap the story, right? But again, we're in Massachusetts. We'll see. And again, if you've only got 30 minutes, how much time and effort can you spend on that patriotic revolution? I think you almost have to decide, okay, where do I have to hit hardest? What is it? I see it's 2:00 now, guys. I've got my eye on the court situation, and I hear we've had some glitchy stuff from the feed or from StreamYard or whomever else we can blame. But that is not us. We're trying to keep that stuff as smooth as we can. Joy, thank you for doing that. And I know that Joy will cut me off mid-sentence if they're back in court and I haven't noticed it. So don't you worry. Yes, I would agree. I would use the same legal term, Carrot Tree. Crappy. Only 30 minutes. That's crappy. That's hardly nothing. So I mean, if it is 30 minutes, you gotta really decide what you think is so important that you focus a good chunk of that on your closing. Okay, I'm doing some cleanup here. Clean up on aisle 5. I can do that. Do that. Again, I'm gonna kind of hang here until I see there's activity. Then I'll go up. I'm not worried about it. I put my folder on my seat. We'll see if somebody's going to sit on it or not. And I really don't care. I'll get in there plenty of time to see the rest of this guy's testimony and check out the jury. Yeah. Okay. Another country heard from Otto. I'm okay with them making 30 minutes each. I'm guessing, Otto 1630, you've made up your mind already. So for you, shorter the better. Let's get in there. Let's get in there and mix it up. They both have so much to work with if they really wanted to. Not just between the law, which is so critical, but so many facts. He took longer than she did on the open. Okay. He took 31-ish and she took barely 20. So who knows? Oh, is that a question? KC, what's the plan tonight? Hanging out? Usually we do our thing at 6. So by the time that's done, it's 7-ish. Then I go and actually get some food. And then I go back through the day's stuff and I pull out a couple of clips, which we post. And then I kind of look forward to what's going on the next day. Tomorrow might be different. As we get toward the end of this thing, there's less kind of stuff to prep for or review. I already been chatting with Bob Mata, who came on with us on Friday. He's been up here, he's from Chicago, Defense Diaries, and he's been here. I'm very lucky. I mean, it's a lovely area, but I don't want to be spending my weekends here. I'm lucky I can go on home. I guess Reddington will treat this witness far different because he cannot stand incompetence and time wasting people. Yeah, I give him the benefit of the doubt on that. I think he will be, again, it's a low bar, but I do think he'll be more respectful, no doubt. Okay, now I'm going to have to take away your Justice Serve TV deputy correspondent badge. I don't remember my source for the 30 minutes, but I didn't make it up. Your Honor, I can swear on, well, not a Bible, I didn't make it up. Just look at this face. Would this face make something up? Yeah, again, I have no reason to doubt it. I just haven't confirmed it. Well, are you sure about this? Because again, it's Massachusetts, and maybe it's something that most in Massachusetts have not done, and that is the splitting, because they go second. So what are you gonna do? You stop and then start again? We'll see. We'll see. I only know from the most recent trial we covered, which was Kelsey, and that wasn't all that long ago. And obviously Karen Reed 1 and 2. So we'll see. Yeah, this is how things happen. Brian Anton, who I saw, I haven't had said hi to him. I do want to get some Nancy Guthrie stories from him, because he was out there pounding it and did a great job. But when it was very clear the case was going nowhere, he was still out there. And so I'm actually giving him just a bit of a break here because he parachuted in with all the other later folks. But I think he's earned a little grace. He said 30 minutes, but he doesn't know where he heard it either. Or so I don't know. Again. Yeah. Hey, maybe can we get Auntie Bev to come in and just listen to the closings just for fun? Yeah, I mean, I fully agree with this. I mean, Joy, he's solid. He's not gonna. He's whatever he has to work with, he's going to work with, and it'll be great and it'll be effective. But I guarantee you, he's this is like doing a Cliff Notes version of closing. I was talking to, if this is our Karen we're talking about here, where'd that go? Yeah, Laura Blue. She sends me a note, because like I said, they queued up very early and she had some traffic issues, et cetera, et cetera. So she got shut out. And then what they do is, as somebody from the media leaves, and sometimes it's, one of the local reporter types, they've got to do a live shot, so they have to run out. They don't hold your seat at that point. They are, it's kind of a loose hold right now, depending what you put in your seat that maybe is more likely to maintain. There's a little bit of, camaraderie and mutual respect in the media, but not with everybody. So if you leave during the proceeding, the bailiffs just let another person in and they'll go right to where you left a hole. So that's what she was able to do. Karen was able to come in after somebody left a hole, as they say. Yeah, and this has been a conversation, amongst some of the folks who are speculating, what if she is found not guilty by lack of criminal responsibility, which means disease or defect kept her from either knowing what she was doing or knowing that what she was doing was wrong. Lack of that ability to understand that because of psychosis. That's the defense position. So she goes to a facility in Tewksbury. I know they have a locked ward, obviously, but I think it's a broader facility than that. So I'm assuming maybe she would stay there and she would have periodic reviews Maybe it's annual. That I think is all subject to discussion by the healthcare providers and the corrections department, I suppose. But if she's not guilty, she's not guilty. And when that condition is resolved, meaning she's healthy mentally, then, they could put her in, the Ritz of all facilities to take care of her. It's originally from Northeast Germany. That was my first guess, Germany. So we'll see how to I like, just my gut tells me Satov with no H in there. H is silent. Satov. As German is more, they're more fricative. They're more, it's a little more Satov. So I don't think it's gonna be a softened Satov, but I may be wrong. And you can pronounce your name however the heck you want. Do you think they'll have the closings written already? I would say to a large degree, and I don't think we talk Commonwealth. I think they're going to be trying to virtually memorize theirs, but still working off notes, very script bound. Whereas Reddington is, he's a high points kind of guy. Just here's my bullet points. Here they are, and I'm off. And you'll notice when he wanders around, and I expect he'll do a decent amount of wandering as he tends to. He'll circle back to the lectern, maybe to the defense table, so he can stand by Lindsay. That's where he's picking up, whatever the next bullet point is, or making sure he hit the ones that he wants to hit, because that's all he needs. He just needs a very short little reminder of what he's really trying to spit out there. Thank you for the jewels and the sunshine. It's a beautiful day here today. Nice and nice little breeze, but I don't know if it hits 80 today, I'll be shocked. Thank you, Cindy W481. Thanks for the jewels. Okay, our 15-minute break this morning went 45. So, and the thing is, other than we had a pretty healthy morning. I have to admit, I don't do these very often, but I'm not getting paid to advertise. This will get me through the afternoon. This morning, though, we started at 9:10. The jury came in at 9:11 or 12, and we were going almost solid 2 hours, which doesn't sound like a lot, but it is, especially when it's medical testimony, especially when you end with the direct from Bo Buckingham. You notice over the last couple of weeks after it became an issue, all the people doing those things online with massive bows and clown makeup, and the bows are now much more, they're very subtle. They're kind of her hair color, and they're smaller. So she's not giving it up. I'll give her credit for that, but she's definitely not making a statement as she was early on. And everybody was like, oh my gosh, can you believe that? Okay, what do you got here? What do you got here planned here, Joy? We play trivia. We have some really smart chat. I bet. I'm sure of that. This is the combination. This is the best kept secret in true crime with the smartest viewers, watchers, chatters, members. We have no 2-digit IQ people in this operation. All right. Okay. Clock. And now it's 2:10. So there you go. And I still see nothing happening. Yeah, we talked about this too. It happened before in a couple of cases. Melissa Voiles, wireless pack. What it does though is it really talk about hot mic moments. You really have to be aware of what's happening with your, is your pack on? Is it off? It's another layer of really TV production that I think they're trying to avoid because it's so different. It just calls such attention to the electronic coverage. So. Yes, maybe their bows are diminutive, but wait a minute, that was not a nice thing to say. Volume booster. Yeah, we appreciate that. And then sometimes if you're not careful, when they go to the mic, you get volume boost right out of the room. there will be a motive and intent of maliciousness or benefit if she was on her right mind. And that, the intent is the whole issue in this case, obviously. Did she have the ability to form the intent to kill those children, or was it all part of this delusion? And that's what a psychotic episode is: detached from reality, a delusion, not knowing what she was doing, or not knowing that it was wrong. Remember from Dr. Video, I can't think of his name, preeminent psychiatric doctor, forensic psychiatry. He really put a fine point on the motive, and that was, if I can't be here for my kids, then they're better off without me. I think that was a very powerful moment. So powerful I can't remember his name. Somebody throw it out there. I'm sure you will. Resnick. Thank you. I always keep thinking of Rentschler. Don't get me started in that direction. You guys are, how should I put this, very honest about how you feel about certain things. Okay, this is good. I know what everyone says. I'm still not convinced she did it. There's some oddities around testimonies for me. Okay, interesting. Amy loves soccer. I need more to give any sort of credence to that, because you're saying some other dude did it, and is that dude Pat, or is that another? You think somehow it wasn't at her hand? There was one guy out here with a sign that said Patrick did it. I don't know. It's been cycling around, so I'm sure you've seen it. He actually, over some time, had more people gather around him in support. So,
Jury?
Yes, Your Honor.
Hi, yeah, bring him in.
when that jury Bryant out of the way. Okay, guys, we'll see you after.
Court, all rise. Jurors entering. This court is now in session. Please be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, including the defendant and including the 18 jurors.
All right, thank you, Madam Clerk. Members of the jury, we're going to return now to the direct exam of this witness. All right, counsel.
Thank you, Your Honor. Doctor, before we broke, you were describing the various psychological tests that you conducted on Ms. Clancy. Can you tell us the results of those tests?
Yes, I can. On the MMPI, which I spoke about first, and this was, of course, 3.5 years after the alleged offense. So it's going to describe, much of it is going to describe her thinking and feeling and behavior in April of 2026 rather than January of 2023. But it's something that's always a challenge when you try to reconstruct what happened some time ago. And so some of these tests were administered from the standpoint of what was it like for you back then. But the MMPI was delivered in terms of how you're doing right now. And she, on the response style scales that I talked about earlier, she showed a slight tendency to underreport, to deny unusual experiences, although she did that in a way that was pretty sophisticated. She's a bright woman. And so given this, we kind of take into account a little bit the fact that she might be underreporting a little bit in terms of what's really wrong with her. However, there are a number of what we call clinical scales on this test, and she was not elevated on any of them, meaning that she's not actively symptomatic in many areas or in great distress in certain ways. But there was one scale that is elevated, and that is the suicide and death ideation scale, thinking about suicide and death. And I should say that Ms. Clancy has been on 1-to-1 suicide precautions, which is the highest level of precautions that a hospital can take, since she came to Tewksbury. This is a very long time to be on that kind of precautions. And what it says to me is that she was at risk for suicide. She remains at risk for suicide. And so she still is. The Adverse Childhood Experience Questionnaire I mentioned earlier, basically it's a measure of whether somebody is reporting experiencing as a child or adolescent adverse or traumatic events. And she was not. So she had a 0 on that. There were 2 measures of suicide intent. One is called Beck's Suicide Intent Scale, and the other is called the Columbia Suicide Severity Rating Scale. And I can sum up those results very quickly by saying that when she responded to one of them as she would have if she'd been filling it out in January of 2023, what it suggested is that this was a very serious suicide attempt at that time. And when she responded to both of them as she feels right now, she also was indicating that she remains at high risk for suicide, and hence the 1-to-1 supervision for 3.5 years. The brief symptom inventory is something where you ask people about a number of possible symptoms that they've been experiencing within the last month or so. Gave it to her under 2 circumstances. One is, how are you doing right now? That is around April of this year. And the other was, how are you doing in January of 2023? Her description of how she was doing in January of 2023 is that she endorsed feeling blue or still extremely depressed, feeling no interest in things, thoughts of death or dying, feeling hopeless about the future, feeling very self-conscious with others, and the idea that something is wrong with her mind. She thought depression, suspiciousness, memory problems, problems with attention and concentration, and things like she was having trouble concentrating. So she'd be cooking, for instance, and she'd forget what step she was on. So most of these are consistent with symptoms of depression. And so I thought that they were good indications that she was endorsing feelings of depression, although she was improving somewhat from her December feelings. Something called the Obsessional Beliefs Questionnaire has 3 scales. One scale is kind of responsibility threat estimation, which is a belief about your personal responsibility and overestimation of threats. She was not elevated on that. A second was perfectionism and certainty. She was not elevated on that either, although she works hard and so on, but she was not elevated on the perfectionist aspect of this test right now. However, she was elevated on something called importance and control of thoughts, meaning that for her, it's always been important to be able to work hard and control what's going on with her mind and her life. And one of the things that I'm going to talk about in a few minutes that I think was making her depressed and hopeless and sad and so on is that she had been trying very hard since October to basically control the problems that she was having, and it wasn't working. It was not succeeding for her. Okay, and then there was something called the Lahoney-Slade hallucination scale. And so she endorsed the following things. Sometimes a passing thought will seem so real it frightens me. Sometimes I get distracted trying to concentrate on my work. That was something she endorsed back in 22 and 23. In the past, I've had the experience of hearing a person's voice and then found there was no one there. That was only on January 24th. I often hear a voice speaking my thoughts aloud, again, only on January 24th. I've been troubled by hearing voices in my head, again, only on January 24th. All right, so those were the psychological testing results, and I'm going to move to the last item on the PowerPoint here, which is why it was important for me to consider her motivation for killing her children. And this is something that, if you look at Lindsay Clancy, would be described as so out of character that I just like to know what could possibly have been going on. Because, for instance, when I talked to her and talked to her husband as well about how do you discipline your kids, it was never spanking, it was never hands-on, it was never anything like that. They both felt bad when they yelled at the kids. So it was one of those things that to imagine her doing something like this is really seems so out of character that I thought it was very important to try to figure out why it might have happened. So this is how I approached it. The other thing about the why question is it could well be something that is valuable to know when we're thinking about whether she understood that something was wrong, or when she was thinking about whether she could conform her conduct to the requirements of the law or control herself. The why question seemed important. So if I could have the next slide.
Sure. And in evaluating the why, did you come up with two possible explanations?
I did, yes, which is on this slide.
And so can you explain that, please?
I can, yes. There are a number of reasons in my experience why people harm one another, why people kill one another. And most of these reasons ended up not applying to Miss Clancy. I mean, it wasn't job related. She wasn't in the military, the police. Didn't have to do with money or property or fame or anger or being callous or abusive or being afraid or doing it himself. None of those there was any evidence for. But there were a couple of things that started to have some evidence for, and this is what it looked like. One is the psychosis, the possibility that she had a severe mental illness, experiencing hallucinations, delusions, that sort of thing. And as part of that, on January 24th, experienced those symptoms that we're going to talk about in a minute. And I'm calling that the first bullet point there, acute psychosis with command hallucinations. The second possible explanation was as part of an attempt to take one's own life, as part of a suicide, one might harm one's children if you thought that would prevent them from suffering. And let me see if I can give you an example of that. If one of us were to learn, and we had no doubt in our mind that the Holocaust was coming tomorrow, and we thought that was going to be awful, and I can't live through that, and so I'm going to take my own life. If I had children, the question might come up, do I take them with me? Do I take their lives as well? Now, I'm not saying that I would definitely do that, but what I'm saying is that it would come up as a possibility in what I thought about. And so there ended up being, in my mind, two possible explanations for why she did what she did. The first being the acute psychosis with command hallucinations, and the second being this was a serious suicide attempt, and she wanted the children to be with her so she wouldn't be separated from them, and so they wouldn't have to suffer after she was gone. Now, in a minute, I'm going to talk about the evidence that I saw supporting each of those, but I will tell you right now, in advance of talking about that, that most of the evidence that I saw supported the second one and not the first.
And so, doctor, if we could go to the next slide and you could talk to us, tell us what evidence you saw for acute psychosis with command hallucinations.
Yes. The first was, that's what she said. I asked her that question, and that's the way she explained it happened. She said, sometime on the afternoon of January 24th, 2023, that she heard a voice, and the voice said, "This is your last chance. You have to kill the kids so you can kill yourself." If she actually heard a voice like that, that would be evidence of psychosis being experienced and what we call command hallucinations, where the voice is instructing her to do something. There were some other possible things that made me think that it could be a severe mental illness that she was experiencing, and two in particular. One was thinking that others might know her thoughts. Now, this is something that is a symptom of psychosis called thought broadcasting if it's experienced in a certain way. In thought broadcasting, if I'm experiencing that, I literally have the idea that if I'm thinking it, you can hear what I'm saying, just as if I were putting it on the television or podcast or a movie or whatever. It's just coming out that way. I asked her about that, and she said, and other people asked her about that too, and she said it was not thought broadcasting, but these were very vivid thoughts, and she thought that it might be that people could hear them as vivid and strong as they were. The second possible symptom is that thinking police might take her children. Now, in some of the records I saw people saying, "Wow, this looks like a paranoid delusion to me." And I will tell you that it didn't look either paranoid or like a delusion to me. And here's why. I'm a healthcare professional, and that means that in Pennsylvania and every other state I know, I'm a mandated reporter. If someone tells me in therapy or in an assessment that they think that a child is going to be injured or severely hurt or that might happen, then I'm required by law to contact Childline in Pennsylvania. Ms. Clancy is a labor and delivery nurse. She's a healthcare professional as well. And so it's one of those things where if she had said to a psychiatrist, psychologist, anyone providing treatment, that she thought she was experiencing ideas like she might harm her kids, she would know as a mandated reporter that they were legally required to report that. Now, that might not mean that the police would literally come and take her kids away, but it would mean that there would be an investigation. She would have to answer questions, and it might be that for a period of time she would be separated from the children.
And doctor, is it?
Well, can she answer?
I thought he was done.
I
don't know.
Well, we'll find out. Are you done?
I just want to ask a follow-up question about your last point. Is that okay?
Oh, yes, that's okay.
And so you mentioned you didn't think it was a delusion. Is it true that a delusion is a fixed false belief?
Yes, that's the way it's defined.
And so Ms. Clancy thinking that if someone knew she thought of harming her kids might be taken away, that's not a false belief, correct?
Well, that was what I was trying to say, is that it is not a false belief. It's quite possible that it could come to pass.
And if you could continue with your discussion of why, the evidence you saw for acute psychosis.
Yes. The other point there at the bottom is that it's appealing as an explanation because it could explain acts that seem so out of character for her. You don't have to get complicated at all. It's just, I had a psychotic episode. I heard a voice. The voice told me to do something terrible. I did it.
And after considering the evidence for acute psychosis, command hallucinations, did you then consider evidence against acute psychosis with command hallucinations?
I did, yes.
And what did you see?
One of the reasons, well, the first bullet point here is that the way she described this as happening is that she heard a voice that she'd never heard before, experienced an hallucination, and she's never experienced it since, but she only experienced it for the 18 minutes or so that it took to kill the children. And to put it mildly, that would be a very, very unusual pattern or manifestation of how this kind of thing comes about. Very unusual. I've been doing this kind of evaluation for many, many years, and I'm always very careful when someone tells me that they experienced a symptom only during the course of committing an offense.
Why is that, doctor? Why are you careful when someone tells you that they only experience this voice during a criminal offense?
Well, because it provides a convenient way of lessening your own culpability. I mean, it's always possible, but as I said, I find it very, very rare. Whereas an explanation for why somebody did something, somebody might look at that and say, it's a convenient way of somebody looks at me and I don't have the same culpability that I would otherwise.
And what was the next part of evidence that you saw against acute psychosis?
There was some discussion of whether this was postpartum. And so she was about 8 months away from having given birth to Cowan, her youngest child. And most of the explanations or most of the sources of authority like DSM-5 or the Cleveland Clinic will point to maybe 1 month after birth or 2 months after birth or something like that. But the farther away you get time-wise from the birth, the less likely it is under those kinds of authority to be postpartum. Now, it could be something else. And there were certainly some things that I saw that were symptoms of depression and other sorts of things that she experienced in January. But it was, given the time, it was less likely, I thought, to be postpartum. Then the next bullet was inconsistencies in her account. To me, when asked about this, she said, the voice said, "This is your last chance. You have to kill the kids so you can kill yourself." And it just kept repeating that, and only that, for about 18 minutes, or the duration of the time it took to do this. There were other times, though, for instance, when she was in the hospital after this happened and was talking to a psychiatric attending, when she said that the voice had said other things, for example, the children will suffer without you, or you have to take the kids with you, or things like that. So inconsistency is important because it suggests inaccuracy. In other words, which version is accurate? Is it the first? Is it the second? Is it neither? I mean, here it couldn't be both, because she said, I only heard this. To some people, she said that. And then I heard this plus this To other people, she said that.
And doctor, if she had said to a third person that it was a different version, such as you have to kill the kids so you can kill yourself because there's a danger to you and the kids, would that be a further consideration of the inconsistencies?
Objection.
Yeah, overall.
The more inconsistency there is,
Can we have a basis for that, at least?
The
It's
test,
asked as a hypothetical?
hypothetical, yes.
I'll allow that.
So it's not based on evidence, it's a hypothetical.
It's a hypothetical.
you might have to repeat the question.
So if the person has a third version of what happened, what the voice said and what the reasons the voice gave, would that be important in your assessment as well regarding inconsistency?
Objection. It's speculation, it's not based on evidence, and there's no foundation for a hypothetical question.
Let's just ask it as the hypothetical. You know, assuming this and then go that way.
Doctor, a hypothetical question for you. Assuming that a person has already given two versions of a voice, what the voice said for them to do, and then gives a third version of what the voice told them to do, would that be significant to you in assessing the inconsistencies?
Objection for the record.
Yeah, overall, go ahead.
What I would say is the more inconsistency there is, the more problematic I find it to take any one particular account and say this is the accurate one.
And then what other evidence did you find against acute psychosis?
There is some research that's been conducted on malingered hallucinations, which are accounts of hallucinations that are exaggerated or fabricated. And I found it useful to look at those, look at that research and see what it suggested and kind of lay it out there in terms of the way she described it. So some research suggests that that one consideration is whether the voices are internal or external, whether they're coming from your own thoughts or whether they're coming from outside of your head. And Ms. Clancy perceived this voice as external, which is more consistent with genuine hallucinations. However, command hallucinations are often, in about 88% of individuals reporting them by one account, accompanied by a related delusion. Ms. Clancy did not report any accompanied delusions. So thus far, you've got 1 point for genuine and 1 point for possible exaggerated. Then there's frequency and control. Genuine psychotic hallucinations are more often intermittent than constant. They'll come and they'll go. You'll hear it, stop hearing it. You'll hear it again, stop hearing it, and this can extend over a period of time. Ms. Clancy, in this instance, reported that the voice was constant for 18 to 20 minutes, and then it stopped. It had not been experienced before, and it has not been experienced since. And she also did not report having any control over the voice or over her actions in response to the voice. Then the next item is content. So genuine hallucinations are often familiar, use both genders, and are clear rather than vague. Ms. Clancy described this voice as clear, but it was unfamiliar and it was a single male voice. So that was sort of mixed. I'm not counting it as one direction or another. And then finally, reaction and coping. Individuals who experience hallucinations like this often try to reduce their influence by in different ways. Could be praying, could be listening to music, and while those who inaccurately report the experience of such hallucinations often do not describe coping mechanisms. And Ms. Clancy didn't report any attempt to stop the voice or distract herself from it or what have you. So there were about 3 points on which her account more closely resembled exaggerated or fabricated hallucinations, one where it looked more genuine and one that was kind of mixed.
If I could ask you a question, you said that there were more points indicating malingering or exaggerating the existence of the voice. But earlier you testified about your psychological testing of Ms. Clancy, and it showed minimization, and it didn't show malingering. Could you explain how those two things could occur in the same person at the same time?
Yes. When we try to appraise through testing or specialized measures something that looks like malingering or exaggeration, the way we typically do it as psychologists who develop the measures is it looks like somebody who is going to take a shotgun approach. They're going to say unusual things are wrong and strange things are wrong and many things are wrong and things like that. If you do that, we're pretty good at picking up that shotgun approach to malingering. But if I ask you a bunch of questions and you answer them almost entirely in a genuine way, that you're being as accurate as you can, except with one exception, when I ask you about one experience or one symptom and you exaggerate or fabricate that, it's we can't pick that up through our testing. So what we have to do instead is we have to kind of develop our ideas about how it might have been experienced, what it was consistent with, what the disorder is. We take a broader approach, which is what I've tried to do in talking about this.
We'll go to the next slide, please. And was there further evidence against acute psychosis?
Yes. I'm going to start with the question of thoughts or hallucinations. I've already said that I found the account of hallucinations to be, as she described it, it would be very, very unusual to experience it that way. Never having, not before, not since, constantly for 18 minutes. However, if this was a thought, an unwelcome, intrusive thought, but still a thought, that's basically, this is your last chance, you have to kill the kids so you can kill yourself, then that would be consistent with thoughts that she'd been experiencing for some time. She'd been having thoughts about harming herself, that she was, it was going to be very difficult for her to do this in a way that was that made sense. She was experiencing thoughts about hurting herself because her brain might have been damaged. She was experiencing thoughts about hurting the kids. She was experiencing all sorts of unwelcome thoughts. If that were the case on January 24th, if these were thoughts, then that would be consistent with what she'd been experiencing for months before. So that was something that made more sense to me, that rather than an auditory hallucination, it would have been an unwelcome, intrusive thought. The next bullet is her response to her husband's question, what did you do? So when he got home around 6 p.m. on January 24th, and the house was quiet, and he went in, thought people might have been playing hide and seek with him, called downstairs, didn't get an answer, called upstairs, didn't get an answer, went upstairs, found the bedroom door locked, unlocked it with his key, went in, saw some blood there, saw the window was open, ran downstairs, and he saw his wife, Lindsay, lying there semi-conscious. And he said, his first question was, what did you do? And her response was, I tried to kill myself. Now, I thought that if she had actually experienced this command hallucination, that she might have said something like, I did what I had to do, or I did what the voice said, or something like that. But no, she said, I tried to kill myself. And this is consistent with my looking at this and starting from the perspective of this is a serious, highly lethal suicide attempt. And that's the way to understand it. And then the last bullet point has to do with the recovery of memories. So when she regained consciousness that night in the hospital. One of the things she said is that she wasn't able to remember what had happened. And she was informed of it, but if this had been a genuine memory loss, then human memory is funny. And one of the things that happens is that when you're trying to remember something that actually happened, things can interfere with that. Things that you read, things that you're told, other sorts of things like that. So it would have been hard to understand how she would recover that memory accurately, including the particular memory of the command auditory hallucination, what it said.
And doctor, did you already go over the first bullet point, the inconsistencies in her description of knowing wrongfulness?
Yeah, I'm gonna pass on that one. Go to the next slide.
Okay, you don't have that's not a consideration?
Well, there were some additional inconsistencies in terms of whether she knew that when I asked her whether she was aware that it was illegal or immoral, she said basically, I wasn't thinking about this at all. No thoughts, no decisions, none of that. It was just all action. One of the things that Dr. Resnick wrote in his report is that she was intellectually aware that it was wrong or illegal, but not morally. And what she said to me is that I just don't think I wasn't thinking about that at all. I didn't know any of that.
Okay. And if we could go to the next slide, I think if you could describe for us the evidence that you saw for suicide combined with altruistic filicide.
Yeah. Altruistic filicide is a term that's used that means killing your kids out of love. Not because you're trying to be cruel or for material gain or because you want them out of your lives or any of that, but killing them out of love so that you could basically, they wouldn't have to suffer, so you could prevent their suffering. And what she did, I thought, was begin with what I said a minute ago was a highly lethal and very serious suicide attempt.
And that was preceded
by months of thoughts and impulses about you should harm yourself, you should kill yourself, your brain is damaged, that sort of thing. And that, I think, is the beginning of the way to understand what happened that day. The second point is that, as I've said before, she didn't like to leave her children. Whether that was for date night or school or going back to work or anything, she did not like to leave her children. And if she had taken her own life, then her children would have been without her, and she thought that they would suffer. And she'd been having these thoughts both about herself and about her children over a several-month period. And the other thing that I will say is that she was in pain. She was suffering. She was doing a little bit better than she had been before she went into McLean. But she was still in pain. She was suffering. I think she was even desperate. And that is something that is often characterized as people who try to take their own life. They're in pain, they're suffering, and they're trying to put a stop to it. And I think when she decided at some point that she was going to put a stop to it, then she had to answer the question of what to do about the kids. And she didn't want to leave them. And she was convinced that they would suffer without her.
For the next slide. And further evidence that you saw for the suicide combined with altruistic filicide?
There was. One of the things that she said when asked about what happened is that in the course of strangling each child, she said, "Go to God, baby, go to God." And that was part of her expectation that she and the children would be together in heaven with God. She was raised as a Catholic, and this, as I understand Catholic considerations, that's not necessarily what happens, but when I asked her about that, when I said, isn't suicide a mortal sin?
Yeah, can I see counsel over here?
Hi, everybody. Can you hear me? I want to make sure because Michael has tweeted, Sheila says, I think the judge is crafting an instruction that makes KR happy. Good luck. Kevin Reddington, happy is good luck. Hi, how you doing? I just rushed in, sat down, haven't even put on my lipstick. As you know, I left you before. I tell you, but I have had this in my ear the whole time. It's really funny. I feel like a UN interpreter when I was out with people that I'm talking to them, listening to what they're saying, and listening to the Lindsay
All
Clancy
right,
case.
so I'm going to ask you to
back.
go back to the jury room, and then we'll bring you back in a couple of minutes. All right?
Court, all rise. Jurors, tonight, vote.
And get a little lip gloss here so I don't look like I'm ignoring you all, being frazzled. I don't know what's happening, but we may get an issue of an instruction because of bringing up the mortal sin. The prosecution's brought that up, knowing that there was an objection to that beforehand. Let's see. I have to tell you, though, Dr. Halburn, I think humanized Lindsay. I would have called him first if I were the prosecution, before Dr. Mack. And also with regard to his testimony, he gave Lindsay a lot of stuff. Whether he finds she knew right from wrong
We'll
is...
be in a short recess, and I'll come out as soon as I can.
We're getting an instruction.
Court, all rise.
We're getting an instruction. It looks like the judge is coming out as soon as they can. They brought up the religion, the question about, did you ask her, or he may have said, I don't know. Can somebody go back? Because I can't do it while I'm on the air. Can somebody go back and rewind that and tell me whether or not the witness just volunteered it or whether or not the prosecution asked? All right. I need to know. That may make a difference in what the instruction says here. All right. Because if the prosecution asked, then we're talking about, the mortal sin issue. Yes, then we're talking, but I need the exact wording. I need the transcript leading up to when that.
And one of the things that happens is that when you're trying to remember something that actually happened, things can interfere with that. Things that you read, things that you're told, other sorts of things like that. So it would have been hard to understand how she would recover that memory accurately, including the particular memory of the command auditory hallucination, when it said.
And doctor, did you already go over the first bullet point, the inconsistencies in her description of knowing wrongfulness?
Yeah, I'm gonna pass on that one. Go to the next slide.
Okay, you don't have that's not a consideration?
Well, there were some additional inconsistencies in terms of whether she knew that, when I asked her whether she was aware that it was illegal or immoral, she said basically, I wasn't thinking about this at all. No thoughts, no decisions, none of that. It was just all action. One of the things that Dr. Resnick wrote in his report is that she was intellectually aware that it was wrong or illegal, but not morally. And what she said to me is that I just don't think I wasn't thinking about that at all. I didn't know any of that.
And if we could go to the next slide, I think if you could describe for us the evidence that you saw for suicide combined with altruistic filicide.
Yeah. Altruistic filicide is a term that's used that means killing your kids out of love. Not because you're trying to be
Joy, can we move it forward a little
or
bit?
for material gain or because you put them out of your lives or any of that, but killing them out of love so that you could. He was raised as a Catholic, and this,
Yeah, here we go.
as I understand Catholic considerations, that's not necessarily what happens. But when I asked her about that, when I said, "Isn't suicide a mortal sin?"
Here we go. That's it. All right, let's go back just before that. Let's do that again. Just at that moment where about the Catholic.
Resnick wrote in his report is that she was intellectually aware that it was wrong or illegal, but not morally. And what she said to me is that I just don't think I wasn't thinking about that at all. I didn't know any of that.
Okay. And if we could go to the next slide, I think if you could describe for us the evidence that you saw for suicide combined with altruistic filicide.
Yeah. Altruistic filicide is a term that's used that means killing your kids out of love. Not because you're trying to be cruel or for material gain or because you want them out of your lives or any of that, but killing them out of love so that you could basically, they wouldn't have to suffer, so you could prevent their suffering. And what she did, I thought, was begin with what I said a minute ago was a highly lethal and very serious suicide attempt.
And that was preceded
It was preceded by months of thoughts and impulses about you should harm yourself, you should kill yourself, your brain is damaged, that sort of thing. And that, I think, is the beginning of the way to understand what happened that day. The second point is that, as I've said before, she didn't like to leave her children. Whether that was for date night or school or going back to work or anything, she did not like to leave her children. And if she had taken her own life, then her children would have been without her, and she thought that they would suffer. And she'd been having these thoughts both about herself and about her children over a several-month period. And the other thing that I will say is that she was in pain. She was suffering. She was doing a little bit better than she had been before she went into McLean. But she was still in pain. She was suffering. I think she was even desperate. And that is something that is often characterized as people who try to take their own life. They're in pain, they're suffering, and they're trying to put a stop to it. And I think when she decided at some point that she was going to put a stop to it, then she had to answer the question of what to do about the kids. And she didn't want to leave them. And she was convinced that they would suffer without her.
To the next slide. And further evidence that you saw for the suicide combined with altruistic filicide?
There was. One of the things that she said when asked about what happened is that in the course of strangling each child, she said, "Go to God, baby, go to God." And that was part of her expectation that she and the children would be together in heaven with God. She was raised as a Catholic, and this, as I understand Catholic considerations, that's not necessarily what happens. But when I asked her about that, when I said, "Isn't suicide a mortal sin?"
Yeah, can I see counsel over
let's
here?
stop it. There you go. So the question was the question. I'm going to try to get my image a little bigger while we wait for this to come here. So the question was the having to do with the altruistic suicide, altruistic filicide, and suicide together. And they have let him talk, obviously, a lot. And in that, he is humanizing Lindsay. I mean, go to God, baby, go to God. He talks about how she was in a lot of pain, how she was desperate. She didn't want to leave her kids. She thought they would suffer if she didn't leave her kids. And then he morphs into, but this has to be in his notes, he morphs into the fact that it's Catholic and she must have asked about mortal sin. So now we know the inception about why the prosecutors asked about the issue of mortal sin early on and got slapped down, right? Now, at that point, Kevin Reddington didn't want a mistrial. I doubt he wants a mistrial now unless it's with prejudice. So I think, is there going to be an instruction? He could ask for an instruction. He could ask for citations against the prosecutors from not telling their witness not to mention this, from allowing this to be elicited, because they're clearly following along the notes, right? That, unless they didn't prepare him, they're clearly following along the notes. Do we have to have a hearing? I am not sure what the judge, and I think this is what the judge wants to research, because if the judge finds that this was elicited purposely or allowed to be brought in purposely, for which I think they need a prosecutorial hearing by the prosecutors, then this could be a mistrial with prejudice, and then the case is completely gone. All right. The problem you have is that the judge has to kind of tell you what he's going to do if you're a defense attorney beforehand, because the last thing you want to do is have the judge say, yeah, I'm going to grant a mistrial with prejudice. I find this can't be cured at this point. So the question is there a curative instruction? Do we sanction the prosecutors for not for eliciting this? It's clearly not the witness's fault. All right. The witness is a witness. He's telling what he did, and he's clearly the one who planted in the prosecutor's mind, aha, this is the question I'm going to ask, because they read his notes. I don't think the witness himself is doing anything wrong. He's telling you what he asked her and what he thought. But if his opinion about right from wrong, okay, and what she's doing is right from wrong, can't be separated from that question and answer that he asked Lindsay Clancy, then I think the prosecutors may have a problem, right? If his opinion is that he's going to eventually say that she knew what she was doing was right, you know, was illegal, and he's kind of hemmed about that right now, because he asked her and she said, I was not thinking more whether it was morally or intellectually. I didn't get to that point. I was just doing. And he said she was just doing. She wasn't thinking, although he kind of then gives her a jab and says, but in her notes with Dr. Resnick, or was it Dr. Zeisel? I forget which one he said. She said that she knew that intellectually it's a crime, it's improper, but morally it's not. So whatever it was, there was some kind of issue there that he was trying to suggest that there was a difference of an answer to the same question. But if his opinion now collapses the issue of she knew right from wrong because she was incorporating her Catholic religious moral beliefs into right from wrong, then they have a problem. Then the prosecution has a problem, because they've been told that that is not what's going to be allowed in this trial. They were told, they were slapped hard. What is it? What does Michael Bryant call her? Our prosecutor, Bo what? He calls her Bo what? Not Sprague, but he calls her Bo Buckingham, I guess, right? That Bo Buckingham has already been, slapped once not to do this, and they know it's not right. Not only that, so it's really two issues now. Now the issue is, how do you cure what he just said that I asked Lindsay about this, and that clearly his decisions and what he's asking her was going to stem around the issue of morality in religion as opposed to illegality in the law. All right. That's one issue. But the second issue is, if his ultimate opinion is based on all the questions and answers she gave, including morality in the Catholic Church, he can't allow that to come in. He can't allow that to come in. And so how do you get that? How do you cure that? I'm not sure the judge can cure that, but I do think the judge is going to try to cure it. And I think that maybe there was an instruction that Reddington wants. Maybe he wants only a mistrial with prejudice. He may say to the judge, I'm not going to move for a mistrial unless it's going to be granted with prejudice. And he could say, I don't think the prejudice is curable. However, the judge wishes to try with a curative instruction. And maybe that's what the judge is going back into chambers for, because the judge wants to, judges like to talk to other judges at times like these. I want to let you know. And so that may be an issue. So what I had wanted to hear is that the prosecution specifically asked the question about religious morality, or how did it come in? And it came in because they're allowing him to talk and talk and talk. Okay. As I said, I left you at what? About 10 to 11 or quarter to 11 today. And I've had this in my ear, and he's been talking and talking and talking since well before that time. And this is just one witness. If we thought we were going to be finished today, we're not going to be finished in the way you thought. All right. So that's something that didn't happen. The prosecutor didn't say, and did you ask her a specific question about Catholic morality? What they asked him was to discuss the issue of her altruistic suicide thoughts she had, her altruistic filicide and suicide, because he said that he thought this was a combination of her suicide, her wish to commit suicide, and coupled with the altruistic filicide comes to support her suicide. And apparently, and he's going to say, therefore, since she was deciding about her suicide, here, and the filicide was something she was not thinking much of. She still knew the difference between right and wrong because of her Catholic upbringing and her Catholic religion. So that's where I think this came in. That's how this got in, through this back door. Now, the defense didn't elicit it. If the defense had elicited it in cross-examination, that would have been a big problem. But they didn't elicit it. They're just sitting there. And now, but Kevin Reddington objected as soon as that came in. Mortals, mortal. I don't even think the word sin get out and all. You guys can tell me, because I'm sure somebody already has transcribed this. All right, but holy McGillicuddies, as we could say here, and all. Let me just take a brief, while you all think about that, let me take a brief breath and answer questions. True Crime Junkie 95, do you think there have closings written already? Yeah, you start your closings actually before you try a case, and then you add to them as you go along. But you're always trying to make your closings better and up to date and by the last witness. But sure, I think that for the most part, they both know where their closings were going before they started the case, because that's how you start writing or preparing your defenses, by writing your closings. It should be how you start if you're a prosecutor preparing your prosecution case too, believe it or not. All right. Cindy, let's see, am I doing this? We play trivia. We have some very smart chatters. Yes, we do. We have very smart chatters at Justice Serve. I think I accidentally deleted the jewels. I'm sorry for that. I apologize, Cindy. Let's see. I think Michael answered this. Did he not? Michael thought that perhaps maybe the jury got it. I heard Michael say that he thought the cross by Reddington went on a little too long because he already got you. Yeah, maybe a little too long, but I loved every moment of it. And I think that Reddington knows a beat on his jury. And I don't know, to me, Michael and I are going to disagree. I think that was the ice, or I don't care. I think that was the icing on the cake. All right. I plan to do a sweatshirt with I don't know. I don't care. I don't care, with Reddington, Kevin Reddington. Can the Commonwealth be doing this on purpose to force a mistrial? I don't think they did this on purpose. I just thought that they thought that, I quite frankly, I think they thought that as long as the expert was saying it in terms of the questioning of his, that he was going to form the basis of his opinion on, I think these two thought that it was appropriate to get in, that he could get it in that way, and they didn't have to ask it. All right. I really think that. I think that that's exactly how they're thinking. So sometimes when you try your cases in this little community, right, and you think if you're Bo Buckingham and you've had 25 homicide trials, and according to Karen Goldberg, she had 25 homicide trials. This was Sprague, although I think Sprague is the boss. Isn't Sprague the boss? And I think that sometimes you forget that maybe you'll come across some really good attorneys in some really high profile cases who really know what they're doing. And that's what happens. I mean, when we brought our team into Boston with Aaron Hernandez and got the double homicide not guilty, the judge told us he'd never seen a team like us. They're not prepared for this kind of preparation. And while Reddington may seem like he's out there singly, and he is out there individually, and he's done this for 50 years, he also has a lot of experience. And, you can see that he had the social media backing him up on some of the things he used this morning when he came back for cross-examination. I thought that was actually pretty funny and pretty great at the same time. One, Dr. Sue, question. They're in chambers. Actually, the judge went into chambers over testifying on another witness's testimony. Mark my words, plus the religion. Is this enabled in Massachusetts law? The question is going to be, what's the remedy for bringing that up? As I said, that's simply what it is. The question is, what's the remedy for bringing it up? Hold on a second. I just have to answer somebody in my own work that I have to do. Right back to you. You jumped on air. Okay. Okay. So then I have to answer this question. I apologize, everybody. Just hold on with me. I'll be right there again. Okay. Apologize. As I said, this is a work day for us. No matter what. And I apologize for having to take a few seconds off. Thank you very much. Can they strike his testimony? That's a really interesting remedy, isn't it? To strike his whole testimony. All right. As a consideration. Yeah, I guess the judge can do whatever he wants as he feels it's appropriate to remedy the situation. He can strike the whole testimony at all. Although some of the testimony was good for Lindsay Clancy. But if you remember that this is the prosecution's burden to disprove that Lindsay Clancy basically knew right from wrong at the time that she killed each and every one of her 3 children. I think, quite frankly, if I'm the defense attorney, I would rather have the testimony stricken as a remedy. And the reason is this: the jury has already heard a lot of the humanization of Lindsay Clancy. So if this is the best witness for the prosecution, and I don't say best in the sense that it proved the burden, but best in the sense of his demeanor, his affect, his non-combativeness, and all, that, yeah, maybe I'd like to have all of the best of all worlds. I'd like to have, okay, hold on a second. Let me answer that. I like the best of both worlds. The jury heard all that, and then we strike his testimony. New tweet from Michael, Bryant, and the buzz of speculation, mistrial motion, too soon back, motion denied, but preserved for appeal. Did this great witness for Commonwealth make a mortal error? Did this great witness for Commonwealth make a mortal error? Okay. It may be that the Commonwealth made a moral error, and this is why you have to prepare your witnesses. Okay. If you are an attorney, I don't care what side you're on, you have to know what your witnesses are going to say. Was this laziness? I think it may have been. It may have been just laziness, that they were just going to let him go on and on with his notes, along with the fact that they thought that because if he's just asking the questions as his review, it can come in. All right. It can come in. So let's see what happens next.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, excluding the jury.
All right. After the following sidebar conference, I think the defendant made a motion. I'm going to allow argument in regards to the motion. I'll hear first from the defendant, and then I will hear from the Commonwealth. Mr. Reddington.
Thank you, Judge. Your Honor, this has been obviously a long trial and a lot of work on the part of everybody involved, from the court to the staff to the prosecutors to myself, and needless to say, the strain on Lindsay Clancy. I have to move for a mistrial reluctantly. The reason is that this is intentional misconduct on the part of the prosecution. You know that this whole idea of injecting Roman Catholic faith, the concept of mortal sin, into this trial occurred, I don't even remember now, about a week ago. And I objected, but before I could get the objection out, Your Honor had us at the sidebar at the same time, and very forcefully, in my opinion, indicated to the jurors that they should not consider that to any degree. At the time, I put on record the fact that I did not feel that I felt that the court's instructions were sufficient. They were forceful. They were right on point. And we moved forward without a motion for a mistrial. I made a tactical decision. But unfortunately, at this point, it's a concern I have, because this is just over the top. It's the same thing again, talking about religion, talking about heaven, talking about killing people and the impact of the effect that it would have on Lindsay as well as her children. The fact that this is not the first time that it occurred during the trial, and the prosecution has previously brought up the concept of mortal sin, based on your ruling in the past, in conjunction with the fact that they brought it up again, I believe it was intentional misconduct, and I feel that the court should grant a motion for mistrial.
All right, thank you. Kamala?
Thank you, Your Honor. The question I asked the witness did not ask for any testimony about religion, about Catholicism, about mortal sins, or anything like that. And the slide is still up on the screen. There's nothing on the slide about Catholicism, about mortal sins, about any of that. The witness was explaining his reasoning. I don't think it was intentional on part of the witness either. If we look at his interview of Ms. Clancy, one of the things that this witness has to do is determine whether the defendant knew the wrongfulness of her conduct. And that can be either that it was criminally wrong or morally wrong. And he explored that with her in the interview, and asked her about whether she knew it was legally wrong, and she said she had no concept of legal consequences. And then he went on to ask her about moral wrongfulness and about her religion and whether she knew it was morally wrong. And she did say that she had knowledge that suicide was considered sinful. So I believe that's where the witness was going in trying to explain his reasoning. I don't think he was intentionally trying to inflame the jury or cause an issue in this case. I know I certainly wasn't, because I didn't ask a question about her religion or a question that would invoke that kind of response. I asked him to explain what was on the slides, and that's not on the slides. So there was no intentional conduct by the Commonwealth. That was not where I intended to go with this questioning. And I don't think that the witness intended to do any harm either. He was just explaining his rationale. So I would ask that the jury be instructed to disregard the answer, and I can speak to the witness and tell him not to talk about that reasoning for behind his thoughts, that he can testify about his conclusions, but to leave that portion of his reasoning out of his testimony.
Well, here's a concern I have, is what the witness did say in regards to go to God, baby, go to God. That was statements that had been made in evidence already. And then he indicated that was part of her expectation, that she and the children would be together in heaven with God. All right. Now we're getting a little closer to problematic area. Then he testified she was raised as a Catholic. And as I understand Catholic considerations, that's not necessarily what happens. How is any of that proper at this point? But it was not, I'm not going to declare a mistrial at this time. What I am going to do is I'm going to bring the jury in. I'm going to tell them to disregard it. I'm going to tell them that's an inappropriate area of inquiry, and that this witness's understanding of Catholic dogma or Catholic teaching is irrelevant. There's no evidence of his background or any of that. And so I think, and that's where he injected that. And so I am giving that, but the Commonwealth, I'm going to strongly, and perhaps the strongest language, talk to him and let him know that he can't go into that. And then my thought is, I'm going to bring the jury back in. I'm going to give them that instruction, and I'm going to send them home. I don't want them leaving here today with the last thing they heard was a discussion about this witness's understanding of the Catholic teaching. That's not the last thing they're going to hear. And so my thought is that as best I can is to address that and minimize the damage or prejudice, because I do presume that this jury will be able to follow those instructions. And so that would be my thought. We'll come back. That will give the Commonwealth plenty of time to talk to this witness, to let him know the areas that he should and should not go into. And then we can come back tomorrow and we can resume his direct examination and cross-examination. All right, so that'd be my thought. We'll bring the jury in. I'll give them that instruction, and then we will recess until tomorrow. Okay?
Your Honor, just for the record, could I note an objection?
Sure, absolutely. All right, so we ready for the jury?
So we have discussed this. First, a mistrial we said was probably not going to be granted unless with prejudice, although Kevin Reddington had to raise that for the record, and that preserves it for appeal. and also an instruction, which the court is going to give. I think the court should consider sanctions but first have a hearing from the Commonwealth about whether or not they knew or had discussed this with him in his trial prep, because that question from Buckingham previously didn't come out of nowhere.
All right.
We'll talk about that later. Again, what I suggest is they still have to, the judge should
This
really.
court's now in session. Please be
We'll
seated.
talk about that in a bit.
For the purpose of the record, we return back to the trial. Commonwealth versus Lindsay Clancy. All parties are present, including the defendant and including the 18 jurors.
All right. Well, members of the jury, just before we broke, there was some testimony from that last witness. And I just want to give you some instructions in regards to that testimony. And I just wanted to let the religion that the defendant was raised with is absolutely an inappropriate area of testimony. It is to be stricken. It is not to be considered. I can't be any more clear of that. It cannot be considered. Secondly, the witness's understanding of Catholic teachings and considerations, again, is immaterial. It's irrelevant. It is to be disregarded based on that testimony. All right? And so because we had a little bit of a delay due to this, what I'm going to do is I'm going to excuse you until tomorrow. All right? And so the thought is we'll come in, we'll finish up with this witness. I believe the Commonwealth has another witness at that point, and then we'll talk about where we go. I apologize for any kind of confusion or delay, but I just wanted to make sure you had those instructions with you when you left here today. All right? So I'm sorry, but so I'll see you tomorrow. Thank you.
Court, all right. Jurors, can I close your notebooks? Place on chairs. This way, please.
Jurors have exited the courtroom. This court's in session. Please be seated.
Hi. Counsel, one more time. Can I see it sidebar?
Okay, so this sidebar is really for what's going to happen tomorrow when they anticipate the closings, et cetera, et cetera, et cetera, because they still have to do, we haven't heard anything about the jury charges, whether the jury gets charged. We have to, the jury instructions have to be done before the closings are done so the counsel can refer to them as much as they can in Massachusetts. Massachusetts really puts a damper on defense attorneys reading the instructions and all. So that's something that we'll have to talk about after and all. But I think that now, really, if Kevin Reddington has his druthers, and I think he will, I would ask for, because what you heard there was Sprague trying to make excuses, right? But the question last week about mortal sin did not come out of anywhere, but in my opinion, out of this witness's notes or discussion with him about prepping him, all right? Because you either have one of two options here. Either the Commonwealth didn't prep this witness and know what he was going to say, all right? Which shows how terrible they are, because they have basically misrepresented to the jury everything their witnesses were going to say. Or the Commonwealth did prep this witness and know what he was going to say and figured they could get it into the back door by letting the witness say it. Now, the witness is going to at some point find out that he's being either the scapegoat or the reason why he was kind of like the jury was stopped, right, with the motion, right there. And remember, all day today, this judge has either reprimanded 3 times today with the prior witness, Mac, or has stopped in the middle of a testimony with this witness over the objection when he got to the Catholic faith. So I really think that Kevin Reddington should file a motion to have the Commonwealth file either affidavits under oath or question them under oath as to when they knew, if they knew that this was in his notes, if they discussed this with him in preparation, if he discussed at any time with the Commonwealth that he had relied his opinions on her questions regarding the Catholic faith. They had to know, because remember, everything was videotaped. Everything was videotaped. So they had to know. So the question is, did they know that this witness was then going to use it in his testimony before the jury today? Was he going to use it in his testimony before the jury today? That's the question. Did they know that? Did they know he was going to run off into it? Did they witness prep him? What did they say?
So we will
As a
be
judge.
in recess till tomorrow. The anticipation is that the evidence will be done at some point tomorrow, with the thought that most likely we'll have a charge conference sometime probably tomorrow afternoon, and arguments in charge would be on Wednesday. All right. Subject to change, as they always are. So thank you, everybody, and we'll see you tomorrow morning. Thank you.
Thank you.
Court, all rise.
Okay, you just heard the schedule. We'll continue to watch in case anything is hot mic'd. But a new tweet from Michael Bryant that the DA is standing at the door into the courtroom. He was not there on the witness's mortal testimony. Was it a mortal wound to the case? But now he looks like Michael put WTF. Okay, I'll just say what the hell. But he looks like WTF, and he's got to, because not only is his office embarrassed, but he's embarrassed. These two prosecutors have embarrassed him, and again. I think there's simply Reddington, maybe he's being nice. I think he knows he's got the DAs on the run. And what are they going to say? I mean, maybe he's going to wait for cross-examination, but he can't. He can't go there. Kevin Reddington can't go there about anything, because that would be an attorney-client privilege. All right, so the seal is back up. I'm going to Joy's going to keep that up in case something else happens. But I'm going to make myself full screen right now until Michael Bryant gets out. Darcy points out that DA Tim Cruz is up for re-election too. Very interesting. Very interesting. Did you waste all your money? You're going to say now, maybe now you're going to agree that she should be allowed to be found not guilty by reason of insanity, remove the prosecution. I don't know what you're going to say, but I do want to know the answer to that. Again, prosecutors who, one of you has had 25 years homicide trials. The other of you, I think Sprague may be the boss. I'm not sure. Did you prep this witness? Did you know what this witness was going to say? If you didn't, you're incompetent. And if you did, you intentionally caused that to be heard in front of the jury. They're going to have to lean back on incompetence, aren't they? And then the question becomes, what would the witness say? Would the witness say, I was prepped and I discussed all this with them? Or is the witness going to say that he wasn't prepped? I mean, quite frankly, Kevin Reddington can't ask the question about were you prepped, because that's, again, it goes into attorney-client privilege, although I think it teeters on maybe not. But quite frankly, this is not only embarrassment, it is outrageous. It is outrageous. But let me tell you again, this has preserved the record. Should she be found guilty, Lindsay Clancy, this case is coming back. It is coming back after that. But I'd like to have Kevin Reddington ask the court and let the court deny either a under oath or actual certifications, affidavits, whatever you want from an attorney there, as to what they knew and when they knew it, and what they didn't know when they knew it. If they didn't know, they should never be trying another case. And if they did know, they should never be trying another case. All right. And that's just simply what you've done here, because you've already misrepresented. Remember, we've misrepresented a lot of things. This witness actually humanized Lindsay Clancy. It agreed that she had suicidal thoughts, agreed that she tried to commit suicide. Remember what the prosecution said in their opening? It was basically a feigned attempt at suicide, right? They tried to sell you superficial wounds all the way through, knowing that their own witnesses were going to say that she was suicidal, that she had a mental disease or defect, that she had serious thoughts, that she had thought about harming the children. They knew their witnesses had felt that. Even Dr. Mack had put that in his opinions and or his facts that he stated. Okay. So when the prosecution, I mean, here's a bigger issue. The prosecution basically, didn't they lie to this jury? Did they prevaricate to this jury, but not telling the whole truth or lying to them on what they did know? I mean, so then you get into that whole question. I think it's outrageous. I think it's terrible. I think it's ridiculous. And quite frankly, I think Kevin Reddington showed a lot of restraint right now, but he knows he's winning. He knows that he has the prosecutors on the run, doesn't he? And he may know that he has this witness on the run who knows that the court had to be stopped. Now, they have to go back. Remember, what did the judge use the word? I strongly suggest, and in no uncertain words, I strongly suggest that you go to your witness. And the witness is going to say, well, you never told me to not to say that. What do you mean? What do you mean I can't use that? All right. And at some point, when this case is over and he gets to see the testimony and hear what happened and hear that he's the scapegoat, he may not be so happy with the prosecutors. If indeed they had prepped him, and if indeed he had gone on over his opinion, if indeed he had gone over notes and all, the prosecutor said, well, you see, it's not on his slide. Question, why isn't it on his slide? Did he take it off his slide? Was he asked to remove it by the prosecutors previously? Why is the slide blank? All right. That's another thing. So I agree that with all of you that are out there, but this is my feeling. Now, maybe all of you think that I'm being a little too harsh on the prosecutors. As I've told you, I have very good friends who are prosecutors. I've been a prosecutor. I understand the duty you have, and the duty is to do justice. And the duty is not to try to hoodwink a jury. All right. You all think that defense attorneys do that. We don't. We try to do justice for our clients. That's why we take a case. All right. So this whole issue of the Catholic religion and confusing what is legally, what she understood was legally violative, and what she understood was moral, are two separate issues. Is it a violation of the law? I mean, it may be morally wrong for me to do something and not illegal, for me to do something else. Are we going to go back? If the 10 Commandments is the law, then it's the law. Okay. Why is it that people who lie, to not, it's a sin to lie also, right? Why is it that the prosecutors are lying aren't getting any punishment? You could ask yourself that if we're going to go on to the 10 Commandments as being the law you have to show, as being the law you have to prove, as being the law. Oh, I'm hearing.
Yes, please.
The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Well, good morning, everyone. Good morning, counsel.
Good morning. This is not.
All right.
Are we replaying that? No, we don't want to read.
All right. So we'll do can I see counsel just very briefly, just in regards to.
We don't need to replay this. Joy, you don't need to replay that. That's the morning. I thought maybe the court was back in session again. Something brought something to their attention. That's the morning. We don't need to replay that right now. Michael Bryant's going to want to replay that and have that queued up later on when we go into our 6 o'clock show. But, and I'm waiting for him to get on the air. I'm sure he will get on the air. Let me see. Hold on a second. I have to check. Okay. Hold on. Okay. Let me answer you as soon as I get off the air in a few minutes. Sorry about that, everybody. As you know, that we're trying to do work here with what's going on. But yeah, I mean, so what are your thoughts here? I know I have 2 starred questions. Can they strike his testimony? We did that with Nosy Ren. The judge is not going to do that. Let's see. Question, Linda. Let me just see this from Brass 6073. Question, Linda. Doesn't this event in the case move the needle to allow Kevin to go straight at the prepping? He's prepped. And Kevin Reddington is prepped. I mean, you can see that. He knew exactly where he wanted to go on this case. That's why early on, he didn't really ask anybody any questions. He didn't do much redirect and all. It was right to the point and all. But when we got to tearing down the prosecutor's case, because this is the prosecutor's case, because now this is the most important part of the case for Lindsay Clancy. This is breaking down the prosecution's attempt to prove beyond a reasonable doubt that Lindsay Clancy essentially knew right from wrong legally. Okay. At the time, and then and I think I think Heilbrunn gave her a defense. He said before he got into that mortal sin, he said she wasn't thinking about morally or legal. She wasn't thinking about that. She was just acting. All right. That was like bullseye, whammo. There was something I posted earlier with Mac, and I said, got him on the issue of postpartum psychosis this morning. That's all you needed. That's all you needed. She was just acting. She wasn't thinking about that. She wasn't thinking about that. What is he going to say? If she wasn't thinking about that, she had to know about it? I mean, come on. Quite frankly, you don't really know what his opinions are, except you know what his opinion is going to be because he's testifying for the prosecution. You know what his ultimate opinion is going to be. His ultimate opinion was going to be that she could appreciate her acts as being right from wrong in terms of legality. That's going to be his ultimate opinion. We know that because he's testifying for the prosecution. But there was so much in there that, you could think that he was testifying for the defense at some points with what he said. You absolutely could think it. And I don't know how then it's up to the jury saying, well, that's his opinion, but we have a different opinion. Remember, the jury charged for expert witnesses. If the opinion is going to help you, if their testimony is going to help you decide an ultimate issue, you can give it the credibility or the weight you want to give it. They may say, oh, yeah, it helped me decide the ultimate issue in terms of what he said that she didn't understand. She just was acting. She wasn't thinking. And that's the only thing I need from him. I don't need anything else. So they can agree. They can take in any part of the expert opinion as they see fit. They can remove any part of the expert's testimony as they see fit, and all. And on that part, that's where we are. Sorry, Joyce says she's sorry she didn't know we were playing it. We weren't replaying that testimony. I thought that maybe the court was back in the session, but we can key that up or tee that back up. At that point, from when Michael Bryant gets on the stand, just before he gets to the mortal error or the mortal mistake, and the judge says, out of here, you're all out of here, and I'm going to go into my chambers, all right? Now, remember, the prosecution right now is telling their expert, probably in their offices, that this is what happened. And even though normally they're still on direct, even though they're not supposed to talk to their witnesses, even on direct, they're talking to him and saying, you can't say that. All right. They're talking to him saying you can't say that. So he now knows, but he may say, why can't I say that? You prep me. And that's what I wanted. Did they prep him to say that? Did they prep him to say that? Michael, Brian, I have been on a rant, not a rant.
I can't imagine.
I've been a little bit of pressured speech, shall we say, because there was so much to talk about. There was just so much to talk about. But now that you're on, and I will just tell you, I went through the whole thing beforehand about the judge's options, what he was going to do. And the one thing I still come out with, and I'm going to tell you, because I know you're not watching our stream while you're in court. Your hair looks perfect, by the way. You look just perfect. I had to rush it. I rushed in and sat down without doing my hair and putting lipstick on. I was putting lip gloss on as I'm sitting here because I was out for so long. That I think that the judge should demand, and Reddington may want to demand, what was it that the prosecution knew? Did they know he was going to say this? Because that slide was blank. That slide was blank for a reason, okay, to me. If they didn't know he was going to say it, then they look like fools, right? Because they should be prepping the witness. And if they didn't know he was going to, if they didn't know he was going to say it, which I think they may have, because that's where you got that question from Bo Buckingham last week about the moral sin. If they did know he was going to say it in the examination, then I think it's intentional misconduct. I think the judge has to go one step more, but he's not going to go one step more unless Kevin Reddington asked for it.
That was the doctor just walked by there, in case you didn't notice.
No, I didn't. I was too busy talking.
And since he's still on the stand, I can't really.
You can't
say
talk to him. No, that would get you a witness intimidation
yes,
charge.
That would. So here's a little more of that backstory in terms of what he did know, didn't know. I'm sure he's already gotten the tongue lashing, as it were, from the ADAs. But
and then says to the ADAs, "Why are you lashing me? You told me to say it."
Well, that's possible. We don't know.
I know. I'm making that up. I'm screening that.
We don't know. But here's what leads me to wonder how much they did say to him, how much they didn't. There was a slide, and these are supposedly his slides, right? It's his presentation. And the first thing he said, I think it was the third or fourth slide, and it had to do with why acute psychosis was not the driving factor here for what she did. And the top one referenced something about inconsistencies. And he skipped that. I'm going to skip the first one. I'm going to go into these hallucinations issue. Okay. And then as he went through everything else on that slide, he was asked to go back up to the top by the Commonwealth. And he said, I'm just going to skip that one. I'm not going to talk about that. Why would you not be talking about one if you put the slides together? Maybe the Commonwealth put the slides together and then was walking him through it. That is the only thing that leads me to wonder whether the mortal sin issue was planted or totally innocent. Now, remember, and this I think is a bigger issue that maybe somebody's going to talk about, the only interview with Lindsay Clancy that was not recorded was day number 2.
Oh, I
Day
thought it
number
was
2.
recorded. I
No.
apologize. I apologize, chat. I said we could go back and look at it to see whether the prosecution knew. I apologize. I thought that I mixed it up.
No.
I thought maybe day number 3 wasn't recorded for some
Well,
reason.
days
Sorry.
1 and 3 were recorded. That's when
that was
Mac was there with
Mac,
Heilbrunn.
okay.
No, they were both there for 1 and 3, Heilbrunn
Okay.
and Mac. Heilbrunn was the only one there for 2 because he, as a forensic psychologist, had different tests he was going to give that Mac, the
Sorry,
forensic
guys.
psychiatrist, didn't need to be part of. Now, that was not recorded. That doesn't mean that in the 6-7 hours of recording that the jury now has, because it's been entered into evidence and not played in court, thank goodness. That's not to say that issue didn't come up. The issue had to do with her take on her actions and knowing whether or not they were wrongful. And during that conversation, again, was it on the second day, not recorded, first or third days recorded with Dr. Heilbrunn in the room? Did she get into the religious issues related to whether or not she knew what was right or wrong? Because that's
So then
clearly
how was
part
the
of the
tape
defense.
entered? How was the tape entered into evidence? Not over
By
objection,
agreement.
by
I think it was
agreement.
by agreement.
If indeed the issue of the mortal sin is on that tape, that would be a mortal error for the defense.
You would think, if they know. Who knows? Who knows? Do you think that I would like to think that Kevin Reddington saw a transcript of or watched that video, but we don't know. We just don't know. But he obviously agreed to let it come in because there is an argument that once that door was opened in terms of what was happening in those interviews, and obviously the defense made it sound like, look at these doctors ganging up on Lindsay Clancy. Commonwealth said, let's look at the video, and you can decide whether they're ganging up on her or not. That's a 7-8 hour process, maybe 6. We know it was 4.5 hours day 1 on April 10. Might have been another couple, maybe more on day 3, which was the 12th. In between was the 11th, not recorded. Dr. Heilbrunn only. We don't know. We don't know what's going on in there, but that stuff's in, and they can look at that to the degree that they want to, if at all.
Wow.
So
give me the feeling in the courtroom. We have to start backward because this was such an amazing turn of events that happened this afternoon. I don't think we ever saw this happening. Give me the feeling in the courtroom. Was there ahs? Was there gasp? What was happening in the courtroom? And then work backwards to this witness is just, I mean, I left you at about 11:15, okay? And then, I've had this in my ear all day. I told the chat that I felt like a UN translator because I was talking to people and being with people in one area and still had this and listening in my ear in another area. And I felt like a UN because I had both going on, both sides of my brain.
Maybe you
going
could
on.
be a court reporter now that just, speak into the magic cone as you're repeating things you hear. Yeah.
But he's been talking all day, and quite frankly, I thought he humanized Lindsay a bit. I thought there was a lot in there.
He's great.
That actually,
He is, because Mac was so bad, this guy looks so good.
Okay.
But this is what an expert should look like and sound like. Reasonable, methodical, has his own basis of an opinion and the reasons for that opinion. All of that was great until perhaps he committed a mortal error by bringing up that phrase that is already a hot button. And we wondered why there wasn't and Kevin Reddington said it during his argument. He said, I chose strategically not to bring a motion for mistrial after time number 1, but this is the second time. It's prosecutorial misconduct. And then, of course, Ms. Sprague got up and said, I don't know why he said that. It wasn't on the slide. It wasn't something we had talked about. Certainly to that again. And, yes.
Yeah, you
Yes.
lost you for a second. I lost you for a second.
Did I disappear?
No, you just kind of like you but that
I glitched.
You glitched.
Okay, let me check my
glitched.
It looks like I got a deep hold on, let me do something real quick. Hold on, let me do something real quick. I may disappear for a moment, but it'll be worth it. Stand
All right.
by.
What Michael Bryant was clearly talking about my nails, everybody in the chat. Okay. Just so you know. Yes, that is Superman. That's a
Okay.
Superman
I think I'm back.
on there.
Am I
So
back?
just so you know. Yes, you're back. You're back. Good.
Okay. I
I
reconnected. I
showed
think
them. I
my
showed them my nails, which I know got you for a second there.
oh
Yeah.
my connection, because I wandered away from the courthouse, had to reconnect, so now I'm back in my normal spot. Nobody
Okay.
wants to sit here on the cement bench with me. But this is you got over here. You got the media
Yeah.
queued up, trying to pounce on somebody
Yeah.
when they
Yeah.
come out, because
But
most of
but
them come out this way, the family and everybody.
he really humanized her. Even the "Go with God, baby, go with God" to me was I wrote that down and I even put it in the chat. And he said that she wasn't thinking, she was acting. That's enough to me to say that goodbye, Commonwealth. Your burden is not met. I don't care what your ultimate opinion is, doctor. You
Yeah.
have all these things that you take. And he talked about how he even talked about postpartum. Did I miss that?
I know that there were moments when you're thinking, is this the defense witness? Wait a second.
Right.
But then, like a good expert, he sets these things up to then knock them down to match his opinion. And, his opinion's only as good as his opinion. The jury may decide to believe him and not believe Resnick. That's possible. Or not believe Dr. Zeisel. It's possible.
Or
At
pick
least
and choose portions of what, as I explained to our chat, the jury can decide to pick and choose and reject or accept parts of what their testimony is.
And
right?
it's so important for an expert to seem reasonable. Like, yeah, that could happen, and maybe that could happen. But in my opinion, here's why it should be this instead of that. That makes a great expert. And up to the mortal issue, this guy was, I think, winning over the jury. I think they loved him.
Interesting, but loved him in which way? Loved him in because
Well, I'm not
I
sure they
thought-
love what he was saying, but certainly his approach, his presentation, doesn't mean they're agreeing with him. Just means that they were at least embracing what he had to say and were open to listening to it, to taking notes about it. And
Yeah,
that's all we know,
So you've been in the courtroom. I thought that this witness should go first as a psychologist to the
Well-
psychiatrist. I thought he should have gone first for the testing anyhow.
Dr.
before
Mack was unnecessary. Dr. Mack shouldn't have been within 100 yards of this courthouse. He's deadly. Now, it could be by accident or design that they put Mack on first, hoping the jury would totally forget about him by the time they got to the last two witnesses. I don't know. I don't think that that's smart. And think of it this way. Remember, the defense had a forensic psychologist, Dr. Zeisel, and a forensic psychiatrist, Dr. Condon, Dr. Resnick, right?
Right.
So they're trying to meeting them one for one, right? And then Dr. Condon is more parapsych. What do they call it? The pharmaceutical psychologist guy. He had a very special subcategory.
Psychopharmacology.
Yeah, psychopharmacologist.
It's board certified. That's a very important discipline.
And that's a niche within a niche. And so, do they really even need Mac? They've got a psychiatrist. They've got a psychologist. What do they need Mac for? At all? I mean, how could somebody who was evaluating him think that's a good idea? That's a good idea. Let's bring this dude on.
Yeah, who's three cases, by the way. We had discussed the cases this morning before he got on the stand because they were spurred up, found up, dislodged by the internet, right? And so I sent them to you. You and I sent them back and forth. We discussed them over the weekend. So Kevin Reddington, he was able to use what other people had drudged up, two of them from my jurisdiction and one from Florida, that Dr. Mack conveniently couldn't remember that the judge said he wasn't, he may be a great psychiatrist, but he wasn't an expert in this very niche area that he was supposed to testify involved in all three cases. And the reason why he did that, I explained to our chat, was because if he says he doesn't remember, then you've got to refresh recollection. You got through it, go through it. And Reddington was just making the Reddington just testified. Hey, you're rejected by three other courts, and one of them's a federal court.
That's right. Whether you remember it or not, you can only say I don't remember so many times. People in the chat at lunchtime were comparing it to taking the fifth. It's like I don't remember. I don't remember. Yeah, well, all of these cases he ticked off, and we talked about some of them. There's actually one I hadn't even seen before, but they're all basically discrediting this guy, if it was even necessary at that point, because you start to go through the guy's CV and you wonder how in the hell he even got on the list. Well, 10 women he believes 10 women with some sort of postpartum something over a 10-year period. I mean, come on. I'm available, Commonwealth. I could testify. It's about as credible on the subject. So
Yeah, we've learned enough that we probably testify better. Although, we would tell everyone to go back to our interview with Dr. Gregoire, Alain Gregoire from Britain, who a lot of people who have been in our chat have worked with him and on his team, by the way, and said he is the world-renowned expert in postnatal maternal health. Okay. Or as we now have a T-shirt, because my husband was watching some of this morning, and he's really into supporting these issues and all, because his daughter is an OBGYN, and so he's really into these issues, and actually asked me to make a shirt, that this is not a disease we're dealing with. This is this is women's health. That we're dealing with, and you don't give any money towards, you don't pay attention towards it, or whatever. So the other one that I know you didn't like, Reddington today, when he said, I don't care. I kind of liked it. That'd be me.
Yeah,
That'd be
it
me.
was just, to me, it was a little over the top. He had already pummeled this guy into submission. It was it was just kind of it was too much. But some jurors may love it, some may hate it, some may not care. Who knows?
Yeah. This is a postpartum is not a disease. It's women's health. It continues on. It's women's health. So hopefully the Baden household will be wearing that a lot. But we're trying to. We keep saying we're trying to bring knowledge to this. I actually think. Didn't we get one point there that this Dr. Heilbrunn kind of. And by the way, I loved it when Mac didn't know how to pronounce his name. I just called him by his first name. Oh, come on.
Yeah.
Okay.
Yeah. And I don't want to pronounce his name for him. You'll have to ask. Okay.
Oh my God. But I actually thought that he kind of gave some credibility, though, to women's postnatal maternal health.
No doubt about it. And he has the credentials to do it. The problem I pointed out earlier with Dr. Mack was, and it explains virtually all of his testimony. Here's a guy that is so inexperienced in that category that he relies on the DSM. That's it. So every time he would get in a hole about what is this a psychotic behavior? Well, the DSM, and because they don't identify even postpartum depression, let alone postpartum psychosis, he has nowhere to go. That's his Bible. That's everything to him. So there's no way he can answer anything. And the judge finally saved his ass by saying, just tell him you can't answer that question if you can't answer the way it's phrased. And so that's how it ended, with him continuing to say, I just can't answer that question.
Yeah, and it looked like a fool. Let me just give you a couple of these. Stay hydrated, Michael, 550 joules from Cat Staff. And Needham, 30 joules of flour. Let me just give you a few of these. Everyone's worried about your Lorelei Annie, a gold coin, 10 joules, Lorelei Annie, flour, more joules and all. And then this, Cindy X8755, member for 2 months. Such awesome discussions on this podcast, the streaming network. Thank you very much for recognizing that. We are trying to, oh, by the way, you've got a loot box for 1,000 joules. Thank you very much for all of your support here, and for Michael, who travels up and sits in the courtroom and is your eyes, your ears, and your impressionism. He's like an impressionistic painting. So what other high point, when you're in there, and the jury, any oohs, ahs, oh my gosh, from the jury. Forget the gallery. We've seen the gallery, but let's talk about that jury.
Yeah, I wouldn't say, oh my gosh moments, but I do think they were over Dr. Mack long before he left the witness stand via video. They were probably just as glad he wasn't there as I'm sure he was, to be beaten up in person. And the video works fine. That was not a problem. But, and I mentioned it at lunchtime, I saw at least a new guy I've identified. He sits next to Tony, third in on the left from the, right next to Tony. He was like this a lot. Like,
okay.
I mean, almost like, doctor, are we done? Are we over this? I just felt like there very little note taking, if any, during the final part of the cross-examination or the redirect, which, good luck rehabbing that guy. Oh my gosh.
Yeah.
And basically it was calling Dr. Heilbrunn. Dr. Heilbrunn, we need you to rehab Dr. Mack. And he was doing a hell of a job, I have to say. If Mack had never touched that witness stand, I think the Commonwealth made some points with Heilbrunn up to the mortal issue. So
what points? Okay, what were the points that you think?
I think he was, because he would acknowledge that psychosis is a thing. Hold on just a second.
Okay.
Hi, Grace. Oh, I just didn't. You were sitting there. I didn't know if you were waiting for them to come out. Has anybody come out yet? Okay. No. Okay. Who? Oh, yeah. No. I mean, I do. He's a good guy. Yeah. Anyway, so what was I talking about? Oh, the fact that they were done with Mac long before he was done with them.
Right.
And then once Heilbronn took the stand in person, they were much more attentive. They were like, "Oh, I'm back in the game," and note taking resumed. And I think the points he made were to acknowledge, as any good expert does, that yes, you can have these ideations, you can have these command voices. He will then, he acknowledged all that. That's legit, which of course Mac would never do. And then he knocked them down one at a time. And here's why I don't think that's the case here. Critical, I think, and who knows what jurors are going to glom onto. Why was there never any specific references to having heard a voice, the persistent male voice, that command hallucination, until after it happened, till the day after it happened? And the counter argument is she couldn't say stuff like that because they might take the kids away. Right.
And then, they use that against her to say they both of them are using that against her to say,
hold on.
Yeah.
Can you see? Let me see if I can get out of the way. See that scrum on the other side?
Yes. Yeah, I see that.
Let me see who that is. Let me see who's. I think it's Kevin's making a statement. I'm sure it'll be everywhere. So I'm not getting in the scrum. I have no need to.
We'll replay it later on. We'll find it.
Whatever it is he's saying, which is going to be outrage, mortal sin,
and as
mortal
well.
sin.
Kevin, hear my suggestion. Make a motion that the prosecution has to be under oath to say what they know, when they knew it, and what they didn't know, and why they didn't know it, if about the mortal sin era.
And what conversations, if any, they had, and who. And let's back up a step. Who put that bullet point graphic together so that your expert wanted to skip one of them? That's bizarre to me.
That is bizarre. That's bizarre, because if they wanted to skip one of them, why? That means
why would he put it on there?
Why would he put it on there? And if it had been a PowerPoint, was he told to take it off? They'll skip it because it wasn't supposed to be there. All right. So, I'm sure Reddington knows what it is. I mean, these things are not given.
Can you see those folks there? I don't know if you could see. That's Patrick Reddington just walked by. He's probably thinking, how do I throw a life preserver to my dad, get him out of that mess? I mean, this is a great day for Reddington to just be an advocate, No,
it's a great. You just sometimes, in poker we have a saying, let the good cards come to you, right? All right. Don't push away. Let the good cards come to you, and they certainly did by end all here. By the way, this is a question that N Needham 8975, mortal sin on video, jury will see. Michael already answered that. He's not sure. We're not sure on video 1 and 3 because video 2, the Heilbronn, wasn't taped, so we're not sure if the mortal sin discussion occurred when Heilbronn was in day 2, when it wasn't taped, or day 3. The videos have been marked to go to the jury, so we assume that it's not on day 1 or day 3, because or else Kevin Reddington would have objected to. If it turns out they are, he's going to now object to before the jury actually sees them and make a reconsideration motion, I'm sure. And then a very lovely donation, Run the World 26-49.9. Thanks for being there, Michael. Maybe this can cover a meal. Cheers. Yeah, we need to have Michael. We need to have Michael hydrated and fed. Cindy X 8755. Thank you. Coffee and donut for both Linda and Michael. Thank you very much, because I was living on coffee and Dunkin' Donuts.
I shared with folks that I'm not a big fan of the energy drinks, but in the afternoon I've been known to. So I had my Monster with me, and this probably afternoon I wouldn't have needed it because there was stuff going on. But generally, man, I start to nod in the afternoon. I really do.
Well, it's 4 o'clock in the morning to drive today. I mean, it's not just today. Let's forget about it. A 7th X generation gifted 5 Justice Serve TV memberships. Thank you very much. Those of you in the chat who already have them, we don't have anything to do with them giving them out, although we do have to give out 10 pretty soon, Michael. It's August 24th. I know.
I've got to remember how to do that. I figure once this is done, and you heard kind of the judge
Wednesday,
talking about, that was my guess from earlier today. I said, that was before the mortal sin.
Right.
I said, they're going to get these other 2 done either by the end of today, they'll get one more done and then, have one left for tomorrow. Now they got kind of 1.5 left for tomorrow. Then they'll have the final charge conference, which, as I talked about today, we don't know what's going on with the involuntary intoxication and the impact on an involuntary manslaughter option. We don't know. That would have been the one question. Nobody's asking those questions, of course. They're a buzz about the motion for mistrial. I would have said, what's the latest on that? That would have been my question.
Yeah. Now, Michael, I want to let you know, I haven't told you yet, but I've moved my sort of daytime vacation to next week. Okay.
Well, good for you. I like
next
the
week.
dedication.
And I have withdrawn myself from the poker tournament tomorrow. I'm not going to play until next Tuesday. So if I get a final table, I won't be on next Tuesday night now, but I'm staying with you tomorrow and Wednesday. So because you need help. Not that you need help. You deserve help.
I appreciate.
You deserve to have.
Never expect. Always appreciate.
No, I know you're just Michael Bryant is. And I'm going to say it to everybody again while you're all listening. Yeah, he is simply the best streaming partner to have. He's amazing in his dedication. As I said to you this morning, he's the Energizer Bunny of going everywhere. He goes everywhere where there's a trial, and he talks to everybody, and everyone talks to him, and his insights are invaluable. Why? Because he's a really good lawyer, reporter, streamer, and person, and you need to be that to be him. So thank you.
Thank you. That's way too much, and right back at you, Patna. I was talking to Dr. Zeisel. Another part of the origin story we'll get from him is he has an identical twin. They are within, for whoever categorizes these things, within 3% of being as identical as you could be.
Oh, wow.
And he's also in the mental health profession. And I said, well, how do we know it's you and not your brother standing here? How do we know you're not Jeff, your brother? And I asked him if they had gone through the dating world, pulling those twin shenanigans. He took the 5th on that question. So.
Oh my goodness gracious. Anyhow, if you, by the way, you see that Miss Jessica with the 5 Justice Serve TV memberships, if you get them and you feel you can pay it forward to somebody else who would like one, either $2.99 a month, I think, for the basic membership, and it gets everyone into being with Michael usually on Wednesdays. We'll get back to the book club as soon as we can because he's a little busy being on this trial, which, by the way, has taken over the world.
Yeah, it's funny that.
Yeah,
I know.
Us about who's there.
I tend to come off, a little bitter about it because I wish people would not have had their heads up their rear ends earlier on and could have really made this a 3 or 4 week, ad, as it were, for the importance of female mental health in general. But no, they're late to the game. At least they're here. And again, something else I was ragging about earlier, we have the list of media. 3 people listed from the Today Show. 2 from NBC News. What the hell? They're taking seats is what I'm getting at. And because these folks are not really all that sophisticated in a massive outpouring of interest in a given trial, no overflow. They're all great. They're really super nice, very helpful, but they're just not experienced in doing this. I would say to them, if I had any suggestions, 1 person per media outlet. That's it. That's it. Right. So you don't have to leave people sitting in the hallway. Luckily not me, because I maneuvered. But there were some folks that were shut out and they had to wait for somebody to leave for them to filter in. And that's just wrong.
And that's wrong.
If you're late to the game and you're bringing multiple people. So
right. And you say, oh, on the Today Show, so I get in because everyone's going to want to do an interview with me after we finish. That's why I'm here. Yeah. We're coming late. There is an article, and I'm going to put it up here. Why people want to believe the Lindsay Clancy conspiracy theories, and its mistrust about the case stems from understandable anger and sorrow at the way women in extremists aren't heard. It's by Jessica Winter in the New Yorker, the lead, August 22nd, 2026. We'll try to discuss it maybe as a separate little ditty that we do, but it's a wonderful, wonderful article. I would suggest if you get a chance to pull it up, try to read it and all. And it even goes into the August 18th cross-examination about Patrick's mother asking about being the practicing Catholic. And that's when that happened, by the way, just for those of us. But
that was the first mortal sin.
Yeah. And then the article concludes with that, Lindsay Clancy wasn't heard for months, and then everyone can hear her now. But take a look at it, because I think that's why we've been talking about it, that she wasn't heard, right? She checked herself in for 4 days to a mental institution, and they still said, no, you're not Yeah, nothing wrong with you. Yeah, go
Hey, well,
forward, my children. You
well,
know.
I'm thinking about it from Zeta. I know I'm probably
Zeta's eye.
Yeah, but this is a donation. Thank you so much. We appreciate that. Thanks so much for all your hard work, is what it says. And then from Kathleen, who is a repeat offender. She is a recidivist in the donating. She says, for lunch, thank you for your invaluable commentary. So thanks, guys, for all of that support. We appreciate it.
Okay, so just hit subscribe if you would before we leave you for our nighttime show and before Michael gives his last thoughts of being in the courtroom, because we do have a 6 o'clock show to get ready.
Oh, that's right.
Yeah.
And I'm working on. I got a couple of options, perhaps, if they haven't scampered away on me. But we'll have somebody tonight. I don't know. I might get Karen, although I was hoping she was going to be here. Karen Goldberg, who's been on before. People appreciate her perspective because she has so many life experiences that touch on things going on in this case and others. So we'll see. I might get her. I might get somebody else. We'll see. But we'll have somebody. We'll have somebody from here on tonight.
Yeah, and we will be doing this case all week. We may even morph into this case next week, depending on what happens with our experts who've been on, as we continue to shed a light on women's postnatal maternal health. In this case, it's postpartum psychosis, something that the American Psychiatric Association does not recognize. Harumph.
Yes, and we heard a lot of that today too, and that was the how many days, how many weeks does the whole thing of postpartum really happen and count? That argument, and the other one. We'll get into this in some detail tonight because I was fascinated by this. Dr. Heilbrunn kept pounding away on this 18 minutes for the children to expire. That is about as disputed as it could possibly be.
Right.
So he just kept saying, hey, you can't have a psychotic episode that's that long. You can't. Well, I think that's going to be disputed in closings and in cross-examination.
Oh,
where'd you get that number?
Yeah,
Did the Commonwealth give you a calculator and show you how they had calculated that number?
Yeah.
Because that's 6 minutes per child, which I think with the ligature involved is ridiculous.
Yeah.
It might have been as short as 1/3 of that. So 6 minutes total. And if I'm cross-examining this doctor, I'm saying, well, let's talk hypotheticals then. What if it were 4 minutes total? What if it were 5? See where his break point is. So there's a point at which he's going to have to agree, right? That would be a period of time in which a psychotic episode could occur. And then you just bring in all the other evidence that that's exactly how long it took.
Yeah. How about the fact that when she goes out the window head first in that swan dive to fracture her neck? Oh, was she being psychotic then?
Yeah.
Or was she being rational? Was she being rational that she could, you know what he'll say? Yes, she was being rational then because she was trying to kill herself, which is what the Commonwealth told you she wasn't trying to do throughout the first half of this trial, you liars.
They really pulled a bonehead move when they started suggesting, oh, well, we're not saying that. Oh my gosh. Well, which is it? You can't be. You can be wrong on both, but you can't be right. Why would they change? Jumping ship right in the middle of the ocean. I don't understand that. Yeah. So anyway, we'll see how they fix that in closings.
Okay. So
there were people that were posting 30 minutes for each side for closing. 30 minutes, and I'm asking that around here. Nobody that could give me an official word, but virtually everybody said that's ridiculous. So I have not confirmed the time. Yeah. Nothing has been confirmed.
Yeah.
But the 30 minutes per side seems to be laughed off by those of us who kind of know what happened.
Those of us who practice there, we know that the fallback position is always an hour in Massachusetts. You get an hour each side. That you don't get longer. You do not get longer. You can be in a trial for whatever.
And generally, defense first and then Commonwealth because they have the burden and no rebuttal. But again, the judge can tweak that if he sees fit. But that's what I'm expecting: defense first, then Commonwealth, and then instructions and starting deliberating.
Yeah, and I don't know whether he'll give the instructions first. Sometimes they'll do it first.
Yeah, and again, that's
portions of
not by statute. That's whatever the court wants to do.
Right.
I always think it's better to do it beforehand because it can kind of lapse you into a bit of a coma as you've just come off the closing arguments, which tend to be more amped up, and then you go into the drone of instructions. I'd rather get that done, be amped up, and then bam, go in and start deliberating.
And then remember, they pick the alternates after that. Okay. And then the judge by statute picks the 4-person in Massachusetts by statute.
Yep.
Okay. All right, Michael
So
Bryant,
all of those
anything
things
else
to be answered.
besides subscribe? We had to make it everybody so that you have to be a subscriber to chat now because we have so many people involved here. But so if you want to chat with our group, hit subscribe, and after about 5 minutes or so, you will be allowed into the chat room to chat with all of you. And we have a very, very sophisticated chat group, as I said early on today. That when Michael and I did these shows over the weekend, one Michael did the process going over the defense opening statement. I did going over Chaplain Kavanaugh's testimony. There were comments in there that were so amazing, just so amazing under both of them, that we learn a lot from you,
Yep.
and hopefully you can learn a lot from us. So.
Like I've said, we do not have any double-digit IQs in our group. We have very smart people. One more I missed, and this is right in line with your subscription request. Another Kathleen, thank you so much. Appreciate this. I thought I was subscribed. Great work, guys. Fun having Bob jump on. So this is from last week. Love yas. So there you go. If you think you're subscribed, double check, because YouTube does things, and you may have been booted without even knowing it. So
yeah, and then you can help us get us the 40,000 number. Is it 40,000? Yeah, I can't believe it.
We're hoping for somewhere at or about our 2-year anniversary. Yeah,
which is coming up. So Michael, you should go get a rest. We have a 6
I'm
o'clock
gonna go,
show.
and then I'll relocate probably on the other side. I haven't figured out. I may be wild and pick a new location here at the courthouse. We'll see.
Wild and woolly. And then you'll check on what Kevin Reddington's, or we'll check on, maybe Joy will check on in the break what Kevin Reddington's press conference is about. Maybe we can
find that clip if I can't, and we'll just throw that out there. Yeah.
Okay. So thank you all. We will see you all 6. Hit subscribe, like, share, notify, and Michael Bryant.
All right, then let's come back in 6, and we'll all do the right thing.
Sun in the sky.